Thank you. I declare open this hearing of the Senate Education and Employment Legislation Committee into the Fair Work Legislation Amendment Secure Jobs Better Pay Bill 2022. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to the elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person and via video conference, with several senators participating throughout the day. I note that today is Remembrance Day, and at 1 minute silence will be announced by the bells at 11 a.m. During that minute, I request that all parties attending in person and remotely please cease activities until the minute is over. These are public hearings, public proceedings being audio streamed live via the Parliament's website, and a Hansard transcript is being made. Remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses have a right to request to be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to a superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. For the benefit of Hansard and those listening to proceedings, I remind all committee members and witnesses who are appearing via video conference who are not speaking to mute their microphones. I now welcome via video conference Professor Sarah Charlesworth from RMIT University. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Thank you, Senator. My name is Sarah Charlesworth, and I'm an Emerita Professor at RMIT University, and I'm appearing in my own capacity.
I'd just like to thank you for thank you, Professor Charlesworth. Unfortunately, the audio we had the other day, and the committee unanimously agreed that we would bring you on this morning to give you an opportunity to answer questions from the committee. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you very much, Senator. And I'd like to acknowledge that I'm coming to you from the Boiwurrung language group for the Eastern Kulin Nation, on whose unceded lands I'm currently working. At the hearing last Friday, I had raised a number of issues that I thought needed to be addressed in the current bill, and I note that one of those, in terms of replacing the new an additional object to the Act in gender equity, is now gender equality, and I think that that's a very important. It's a small change, but it's a very important one. I also want to talk very briefly about the equal remuneration provisions. Just two small points. I've got some points about the supported bargaining stream, particularly as it concerns workers in publicly funded sectors, and also some small amendments to the right to request flexible work arrangements. After Friday's hearing, I was asked a couple of questions on notice from Senator David Pocock in terms of the comparability of Danish gender pay gap data with Australian gender pay gap data, and I've sent a detailed response to that. I was also asked a question by Senator Barbara Pocock about comparative right to request regulation, and particularly in the Netherlands and the UK. So I've that material has been sent into the committee, and I'm assuming that you have it, but if not, then I'm happy to elaborate on those issues.
You can go ahead with, we should have it for the committee if the committee received it.
I think it would be worthwhile for the committee to hear a short verbal summary, perhaps from Sarah from Professor Charlesworth on those two issues.
It would probably be helpful for some of the committee members here. I appreciate if we go a little bit over time, then we're certainly able to do that. So as we started late.
So in response to some questions of Associate Professor Chris Wright, Senator Pocock pointed to the fact that the gender pay gap in Denmark was pretty similar to that in Australia. And my inaudible remark on that was that you have to compare apples with apples. The Danish pay gap data is basically based on an hourly wage measure, and it's for all employees in enterprises above 10 employees. So all employees are above that size. In Australia, unfortunately, we don't use hourly data. The Australian Bureau of Statistics only produces hourly data for non-managerial employees. And given that there are many more women than men, or fewer, I should say there's a smaller proportion of women who sit in managerial jobs, and within those jobs at the higher paying jobs, if we just look at non-managerial hourly earnings, it rather skews the picture. The other issue is that in Australia, we have continued to measure our gender pay gap data for full-time employees only. That is, we exclude part-time employees from that calculation. And that's a problem because almost half of the female workforce in Australia works on a part-time basis. So it was, I've provided full details in my in my response to questions on notice, but it was really pointing out it's very difficult to make those comparisons, and the fact that the Danish data is including all earnings, not just ordinary time earnings, is another factor that makes that difficult. So that's that issue. The other issue that Senator Barbara Pocock raised was the some proposals I had in terms of improving the current amendments around the right to request flexible work regulation, and that is the new bill provides an avenue, if you like, to appeal an employer's decision to refuse a request, and it allows the Fair Work Commission to assess whether or not the business grounds on which the employer did that were reasonable. Given that we're making those changes, I thought it would be a very good idea to also make a couple of other small but very consequential changes in both the UK and the Netherlands, who've had right to request flexible work regulation in place for some time. That regulation is accessible by all employees, irrespective of caring responsibilities. It was from the get-go in the Netherlands when that started in 2002. In the UK in 2014, on the base of quite a bit of research and evaluation of the use of the right to request, there was a decision made to extend that right to all employees for a number of reasons, which I've sent out in the detailed response to Senator Pocock's question. And I'm just going to it at the moment. So the reason why the UK, they changed that was that they wanted to increase the availability and take up of flexible working to enable individuals to manage their work alongside other commitments. They wanted to remove the cultural expectation. I think this is important, that flexible working only has benefits for parents and carers. And that's important because that can create a stigma for those who actually access those provisions, which at the moment are overwhelmingly women. And it was also the UK amendments were based on the policy objective of, as they say, improving the functioning of the labour market through a more diverse provision of working patterns. So that's something that it would be great if the committee could consider. The other one is the length of service an employee has to have with their employer. In Australia, it's 12 months, and that right is open to permanent part-time and full-time employees, and to casual employees who've had that 12-month service and have been employed on a regular and systematic basis and have a reasonable expectation that that employment is going to continue. In the UK and the Netherlands, it's just 6 months. And given that for lots of parents returning from parental leave, this is the point at which they are going to require some additional flexibility for a period of time, it seems to make sense to actually decrease that period of service, of required service with employer. The only other provision that I would draw the Senate Committee's attention to is that the right to request provisions at the time of the establishment of the National Employment Standards, that particular right to request was not able to be reviewed in terms of the reason for employers' refusal of that request. There is a similar right to request sitting in Section 75, which is the unpaid parental leave standard, whereas part of that standard, employees have the right, after they've had 12 months unpaid parental leave, they have the right to request an extension of that leave. And currently that right to request is also not reviewable as per Section 44 of the Act. That really singled out, they're the only two national employment standards that have no right for an employee who's unsatisfied with an employer's decision to actually take that to the Fair Work Commission.
Thank you. Thank you, Professor Charlesworth. Now to Senator White.
Can I just take up that last point? I mean, is the point that you're making about those two unreviewable matters is that that it's likely that both of those would be requested by women in the main?
Well, yes.
So there is an inbuilt, not being reviewable, inbuilt a gender bias against women.
Well, it rather takes away the point of the provisions, because if your employer says to you, and there are requirements, for example, the right to request, an employer must respond in writing within 21 days. And if they don't respond within 21 days, then that part of the employer's conduct is reviewable, but not the substantive reasons. I've spent a lot of time in a lot of organisations, and it's not uncommon to hear managers saying, we just don't do part-time here, or no, that's simply not going to work. And that's as far as it gets.
Thank you. Can I just ask you about the low-paid bargaining stream? Why has the current low-paid bargaining stream failed, and why is it important that we fix it?
Well, they've been, under the original provisions for the low-paid bargaining stream, the explanatory memorandum set out that it was specifically designed for workers in low-paid sectors, and in particular in feminised sectors, such as those that sit in the care economy. But over the years that it's been in place, and I think the first case was taken back in around about 2011 by then United Voice, which in respect of residential aged care employers. And the Fair Work Commission, I think there was a proposal, I think there was something like 300 employers going to be involved, but the Fair Work Commission decided that if people had been covered by an enterprise agreement, that they couldn't be included as part of that. And so then the number of employers was reduced considerably, and the union didn't end up pursuing the authorisation once they'd got it. There were another 3 cases involving nurses, security guard, memory, which also didn't get up because the Fair Work Commission made decisions about whether or not they were low paid or not, and it became incredibly technical and highly unsuccessful, and really didn't meet the intent that had been expressed in the explanatory memorandum for the Fair Work Act.
So, are you aware how many have actually been successful?
None.
None, okay. What are the main reasons that workers in the care economy have not been able to access the benefits of single enterprise bargaining?
Well, for a variety of reasons. Let's take home care workers, for example. So increasingly under the types of funding models we have, workers don't see their employers, let alone other fellow workers. It's very hard to organise workers, and where enterprise agreements have been struck, and this is something that the Fair Work Commission noted in its 2011 decision on that original application, wage rates sat at or cents above the actual rates that sat in the awards. So there wasn't an enormous amount of point in enterprise bargaining, and you're already working off a very low base.
So when you say they don't see fellow workers or often their employer, it's because. Sorry, can you expand on why that is, the nature of the work?
It's the nature of the work. So, as you will be aware, Senator White, that in Victoria there has been historically a different provision of home care, which has been through local government, where that institutional home, if you like, and the fact that local government has in fact subsidised to a large extent the provision of home care has been really important in making decent wages and conditions, and those workers are paid, $8, $9, $10 above what sits for most other home care workers who are employed by for-profits or not-for-profits in the home care sector. So, for example, we're moving increasingly to these individualised funding models, the home care packages program, for example, and there's been a lot of new entrants to the market, and workers will be employed, but their communication with their employer consists of them being sent a roster on their phone. They sometimes get details about the client that they're going to see, they sometimes don't, and there's very little opportunity for them to kind of come together and meet with other workers. So it's not exactly conducive to single enterprise bargaining.
Thank you.
Senator Little.
Thank you. Professor Charlesworth, my questions relate to multi-employer bargaining. In your opinion, would it be easier or more difficult to strike under multi-employer bargaining?
To get well, I think the care sector, it's envisaged that they would be covered mostly under the supported bargaining stream, and that's the section of the bill that I've paid most attention to. It should be easier, one hopes, because there's one of the issues that I suppose trip things up has been the Fair Work Commission's trying to understand what constitutes low pay. So a lot of effort goes into that. So, for example, a case by nurses was rejected because they weren't considered low paid. I think that the supported bargaining provisions make it clearer, both in the explanatory memorandum but also in the provisions, that it is anticipated that, if, for example, in the care sectors, that you would have relevant parties, and in this case it would be, in most cases, the federal government, actually at the table. I think that will be very important, because at the end of the day, it's government that sets the parameters for the possibilities of achieving wage increases. That said, one of my comments on the supported bargaining stream, while the explanatory memorandum makes it clear that relevant third parties such as governments, where it's a funded sector, would be involved. In my proposal, I think that could be tightened somewhat. At the moment, you have to wait till you actually got the authorisation before those relevant third parties are brought in. I would propose that they're brought in from the get-go, so that they're actually included in the bargaining authorisation application process, not just the bargaining process once it's in place. And the other issue I would like to raise is that, given the aim of the supported bargaining stream is to provide the opportunity for workers in low-paid industries to get a pay rise, hopefully sooner rather than later, that raises the issue of the start date of, making an application for a supported bargaining authorisation. So currently in the bill, those covered by existing EBAs, it makes clear that process can only start after the nominal expiry date of the relevant EBAs. Now, for some evidence I gave before the Fair Work Commission in the aged care work value case and looking at enterprise agreements, most of them just sit at the award wage or just above the award wage. There are not so many enterprise agreements, but where there are, they tend to be fairly low. The exceptions, once again, are a couple of standout residential aged care employers and also Victorian local government. So my proposal would be that amendments could be considered to provide that if there's evidence of no or just very meagre above award wage increases in the existing EBA, that the supported bargaining process, that is the application for the authorisation, could start before the nominal expiry date of that EBA. It would, of course, then only come into effect when that existing single enterprise EBA had concluded. Another option would be to ensure that the supported bargaining process allows the party to an existing EBA be part of the authorisation process. So once that EBA reaches its nominal expiry date, the new multi-employer agreement could take effect. That's really in the interest of getting things moving. And there are, the enterprise agreements that sit in the sector are pretty basic in terms of wage levels.
I note that you mentioned earlier that your focus has been mostly in the care sector, but you also referenced construction workers being successful in getting an increase in wages growth. Will the removal of the ABCC...
Senator, I don't think that's correct. I haven't mentioned the construction industry.
Right, okay. It was in an article that...
in the conversation on 16th of May.
On the 16th of May?
Okay. My comparisons with the construction industry are to show that have been that if we think of federal or state government infrastructure, that the relevant governments are prepared to pay what it costs to get the bridge or the road built. They have not been prepared to pay what it costs to provide decent wages and conditions to ensure that we provide good quality care, in the case of the care economy, to often very vulnerable older people or indeed children.
All right. Thank you.
Thanks. Senator Lambie.
Thank you. Good morning. I just wanted to go over a couple of things. Universities often receive 3 to 5 year grants of funding for research. Do you have any concerns about the proposed prohibition on fixed term contracts and how this would operate in the university sector?
Senator Lambie, this is a huge issue. Well, there's two issues in the university sector. One is fixed term contracts. The other is the extraordinary level of casualisation, which is a really, really serious problem. The fixed term contracts could be very useful because often people, we call it soft money, so that those ARC grants people employed on them often aren't employed on an ongoing basis, so they're employed for the term of that grant. And if the chief investigator of that grant is lucky and can find continuing money, then that person can keep being employed, but then is on a new contract. So I do think universities having to step up and provide more secure employment after 2 or 3 fixed-term contracts would be fantastic. I think that would really enhance not only the quality of employment in universities, and I'm someone who's just recently left one, but it would also really improve the quality of teaching, and it would improve the job quality and security for people who get stuck in those invidious rolling short-term contracts, often with gaps in between when they're employed on soft money.
So what about the research grants that I guess that's the big one, is the research grants? Because sometimes these research only take, 12 months or 2 years. Do you see a problem with that?
No. Most of the Australian Research Council and NHMRC Council grants go for at least 3 years, but yes, every now and again there will be grants that are for just 1 year or 2 years, but I think that it should also apply there, because if somebody is being employed and they're being employed for their skills for that period of time, and then all of a sudden, the grant money ends and they're really put on the rubbish heap at the end of that, and then have to hang around and wait to see whether or not their chief investigator or some other chief investigator in the university is able to get some other grant funding to employ them.
So what about, so you don't believe that the proposed prohibition on fixed-term contracts have the effect of preventing universities hiring researchers on fixed term? You don't think it'll go in the opposite direction because they actually can't afford to move these staff onto full-time contracts?
Therein lies the rub, Senator. I think that they can afford to move these staff onto ongoing contracts.
Okay, so...
They choose not to.
Okay, so we're very aware of the big eight. I've done a lot on them. The main eight there, they have plenty of money. So what about the difference between the universities like in Tasmania versus, say, your university, RMIT? Wouldn't this new bargaining system draw academics away from smaller rural regional areas because they can't afford to pay their staff the same as sandstone universities?
Well, the university in Tasmania is regarded as one of the sandstone universities, and it certainly pays a lot better than a university like RMIT, where I've been for over 20 years. So I don't think in terms of pay rates, you'd be better off at the University of Tasmania. I don't think it's going to have that effect. I'm not aware of the financial situation of the University of Tasmania, but as you say, Senator, the group of eights have significant financial resources.
I think what bothers me is these rural and regional universities, and a lot of them are not that well off. And it bothers us that if we're going to lose good teachers from there because we can't afford to put them on full time, then, it's going to be the group of eight that will benefit from that, certainly not in those rural and regional areas. And that is a problem for me.
I don't really think it's going to have that impact. To my knowledge, I haven't worked at a regional rural university. I've got plenty of colleagues who have. People move there because they want to live in rural and regional areas. It's the system in Australia. We tend to be not nearly as mobile as, say, in North America. In North America, people will move, states on a regular basis, for a job. In Australia, people tend to stay where they are. They will sometimes move, for example, to the University of Newcastle. But once again, universities like that do have the wherewithal to employ people on an ongoing contract. And quite frankly, Senator, it's not as though there's not work to be done. One of the huge issues post-COVID in the university sector has been and I'm not sure about the data for the University of Tasmania, but has been a really rapid downsizing. So the existing teaching staff who are left are doing an extraordinary workload, and there is money available to employ them.
Okay, what about, I just wanted to see what you thought about these, because I know you're talking about pay rises, right? So you've got government-funded childcare, aged care,
disabilities.
Disabilities. There's quite a lot of those government-run, paid for. So I guess if my question would be, obviously they've just had a pay rise in aged care of 15%.
Not yet, unfortunately,
No, but that's coming. Sorry, yep. Next year, yep. But there will be people that in that aged care that will not get that pay rise because they're already above the ward rate. I think that hit them thinking that they would get their 15%, but because they're already sitting there, they won't get anything. That's my first issue. The other issue is when you like childcare centres and things like that. So if you're out there, we have been extremely generous. The country has been extremely generous when it comes to childcare. So that means every time they get a pay rise, that comes out of the taxpayer as well. So I'm just wondering whether you have anything to. So I'm just wondering.
Yeah. So, sorry, Senator.
I'm sorry. I'm just trying to work out, how I guess for government, how generous is it going to need to be over the next few years, considering the economic slump that we're starting to head towards?
Senator, you make a good point. There is a lot of money going into early childhood education and care. There's a lot of money going into aged care. Unfortunately, in both systems, the federal government, and this is quite frankly successive federal governments, have not stood up and really seen how that money is spent. A lot of money goes into, for example, ECEC, and there are private equity firms running private childcare who are making a mozza. Now, we really have very little oversight of that. And I really think that and yet their workers, and several of these large firms have been recently, the Fair Work Ombudsman has taken action because they've actually been underpaying, under the award, their workers. So in my knowledge, and I spend a lot of time, not in ECEC, but I spend a lot of time in home care providers and residential aged care providers. I don't come across frontline workers sitting above the award wages. Sometimes the executives do, because in some of the not-for-profits they're able to use salary sacrificing to affect the more money you're on, the more you make out of salary sacrificing. It's not the norm that people are paid above the award wages at all. So I think it really means that we need to have, particularly in areas of what I would view as public good, like early childhood education and care, aged care, the NDIS, government has to step up and scrutinise how that money is being spent.
Thank you.
It's
Yes.
certainly not going on workers' wages.
No, I'm aware of that. I'm also, do you have any ideas on I agree with you in childcare. There are some of them out there doing it really tough, especially those government ones. And then you've got rich people running around with 10 cars in their garage. Do you have a solution for that sort of an issue at all? Is it worth looking at capping or something? Or I just find it bizarre when I read in papers of these childcare owners out there that are absolutely making an absolute handful of, an absolute crapload of money, to be honest with you, and still
I
not
think-
paying their workers. Do you have a solution for that at all? Because seriously, it is completely out of control.
Well, the Royal Commission to Aged Care Quality and Safety considered this issue deeply in respect of aged care, and they really said that there's got to be a lot more transparency in governance arrangements of providers, and also accountability. So, for example, the federal government over the last couple of years, in particular of COVID, have given a lot of additional funds to residential aged care. We have no idea how much money, how that money was spent. We don't know if they got additional funds for infection control, it was spent there. So there needs to be a lot more transparency. I actually think while in an ideal world, if I was redesigning these systems, I would have them public sector systems. But really, the privatisation horse has bolted to some extent. And I think that we need to make things much more transparent so that when you receive government funding, you have to account for it. And there has to be a limit put on how much profit you're able to make out of services that are providing, as I said, public good.
Thank you. Thank you so much.
Good, thanks. Thank you, Senator Lambie. Senator Payman.
Thank you, Chair. Professor Charlesworth, can you please explain or go through what improvements need to be made to awards in low-paid sectors?
I'd be very pleased to, Senator. So if once again, and I'm thinking of awards such as the Aged Care Award that covers personal care workers in residential aged care, the Social Community Home Care and Disability Services Award that covers home care workers who do home care work. I'm thinking of the General Retail Award that covers retail workers. And in all those awards, there is not only low wages, which is one thing, but the other thing that those awards have, which you don't find in an award, for example, like the General Manufacturing Award, is extremely porous working time conditions. So you've developed in retail, but also in aged care, an employer practice of employing people on part-time contracts, really short-hour part-time contracts, which keeps people hungry for hours. So they only get 10 or 15 hours guaranteed a week, but then they're offered an additional shift and they're expected to work it, and they often want to work it because they need that income. So they're going hungry for shifts. That produces the most extraordinary lack of working time security for workers and income security, but particularly if you're trying to juggle caring responsibilities, it makes it almost impossible. So if you're in retail and you're getting 3 hours or 15 hours a week and you might get 3 hours a day, how do you organise childcare? Childcare wants you to pay a day's fee. It won't accept you paying just for 3 hours. If your shift gets changes, and once again, in all those awards, the ease with which employers are able to change the shifts of, I'm not talking casual workers, permanent part-time workers, means that they achieve a casual-like flexibility at ordinary time rates. They're not paying any premium. They can flex people up to 38 hours and flex them back down again to their minimum wages. So I think it's a major issue, and I think that kind of renovation where we're looking at, or revitalisation, if you like, of the award system is absolutely crucial. So yes, we need decent wage structures, something that the Fair Work Commission noted it would in its recent work value decision in the aged care sector, noted it would consider the classifications that we have. In all those awards I mentioned, they're very narrow classification structures that are compressed, that don't have proper skill descriptors. So if I'm an employer, do I employ someone at level 2 or level 3? It's entirely unclear under the award. And guess what? I'm going to employ them at level 2 rather than level 3. But even if I employ them at level 3 and say in home care, you get an extra 35 cents an hour, really. So they need to be addressed, but particularly working time provisions. We need proper rostering provisions to protect workers and create, jobs that are possible for them to do and manage within the rest of their lives.
Absolutely, thank you. Why is it important for the Fair Work Commission to have the power to bring the funder to the bargaining table?
Well, the funder sets the price. So if you think of the funder as the lead employer in a supply of contracts, so it's for example in both residential aged care and home care, depending on somebody's the client or the resident's assessed level of need, a certain amount of funding is paid. But, for example, even if we go back to 2011, the Productivity Commission found that the government payments for the sector did not take into account the cost of labour. They were made irrespective of the cost of labour. Things are slightly better, as I understand from one of my colleagues, Fiona McDonald, who does a lot of work in the National Disability Insurance Scheme. At least there, the costings are based on what it costs to employ a disability support worker at level 2.2. So that's factored into the system. In aged care, both home care and residential aged care, we haven't had that. So, having the funder there who's actually saying, well, okay, but, these are the things we have to take into account. But yes, we're prepared to facilitate an increase in wages is incredibly important. And I'd note that one of the unusual things about the aged care work value case is the employers and the unions were at one. They all wanted a wage increase. Now the employers, because they're desperate for more workers, and the fact that you get paid the same for, doing, sitting beside someone when they're dying and providing comfort to them and their family, as you do for stacking shelves in Aldi, is a disgrace.
Thank you. That's all from me, Chair.
Thank you. Senator Pocock.
Thank you. How's our time, Chair?
We've got
a few minutes.
Yeah, we've got 6 minutes. Yeah.
Okay, thank you.
Very good follow-up.
Do you want to do that yours now?
Oh, it doesn't matter. So I'm just wondering what your thoughts are right now. The unemployment rate is right down. There are jobs galore out there. People are moving up. There's a real hustle out there, especially in some of those industries about, poaching. Wages, I think people are getting some really good wages at the moment. What is your take on that? Especially, you've got, especially places like hospitality and that, they're actually offering more to get workers so they can keep their doors and that open. Do you see any issue with this at all, why this unemployment rate stays down? Because seriously, people are screaming and they're already paying extra and offering extra out there. Is there any thought on that at all?
It would only be anecdotal, Senator. I couldn't really talk meaningfully about the hospitality industry, except to observe my youngest works in hospitality and he gets paid the same wage as he used to before this. So
Okay, yeah, it's not
I
just
think-
it's not just hospitality, because people are screaming for
No,
they're
no.
offering extra money. There's a lot of that going on.
Yep. Yes, no, I've read the media, but as I said, all I could, the only comments I could make would be entirely anecdotal.
Thank you.
Thank you, Senator Pocock.
I think Senator Lambie raises a really important point, which is that in some sectors, for example hospitality, we do see rises in pay to attract workers in some cases, but it's not possible and it's not happening in childcare. I had a delegation in my office yesterday of childcare workers from across the country, a number from Western Australia, South Australia, no one from Tasmania, but they were talking about how they've had no change in their pay, but they've had a massive shift in the workload that they face. And so their colleagues, we had, they've now got childcare centres who have been for many, many months below the required ratio of carers to children, for example. And those ratios are meaningful. They're about the health and safety and proper education of our kids. So we've got some sectors that can and move ahead in terms of their pay offerings, others that can't, and a massive exodus of workers out of childcare into retail. That's a statement, but I'm wondering, am I representing what the data story says on the ground, Professor Charlesworth?
In terms of it is true in terms of early childhood education and care, as in aged care, they are absolutely screaming for workers, but it's to do with it is to do with pay rates, and it is also to do with job security, and that really sits in the gift of the federal government, in my view. We really have to do something about this. We're requiring, particularly early childhood educators, we're requiring quite a high level of formal education from them. We entrust our children to them, and it's shocking to think that the ratios are not being met, because they're pretty, they're minimum ratios. They are not what we would like to have. They're minimum ratios where you can have a safe workplace, safe for children, safe for workers, and actually, as you say, provide some education and care. I mean, we really have to, I think, review, and as I was saying to Senator Lambie before, we have to review in these care sectors the whole economy. I mean, where is the money going? Because it's not going to the workers, and it's a serious issue, because we're both wanting more women back in the workforce, but if they can't find a place in childcare, and it's dire in regional markets, in regional areas. And one of the problems is our system incentivises childcare in the richer socioeconomic areas, and so we've produced what we call thin markets. So in regional areas, in lower socioeconomic areas, it's even harder to find a childcare place for your child. And that's to do with the design of a system.
So are you suggesting in aged care and in childcare that the for-profit centres flow to where the profits are larger? For example, it is much less profitable to look after a child of 6 months, a baby, than a 3-year-old. And it's easier to look after a low acuity aged person than someone with dementia.
Yes, it certainly is. I mean, there's certainly a little bit of creaming, but what some of the for-profits are able to do is in better socioeconomic areas, they then say, well, that they'll provide for an extra fee, Japanese classes to your child, or they'll provide, there are all these add-ons that they can put on to really make considerable amounts of money. And so we're left with kind of bargain basement care for a lot of people, but particularly it's a chronic issue, as I understand from colleagues in rural and regional areas, being able to find any childcare at all.
I wanted to go to your evidence on what you called a lack of working time security. And I'm very intrigued by this because we've heard a lot of evidence at our Select Committee on Work and Care from workers who cannot predict their care needs tomorrow because of what you described, a kind of Hunger Games around shifts, a complete unpredictability about hours next week or tomorrow. What is the solution here? I'm wondering about whether there is something to be learned from more male-dominated industries which have greater working time security. For example, would there be some value in looking at award provisions or creating more of a platform in awards to give a responsibility to employers to attempt to reasonably accommodate, for example, and provide some security around rosters? What can we look to there that would make a difference? And I'm thinking about the right to request as well. When I raise these issues, I'm often told the right to request is the means to address them, but that requires an individual every time to take up a discussion with their employer. Many workers are not in that position, especially in a highly casualised labour market. Would it be better to put more onus on a reasonable accommodation in awards?
Yes, although I suppose the notion of a reasonable accommodation is what comes out of anti-discrimination provisions. For example, in Victoria, the Victorian Equal Opportunity Act, there is a provision that a person's carer's responsibilities have to be reasonably accommodated. But once again, that's an individual. It means an individual has got to go to the Fair Work Commission and say the employer didn't reasonably accommodate me, etc., etc. So it always puts the onus back on the individual. I think we could learn a lot from some of the working time provisions in male-dominated awards. And once again, if I go to the manufacturing award, if I'm employed on a permanent part-time basis, for example, 20 hours a week, the moment I work an additional hour, I have to be paid overtime. Now, that has two effects. One is that I'm properly compensated for making myself available beyond my guaranteed minimum hours. But secondly, it can also encourage employers to say, well, look, we're always asking, this worker to work additional hours. We should increase their period of minimum engagement. You tend not to have in manufacturing that almost just-in-time rostering that I think we see in sectors like retail and in care sectors, so that it does amaze me because we've got plenty of science about the way these things work, and there's always going to be small changes. Somebody is always going to be sick, but you can't build a whole system around then just deciding you're going to ask somebody who's just worked, their 3 hours to stay on for another 3 hours, because that's the way it's working at the moment. In aged care in particular, there's an awful employer practice called availability, so that a worker might get 15 hours, guaranteed hours, but to get those 15 hours, they've got to say they're going to be available for 20. So they might say, okay, I would normally start at 9, but I'll be available from 7, for example. And it means at 6:30 they can be rung and said, right, Sarah, you're on. You've got to go and see Mrs. Brown. It's absolutely hopeless because it's assumed, and I've sat beside rostering clerks as they do this, at 6:30 in the morning, as somebody might call in sick and they've got to cover somebody's visit somewhere, and they'll just look and see who's green, and that green means that worker is said that she can be available in those hours. Now that's on that kind of on-call nature of the work. It's not compensated in any way. There's no on-call allowance. It's just, so I really think that we can take a leaf out of some of the rostering provisions that sit in some of those male-dominated awards.
Thank you, Professor Charlesworth, for your evidence. Thanks, Chair.
Well, thank you very much, Professor Charlesworth, for your time with us today, and thank you for adding to our discussions and our considerations for our final report. If you've taken any questions on notice, if you could have return those answers by the close of business on Monday, the 14th of November, it would be a great deal of assistance to the committee. But thank you again.
Thank you very much, Chair. Thank you. Bye.
Now invite the National Farmers Federation to join us. So I now welcome in person representatives from the National Farmers Federation. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
I'll start. Thank you, Senators. My name's Tony York, and I'm the chairman of the NFF's Workforce Committee. I'm also a farmer from Western Australia, and I have to say that usually for these appearances we'd have our President Fiona Simpson and Tony Marr here, but they send their apologies. They're away at the moment. Thank you.
Thank you.
And my name is Ben Rogers. I'm the General Manager for Workplace Relations and Legal Affairs at the NFF.
Good, thank you very much. Now I invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions. Over to you, Mr York.
Thank you very much, yes. I hope, Senators, that you're all familiar with the National Farmers Federation and that we're a national organisation representing farmers across the whole of Australia. We're the only organisation that's in that capacity to represent all of agricultural farmers across Australia. In summary, agriculture at the moment is very fluid, but for most farmers, we've been enjoying relatively good seasons and quite positive commodity prices, notwithstanding the recent floods in Eastern Australia, which will most definitely affect many farmers. And I would like to point out that overall inflation is having a very significant forward-looking impact on the cost of production for many farmers. I myself am a cropper in Western Australia, and we're already doing budgets that are looking at the cost of our input costs for production and for cropping next year are something like more than 30% above what they were only 12 months ago. So we are experiencing very significant inflation impacts, and they are certainly having a bearing on where farmers will be investing and farming in the future. There are a number of complex and domestic and global issues that farmers are dealing with in the industry, and we must navigate that in partnership with government. One of the most significant and long-standing, of course, is the issues of reliable and consistent supply of the workforce and labour. It's a problem for us in securing reliable farm workers is heightened through the COVID and border closures. But the reality is that the farming sector has always had a long-standing challenge in meeting sufficient labour for many, many years. As a consequence, we are, of course, interested in the amendments to the bill and the introduction of this bill. We're prepared to welcome any rational and well-considered changes to industrial relations and labour policy, particularly those that promote and help farmers be seen to be employers of choice. So that's absolutely consistent with the view of the NFF's on workplace relations. For that reason, we're keen to take the interest that we have in the Secures and Better Pay Bill. We were a participant in the recent government's Jobs Summit, but we would like to point out that we've had basically no ability to realistically contribute to the debate to date, and one of the big reservations we have about this process is the rapidity and the speed in which this bill has been introduced to Parliament, and hasn't given us adequate time to deal with all the issues and digest the amendments. Taken as a whole, the bill contemplates massive changes of the Australian industrial relation landscape. Some of the individual changes are relatively minor and not directly related to agriculture. For example, in the building industry and the abolition of the Building and Construction Commission is not really an aspect of the bill that we can actively and knowledgeably participate in. Many of the reforms are welcome. Many of the reforms are welcome. The laws to promote positive social reforms in particular must be embraced by all modern industry sectors, and agriculture wants to be part of that process and embrace those social reforms that are being proposed. So we support those, and we can understand the motivation that is used in that context. However, there are some unintended consequences, and for example, I'd like to point out the limit on fixed terms over 2 years is likely to be a challenge for parts of the agricultural sector, and it particularly could be problematic with seasonal workers in that they are regularly being employed on fixed-term contracts and will continue to go on. So in the past, well more than the 2-year cut-off limit that's proposed. Of most broadest concern is the potential of multi-employer bargaining and the potential that can throttle business innovation and productivity. There have been little mechanisms that we can see in this process to offer productivity gains. It's really a process of adding costs. We are concerned about the potential of the bargaining across multiple competing interests and the increase of complexity, delay and costs of this process. Potential for small business to be steamrolled into these arrangements, which is unsuitable to them and give their bigger competitors a commercial advantage. If you're in the employment sector, it's very difficult for small employees not to be forced into following the lead that's been set by big business in terms of costs, without being directly participating in the process that's got to those increased employment costs. Concerned about the instruments being imposed on farms through the multi-employer bargaining as well, arrangements and the attractable bargaining declarations. We are most concerned effectively about the potential for widespread industrial action shutting down supply chains and processing sector. They are of direct consequence to farmers. I'm old enough to remember the consequences, say 30 or 40 years ago, when there were much more widespread across-the-board industrial actions and strikes, and they have, very significant implications and costs that get passed on through to the agricultural sector. And it's not just a monetary consequence. You lose the opportunity of continuity of supply and shortages, and there's even animal welfare issues, etc., that can come into effect if we have widespread strike action across the supply chain and processing sector. We do think that, as a whole, the whole bill proposal has too many changes and are far too significant to be rushed into law. So while we do applaud some of the social reforms that are part of the bill, the complexity that the bill introduces make it very difficult for us to support the bill as it is at the moment. In a summary, far too many changes far too quickly. We haven't had time to digest all of the consequences and the nuances that are like to be involved. And to be frank, I haven't had a lot of time to read the bill, and I believe it's only been around for a week or two. I do think the government is treating the parliamentary processes with some degree of contempt by rushing this through to the extent that it has. Thank you very much, Senators, for allowing me to make that statement, and we're willing to accept open to accept any questions.
Thanks very much, Senator O'Sullivan.
Thank you very much, Mr. York, Mr. Rogers, for your appearance today from Western Australia too, Mr. York. So I appreciate you coming over.
Yeah, thank you.
I know what the trip's like. Thank you. Your statement was really strong, and I appreciate your frankness before the committee today. The government does claim that they've consulted widely and they've got a mandate for this. They point to the Job Summit as, I guess, their key consultation piece. Can you just elaborate a bit more on your feeling with regard to the, whether or not the government has in fact consulted widely? And as you respond, can you also talk to us about what you would normally do in terms of engaging with your members and what sort of time frame you would need to be able to get their views on particularly complex legislation such as this?
Thanks very much. I can make a brief comment, but I'll invite Ben, if you may, to explain the process. But look, we've had no time whatsoever to consider the bill, and my experience in the past that we would be given at least a couple of months really to digest and get back to our organisations as we're disparate and spread right across Australia. It does take time to feed the amendments and the proposals down to our membership and get it back. So this is just ridiculous for it to be going as quickly as it is. But Ben, you might be able to elaborate a bit more.
So I mean, there was some vague allusions to multi-employer bargaining at the Jobs and Skills Summit, but it wasn't really fleshed out in any meaningful way. The first time we became aware of these significant changes was, or what I became aware of it, was at the COIL process, which is where government consults with industry and unions. We got a copy of this, the bill, which is, this enormous piece of legislation introducing massive change. We got a few hours to read through it. We didn't get any context from the government. We didn't get any context from the public servants who were supposed to be guiding that process. We were told in no uncertain terms we weren't allowed to. We were given an opportunity to give feedback to the bureaucrats about the bill, but we were told in no uncertain terms, not on policy, just on technical aspects where you see conflicts or that sort of thing, or where you have concerns about some of the language, that sort of thing, but not because we were expressly told can't comment on policy. The bill was then taken away from us, so it's not like we could take it back to our membership then and really spend some time getting across it. So we really didn't get the bill until it hit the floor of Parliament about 2 weeks ago. And it's a really complicated bill. It's not a standalone piece of legislation, it's an amending act, so you have to read that in conjunction with 1,000 pages of Fair Work legislation. And then there's been rolling amendments as the bills progress through the House. I'm not even familiar with what those changes are, but I understand there's around about 150 of those changes. So this is not current. I don't have a current copy of it, and some of the comments that we may make today are based on a bill that's no longer relevant. So it's really unhelpful. And then just in terms of consultation with our members, well, we're a federation, so we don't have direct membership. Our members are themselves farming bodies, so we have to go to we have to explain this complex piece of legislation to our members, who then have to get a thorough understanding of it. Then they have to take it out to their members who are farmers, many of them whom are remotely located. They're working on the farms, so they can't just drop everything and come to a consultation process.
Well, no, it's harvest time now, isn't it, in WA? So.
It is.
Yep.
And then they have to our members have to get that feedback from their members and then feed that feedback back up to us, which we then have to gather into some submissions which we make to the government. It's a fairly long and detailed process. When I'm expressing a view, I'm not expressing Ben Rogers' view, I'm expressing the view of farmers out there, and there are a lot of farmers out there, so to get their views and reach a consensus is a fairly time-consuming process, and we just have not had that time.
Now, we haven't got a lot of time today, and not a lot of time to look at the bill. Certainly don't have a lot of time today, so I'll just run through a couple of quick questions and with your brief answers, if I can ask. The government is also saying that this bill is justified on the basis of lifting wages. Have you been provided with any modelling that demonstrates how the bill will impact wages across both the supported and single interest streams?
The short answer to that is no. We haven't seen any evidence, any convincing evidence. There's been no significant consultation, so there's been no effort to explain to us how that's going to happen. So we have to weigh the changes and the concerns we have around the impact upon the industrial relations system against the likely outcomes and the prospects of this thing actually, this legislation actually boosting wages. And we don't see any evidence they're going to boost wages. We see really significant consequences for the industry potentially. So how can we support this bill?
And are you clear on the... Sorry?
Can I? I'd like to point out I can't see why the current bill is not being effective in raising minimum wages anyway. For example, there was a 15% increase not that long ago. So I can't see that, there are great inadequacies in the process at the moment.
Certainly for farms, we hear about, because of the lack of labour, we hear about massive increases in salaries across the board. Now, that is partially a consequence of the COVID border closures, but in terms of our industry, we're not convinced that there's a massive issue about wages and low pay.
Okay. Are you clear on the parameters in relation to which workers will be included in the single interest and supported bargaining streams?
No, I'm not. There is a little bit of a framework within the legislation, but my reading of it is it's largely at the discretion of the Fair Work Commission. There are some things that the Commission is directed to have regard to, and that can include some other things which are identified in the legislation, but really it's extremely broad.
Extremely broad, yeah.
There has to be a common interest, but what that really means, probably there's not going to be a common interest between someone who's selling bikes in Fremantle and someone who's growing grapes in the Sunraysia. Okay, fine, but beyond that, I don't really know. And it seems to me that could be up and down the supply chain. It could be with everyone within the same region. It's really broad.
And different geographies. I mean, you're all farmers, but you could have potentially be brought in a situation in Tasmania and you're in WA, or there's those sort of concerns.
Kind of a berry grower in
Well, supply chain. Yeah, exactly.
You mentioned supply chains in your opening statement, and just the impact on potential costs and disruption, particularly if there was increase in industrial action. What do you think the impact would be ultimately on consumers in the grocery stores and supermarkets across Australia?
Well, I'm pretty confident to say that it's going to increase the costs of those products and the food on the shelves in Australia. I mean...
and how come? Might seem obvious to you, but explain to us.
So we're price takers, farmers are price takers, and invariably the supply chain process, which is post-farm gate, but it adds to the costs of goods and services and groceries, for example, and food that's on the retail plate, and that'll get passed straight on to the consumer. So most definitely that that process will be pushing back and trying to minimise the increase that's paid to the farmer for their goods, but at the same time they'll be open to add costs to the consumer in terms of the end cost. The thing about agriculture is in that supply chain, we don't have control of that supply chain. There's very few sectors in agriculture that are vertically integrated and have control of that whole supply chain. It's also quite diverse. There are different levels of logistics companies and sizes and so on. They're not all under the one organisation, so there's going to be a lot of uncertainty about what the consequences are.
So is this just hypothetical, what you're talking about, or is there a history here? Have you got any examples you can point to where in the past this has occurred?
Yeah, well, I mean, Tony will probably have plenty of examples, but most recently at Port Botany, there was the ports were shut down. It was just affecting the stevedores. It didn't go across the entire industry, and it certainly didn't affect down the supply chain to the transports or the storage warehouses. That added another 5% onto the cost of production. Now, farmers can't pass that on easily to consumers. Farmers have to absorb that. So the consequence for farmers is the cost of doing business is extremely high. And I wouldn't be at all surprised if we see some farmers go out of business as a result, particularly when you're taking into account the increase in the cost of living and inflation. And I also, just to add to Tony's point, consumers were horrified, within the last couple of years when they went to the grocery store and saw the shelves bare because of difficulties within the supply chain and labour shortages as a result of COVID. I don't think it's far-fetched to think that could happen again if there is widespread industrial action, which most business groups, ourselves included, are anticipating or at least concerned maybe the consequences of this bill.
Okay. Do you see a possible scenario where multiple businesses with competing commercial interests are compelled to bargain with each other?
That seems to be eminently possible within the context of this bill. I mean, the present legislation prevents that, but this bill removes that prohibition. You could have one large producer, and I won't call anyone out, but you can probably think of some of the larger growers out there, and then you've got a lot of smaller growers. Yeah. The larger growers can absorb the additional costs, and it might even be to their commercial advantage.
Might be to their advantage because
the majority can't absorb that cost. They're out of business.
And you could get a majority within that large business, rope in a bunch of others sign them up, get a small majority there.
Yes,
Yeah, okay.
exactly the point.
And so what's the impact of that? What's the impact of, particularly for small businesses? What percentage of your organisation, of your members are small businesses?
Well, under this bill's definition of under 15 employees, probably 80, probably 90%. So
Yeah.
a very, very small percentage of farmers themselves are not small businesses. But there are some, and
Yeah.
there is an argument that many farmers that see
But it's the
themselves as
supply
small
chains
businesses
as well, yeah.
do employ 50 to 100 people, particularly in the horticulture sector, on a very regular basis. So they can't be defined as a small business, but it's the supply side,
Yeah.
both supply into agriculture and supply down into the markets that are much more likely to have a good mix of small and large
so what-
businesses. So probably the majority of them are larger businesses.
Yeah, so what you're saying is that while maybe the farm, which might only have a small number of employees, wouldn't necessarily be directly impacted by
Yes.
this, they would be impacted because of their supply chains. Their
Correct. That's
inputs
right.
and out. Yeah.
Yes.
Okay. Thank you.
Close question, yeah.
Oh, that's fine. Okay, thank you.
Thank you. Senator Pocock. Senator Barbara Pocock.
Thank you for your evidence and for being here. I just wanted to pursue your comments, Mr York, on fixed-term contracts. My reading of the fixed-term contract clause is that it's not intended to capture intermittent, seasonal, short-term labour needs. I grew up on a wheat farm in Lameroo in the Mallee in South Australia. I know about seeding and harvest and how you know everyone is looking for extra drivers and so on at that time. The clause says shouldn't be continuous contracts beyond 2 years and end on contracts that have a sum of employment that's longer than that. I'm just curious about your thinking there. I mean, if you're on continuous short-term contracts as a worker, where your work is continuous, trouble getting a home loan, trouble and uncertainty in your life, that affects our country, towns and communities, the certainty for people. Have you got a worry about the 2-year limit, or are you worried that it's going to catch genuine seasonal work? And, I don't read it that way. But what's your comment?
Well, I'll speak to that, Ben. So, yes, we're uncertain about whether those short-term contracts will be able to continue, given our reading of the bill is that once it's accumulated to 2 years, you have to no longer be on a contract. And
I think it's continuous employment. It's not adding up your seasons the way I read it, but I'd be curious.
Well, I mean, again, it's difficult to say, but my read of it is that there has to be substantial continuity of employment. So I don't really know what that means, but my concern is that if you have, for example, a worker who comes out to Australia to work on a horticulture farm under the Pacific Australia Labour Mobility Scheme, they might come out for 9 months, they might go back to East Timor or wherever they live, and they come back for another 9 months. Now, if they're coming back to the same farm over those 9 months period, my concern is that there would be a substantial continuity of employment for the purpose of this bill. So there's 9 months and the subsequent 9 months and perhaps another subsequent 9 months, they start to add up, and this employee automatically becomes a permanent employee under the terms of this legislation. Now, there is a carve-out, which I think is supposed to be for harvest seasonal work, but that talks about essential work, which is necessary during that season. If you have workers who come over, say, to pick fruit, if you move some of your permanent staff over to the picking roles and you bring in temporary staff to backfill those roles, then those people backfilling those roles aren't doing essential work, so they wouldn't be entitled to that exemption. It's just I need to make clear, the feedback from our members is not that we have a massive objection to this provision here. It's just we're concerned about inadvertently being caught by situations which it's not supposed to cover. That's it. And it really does come back to that piece around consultation and getting a sense and really being able to spend some time with the legislation, understand what it does and give some feedback about, well, maybe you want to tweak this part here just to make sure that our guys aren't caught in a circumstance in which they're not supposed to be.
So it's clarity you're looking for.
Basically, and being confident that this is going to work the way it's supposed to work.
Great.
That's
Thank you. Thanks for being here. Thanks, Chair.
Thanks very much. I'll now go to Senator Lambie.
Thank you. Good morning. Are you worried about any collusion going on up the top there and what that effect is going to have? Let's face it, there is some big companies out there that do farming. I won't mention any of them here as well, but are you worried about for them obviously to make more money, that they may collude together and which will have an effect on these guys down here?
Look, to be frank, I'm not concerned about that. I don't think that's an issue. But
You don't see the big boys out there making deals which will affect these guys down
I think
here?
that's
comes
what
back-
you imply.
Sorry,
Yes.
sorry.
I
I
misunderstood.
probably didn't say that, yeah.
I think-
Joining forces of the repercussions out of that.
Yes. I
Concerned
think
about the
we-
potential for that, yeah, and I think it comes back to the question that Senator O'Sullivan asked us around whether or not big employers can use their bargaining power to drive home agreements which are disadvantageous to the smaller employers.
So they're looking for pay rises, right? They believe this is going to do pay rises. Now, we can go back to I believe that 30 or 40 years ago you were talking about the Wharfie strikes. Is that what you're talking about?
That was the
Yeah, why
main
don't you
driver,
quickly
yes.
give us the 2 minutes on how that went for the country and what effect that will have? Because right now we are paying high prices. We're already paying for. We're Tasmanian. We do our own down there, and the price in the supermarkets right now, right across the boards for meat and vegetables, is bloody atrocious. So why don't you tell us what's going to happen if that comes into effect when there's strikes? Why don't you give us a quick rundown in 2 minutes and remind Australians about how this can have this negative effect if union gets too much power out
widespread
there?
industrial action, from our experience, had really fueled inflation. It didn't relieve inflation. It didn't distribute, and the effects of inflation were the real consequences of the widespread industrial action. It added costs across the board to pretty well all Australians. I can only speak for agriculture directly, and it had very, very severe and debilitating consequences. And I mention again, it's not just the added cost, it's the disruption to supply, the loss of a relationship with clients, etc. If you're with regard to the wharves, a lot of the agricultural sector it's very reliant on the export sectors, and you lose clients if you can't supply reliably. And through no fault of the ag sector, those widespread industrial actions had very, very significant consequences in terms of loss of market, loss of confidence in our supply, and effectively added costs. So there were some commodities and some products that, as a consequence of that, were no longer competitive in terms of meeting and supplying their markets. And if I haven't said it clearly enough, it had widespread consequences across the whole economy. They were very, very debilitating, and it's a nightmare of shudder of the consequences of having that sort of industrial action, and we're just extremely worried about the consequences of those sorts of events happening again. I don't know, Ben, if you want to add anything.
Just briefly to say that when we talk about this stuff, we tend to think about our imports, but also about our exports, but also imports are important. You know, farm machinery, the inputs into farm chemicals and so forth. If there's strike action happening on ports, then that has a massive impact on our ability to access the machinery and the inputs that we need. So, for example, again, looking back at Port Botany, you'd have massive machinery which was supposed to come into Fremantle, arriving instead in Melbourne, then having to be transported across the country by road at significant cost in the millions of dollars. Massive impact on farming.
And I just have one more question. And how much time have you been given to raise these concerns with the Agricultural Minister?
Well,
Look, he's aware of it, that's all we can say. I mean, we've only had a couple of weeks, and we certainly haven't had enough time to really detail the consequences. So I think the Ag Minister is awaiting us to give him more substantial cases of the repercussions that this could affect. But
I mean, I know Tony and Fiona have talked to him about it, but it's only at the very highest sort of level. There hasn't been any sort of detailed feedback around concerns that the ag sector has about this stuff.
Oh, okay. Thank you.
I now go to Senator David Pocock, but just a follow-up question. You seem to have some very definitive views about the legislation for somebody that doesn't have a view about the legislation because you don't know what's in it. It's very interesting. Over to you, Senator David Pocock.
Thank you, Chair. Thanks for your time today. Mr York, thanks for all your work in ag R&D over the years.
Thank you.
I'm interested to just learn a little bit more about the ag workforce and whether or not are parts of the ag workforce currently covered by single enterprise agreements. What's the usual sort of setup?
Most of the ag workforce will be covered by awards. I mean, there are individual contracts, obviously, and farmers tend to be less formal in the way they approach this stuff, probably to our detriment, if I'm honest, but they wouldn't usually go to the trouble of negotiating an industrial instrument. So the use within the sector, I'd have to take it on notice, but it is very, very small. And it's, I mean, like a lot of the sectors, it's interesting. If you look at the stats, you can see how the use of the industrial agreements sort of went up through the early 2000s and then sort of fell off a cliff around about 2014. So yeah, the use of them is very, very small, but that's not to say that there aren't some industries out there, and obviously some of the bigger growers would use them when they have those massive spikes in their workforce around harvest time.
And do you have stats on the average business size for a farmer in terms of FTE and then in terms of headcount?
We do, but it does vary in different commodities and so on quite significantly. A lot of the broadacre agriculture, the figures are more like 4 or 5 or 6 full-time equivalents, but in horticulture it's considerably more than that, and not probably on average. A full-time equivalent's way above the 15 threshold. So there's really no average figure in agriculture. It's really specific to each commodity
And region, yeah.
And for the businesses, farmers who are doing fruit, when you have those seasonal workers coming in, obviously the headcount is going through the roof. But
Yep.
how are those workers generally being employed?
Most of them would be casuals. Do you mean in terms of the form of employment, or how are they? Yeah. So most of them would be casuals, is the reality of it, and I describe that as a true casual employment relationship, because they might come on the farm for just 3 months, and the work that they do there is going to be highly dependent on the weather. It's going to be highly dependent on the season. It's going to be highly dependent on a whole range of factors that it's extremely difficult for the farmer to predict. So they have to have a worker who they can pull in when they need them, or a whole army of workers to pull in when they need them. But it might be that they don't need them the next day because there's been rain. They don't need them the next day because there's been frost, or they might need them to come in really quickly because they need to get the fruit out of the ground before those weather events affect the capacity to pick it or the quality of the fruit.
You've talked a few times about the supply chain, and again, keen for you to elaborate about your concerns here, in terms of getting produce from the farm gate to the retailer. If you could maybe give an example so we can kind of get our head around what you're talking about when you sort of say concerns about the supply chain being disrupted.
So my direct experience is not with the consumer side of marketing and agriculture. It's really the export sector, or the processing sector. So for me, there's a real risk that there are intermediaries in the supply chain, and I'm pretty confident some of them will get roped into these amendments in one way or another, because they're in that crossover of not being small but not being large companies. And there is some uncertainty for that on the side of things. But in terms of horticulture and fresh foods, maybe, Ben, you've got a better
So I mean,
hold on it.
Not really my area, but I mean, for example, you might have a small grower who picks their fruit, then they'd ship that to a large grower where it would be packed, and then the grower would, there'd be a storage service at the large growing farm. They would then ship it to the delivery units for the big supermarkets, and then the supermarkets would put it on the chain on the supermarket shelves. But you can see there's a lot of steps in that process, and any one of those steps, industrial action could, basically throttle the industry.
I think I've heard the NFF talk about being supportive of splitting this bill. If that was the case and the supporter and cooperative stream were sort of split off, would you support those two going through as is, or do you have concerns with them?
I have concerns about the supportive stream because we don't really understand the scope of that stream. It's pitched at low-paid workers, so we understand that. But if you read the legislation, again, my reading is it's nowhere near that narrow. It's extremely broad and effectively up to the Fair Work Commission as to whether or not the workforce and the characteristics of the workforce are appropriate for that stream. So we would suggest that be split off as well. The cooperative stream, we've got no problem with that as long as it's an opt-in type arrangement. I think it's actually, frankly, I think it's a really good thing, and I'd like to see it be adopted by farms.
And in terms of the consultation process, while the policy was being developed by government since the Jobs and Skills Summit, my understanding is that they've been in touch with stakeholders. Were you able to take information from those meetings to your members, or had you signed a non-disclosure agreement, or how did that process work?
So that was the call process I was referring to earlier. Yeah, you sign an NDA, so you can't actually communicate until the bill hits the Parliament floor. I can't actually share with my members, and I couldn't, and I didn't because I signed that NDA, what was in that bill with my members. So that is, I'm sorry, but that's not a consultation process in my view. It's a sort of a vetting, a sense checking. It's a having a look at the bill and making sure there aren't technical issues that you can identify. But in terms of actually being a consultation with our members, it's not consultation. And I can't go to those meetings. I haven't read the bill before I go to that meeting, so I can't actually get my members' feedback to take to that meeting. It's just what I think when I'm reading the bill. And again, it's just technical stuff. It's not policy.
Can I just...
You both shook your head. I just want to make sure Hansard picked it up. You both said no.
No, yes. Yes, the answer is no. I would reiterate that my observation, and from what the feedback I get, is it's very, very rare for a bill like this, as complicated as it is, to be pushed through as fast as it has been. And I just repeat, I think it's a breach of parliamentary process. I just cannot see why there is the necessity for the government to put the whole bill as an omnibus bill right through. And certainly we're one of those advocates that said, look, there are aspects of it that we're comfortable with, and you can pull them out, and particularly I'd reiterate some of the kind of social equity aspects of it. I think, we've got no problems with that, but we really do need a lot more time to fully digest what the IR sides of things are in terms of the long-term consequences. Thank you.
If you want to do a
Sorry.
follow-up question, if Senator Pocock's...
I just want to go back into that single interest bargaining stream and supported bargaining stream. Can you explain to me, because I too am still trying to get expert advice from left, right and centre, do you know what it means with when they say this idea of common interest? This includes reference of geographical location, government funding and the nature of the enterprises.
Go, Ben.
Sorry, Ben, I'm just trying, how does all this fit together? I'm just a bit, what's the geographical location? What is that?
Well, so, I mean, you've identified, I think, one of the shortcomings of legislation.
Okay.
I don't really know what that means, but does it mean that they're all within the same state, within the same country, within the same local government area, within the same postcode? Right. Short answer is no, I don't know. I mean, and that's something that will be up to the Fair Work Commission to decide what that means if this bill goes through, and the scope of, what constitutes a geographical location.
And what's that got to do with government
I do
funding?
understand that the retail sector, I think, are interpreting it to mean perhaps a geographical is a whole shopping centre, for example, and every small business that's in a shopping centre.
Oh, I see. Well, where the consequences of that, I see. Right.
That's in the retail sector.
Right,
I haven't quite digested it all in terms of the consequences it would be, but it could be horticultural sector, it could be all the farms in one particular valley are all roped in. Perhaps, we don't really know, actually.
Right,
so.
okay, thank you. I was just wondering whether you had an answer for that, because I don't get it. So, thank you.
Thanks, Senator Lambie. Just my last one, I guess, interested in the NFF's position on this. You know, there have been some, I think, really legitimate concerns raised about some of the working conditions and pay in the ag sector. How are those best addressed?
Well, I mean, the way to address them is with cultural change, really. I mean, the farmers aren't the kind, and Tony can correct me if he thinks I'm wrong, but farmers aren't the kind that respond particularly well to things being top down. It needs to be driven from within the sector. So we are engaging in a process of trying to drive cultural change to modernise the workplace practices, to really engage with, you know, modern workplace practices and develop the sort of systems that you'd see in a more contemporary workforce.
I would only add that from a NFF's perspective, we don't have any reason to say that we want to perpetuate unreasonable workplace conditions or environments and so on. Absolutely. So as such, for example, we want to disown ourselves from any examples of inappropriate employment arrangements and exploitation, which have recently, some of which have come up through the horticultural sector, and we really want to make it very clear that we in no way want to support any of those examples of exploitation.
And just find, how are those terms and conditions of sort of average employment on farms set? Is it with reliance on the relevant award, or, you know, earlier I mentioned single enterprise agreements?
Well, it would be a combination of factors, but it would be, the award would be one of the things. It would be, you know, individual contracts which are negotiated with the farmers. As Tony pointed out earlier, most farmers are small employers. They don't have that many employees, so there's an individual relationship with the farmer and the worker, and, you know, so that will guide how those sorts of matters are dealt with.
Yeah, so for me, I'd argue that there is a pretty broad-spread reliance on the award structure to set benchmarks, so a broad acceptance that they're the minimums, okay, and that's where we should work from, but there are very strong examples in some sectors, and mine in particular, in the broad agriculture in Western Australia, we're paying well above the award rates across the board, and you know, excellent conditions. I mean, by a factor of 50% sort of thing above the appropriate award rates. So very, very significant above award rates in some sectors of agriculture. But the awards are relied on as a benchmark.
Thank you very much. Thank you, Chair.
Good, thank you. I do find that answer to that question very interesting. The hospitality industry says they're paying people to wash dishes from $50 to $90 an hour. Unfortunately, the ABS statistics tell us something very different.
Yeah,
so if you have some statistics that you can prove your assertion, that would be helpful to the committee, and I can allocate to everybody. Thank
Sure,
you.
I think we can provide that.
I'll be very interested. Over to Senator Pocock.
Just
Pocock.
a question on that, so that I understand the picture. Your farmers are competing with each other. I know they are in my hometown to steal each other's workers. They're offering more, and they're certainly driving the pay rises up. So that's one really important part of the picture out there in agriculture and in farming. A lot of over-award payments. The ag sector is basically not a place where any enterprise agreement making is happening. I mean, across our whole state in South Australia, 4% of people are covered anywhere in an enterprise agreement. And you could probably walk the state and you wouldn't find a farm or an agricultural enterprise where there's an enterprise agreement. Wages are up, bargaining is non-existent. Why are you worried about, why is one of your main worries about the implications of the bargaining stream? Because that just, I don't hear that.
The consequences in the supply chain and in the processing sector, effectively, we end up incurring the consequential increase in cost.
I understand that.
And it would also be concerns that we've mentioned earlier around the multi-enterprise bargaining agreement being gamed by some players to their advantage and the disadvantage of the smaller growers. Increased complexity in the system. I mean, I would love to see a bigger uptake of industrial instruments, enterprise bargaining within the sector. I think it would be really healthy. I just don't think this is the way to do it.
Thank you, Chair.
Thanks. I'll surely just have a brief question. Well, the question's probably not so brief, but the answer, we'll see how we go with the answer. You've gone through this issue of, quite frankly, hysteria and a scare campaign for an industry that has very little enterprise bargaining. In actual fact, the track record of this industry dealing with minimum wages in various sectors of this industry has been appalling. We saw that the National Farmers Federation, this is to you, Mr. Rogers, last year at the Fair Work Commission decision on the Horticulture Award, some amazing comments which I'm seeing repeated right now in a different way for people that don't have experience dealing with enterprise bargaining at all. And I'll refresh your memory. The Fair Work Commission ruled that horticulture piece rate workers should be guaranteed to receive the legal minimum wage. The Commission made that decision after countless stories of workers, mostly migrant workers, being paid almost nothing on Australian farms through shonky piece rate agreements. When that decision was handed down, you said that, and this is to Mr. Maher, your boss, when the decision was handed down, he said that having to pay workers the legal minimum wage, and I quote, a bitter blow, unaffordable, and a handbrake on agriculture's growth. Now, isn't it the case that whenever workers have been given rights, even the basic legal rights, you say the sky is falling in? I'm saying this to Mr. Rogers, Mr. York. If you want to make some additional comments, it's up to you.
Me personally or the NFF?
I'm obviously saying to you, there was on behalf of the NFF, and your boss said that.
The extent to which...
sky falling in or not?
So the extent to which workers weren't being paid in accordance with the award was not something we were supportive of. We were vehemently opposed to that. We were supportive of the productivity-based basis for the piece rates. Where people were being paid virtually nothing, to quote you, that was almost certainly in breach of the award, and the Fair Work Ombudsman should have been in there prosecuting them. I've got no problem with that whatsoever. So, you know, I mean, that was a difficult case, I get it, but the Fair Work Commission's made their decision. We're abiding by that decision. Do we say the sky's falling in? No.
Well, that's contrary to what Mr. Maher said at the time when that decision about the minimum wage being paid in this country. So it's very convenient that you're now saying that that's not correct, because it actually, in fact, there is actually on the record, and on every occasion there has been industrial relations reform, you've taken that position.
Well, I'm sorry, I don't agree. He didn't say the sky is falling in. I can't remember your quote, and I obviously don't have it in front of me. He did say it's not a great outcome for the sector, sure. Okay, but that's not every single industrial relations reform. That was one example. We're calling for things like labour hire licensing. We want to see the government do that. There's been delay after delay after delay. I would call that a positive industrial relations reform, which we would welcome. We certainly wouldn't say the sky is falling in if that was to happen.
Yeah, I'll be correct in what I'll be very clear in what I'm quoting then. Then he said that there was a bitter blow, it was unaffordable, and a handbrake on agricultural growth, paying people the minimum wage. Well, I find that horrendous.
Did he say paying people the minimum wage or just the decision?
The decision paying people the minimum wage.
Can I my understanding really is that it's the circumstances in horticulture where a piece rate allows inefficient workers to pick some fruit, for example. If you are forced to use those particular people to be paid an hourly rate, the consequences are that the costs go up, and effectively it could make that orchard unviable. So there are examples since that bill was put in place, and I can get the data for you, or the example in Western Australia, a horticultural grower who had been consistently employing casual staff, backpackers in particular, in the main, on a piece rate, and he's had to completely restructure his employment process because he cannot afford to employ those backpackers on an hourly rate. It just is unviable. So he's going through the process of recruiting more reliable, more efficient, more productive workers that he can afford to pay the hourly rate. So
Mr.
it's
York,
having consequences.
Mr. York, I don't oppose an employer. I would be concerned if any employer didn't have the right to properly manage their workforce, and what you've described to me is that the employer's properly managing their workforce, but the minimum hourly rates should be paid, and that's what's both legally obliging, and also it's unfortunate that the National Farmers Federation, right until the bitter end and until after the decision, were appalled that the minimum wage is being paid. I find that reprehensible. Senator White.
Thanks. You understand, don't you, that government sometimes has to act very quickly when emergency situations or difficult things confront the country. Let's take, for example, in your own industry, you know, the FMD and the Varroa mite. You wanted the government, didn't you, to act quickly and to do things quickly?
Yes, where it can, absolutely.
Yeah, absolutely. So if there hasn't been pay rises in the country for 10 years and the majority of people, you know, large numbers of people are suffering, you would want, surely, that's an emergency for the country, and it would seem right that a government should act as quickly as possible to right that wrong, wouldn't it? Like in your situation with FMD and Varroa mite, you wanted them to do that.
Yes,
and so in this situation, wouldn't you want them to act
haven't
quickly?
just received a 15% increase?
So, but you would want them to act, yeah, exactly.
Quickly, they acted quickly.
Well, the 15% increase took 2 years in a case that was run by unions. That's a long time. That's not quick, right? So, but they did act quickly. We did act quickly to support the case, unlike the previous government. Can I then take you to what are the social reforms that you think you support in this legislation? You said you opened with you support the social reforms. What are those social reforms that you think are good in this?
Well, I'll
Bill?
make a few comments, and hopefully Ben can as well, but certainly equal pay between the sexes, absolutely. I can't see any reason why we wouldn't be objecting to that. And discrimination of any way, I can't see why we won't, as a responsible employer, be objecting to any of that process and what's being introduced in this bill. Absolutely.
And you are supporters, aren't you, of the modern slavery protections that have been prosecuted previously?
As far as I know. Ben?
Yeah, well, we have no objection to the Modern Slavery Act, if that's
equal pay you think is good, the pay equity matters you think is good, is that right? Anything else that you think is good about this bill?
Yeah, gender equity, changes to the objects of the Act, the expert panels, prohibition. I mean, we'll go into more detail in written submissions. Obviously, we haven't had an opportunity to do that.
No, but you opened with it, so
I know.
For those people
yes.
following at home, I'm interested in what are these mostly things that don't really affect your industry, or so it's okay for other people, but it doesn't really affect you. Is that right?
I think that's...
I don't think that's the case.
Okay.
I mean, we presume that our membership are reasonable employers, and there's plenty of a diversity in the agricultural sector, although it is less diverse than some other employment sectors
Sure,
in
and so
Australia.
well, let's take that point. You definitely want to bring those people who are not doing the right thing up to doing the right thing, don't you?
Correct.
Right. So let's go to the point you were talking about, the fixed-term employees. That if you look at the explanatory memorandum, I think at paragraph 573, it definitely suggests, it definitely pulls out the fixed-term employees in fruit picking, for instance. It calls out fruit picking wouldn't be covered by these provisions.
I have to defer to you, Ben.
if that's what the XMEM says, then that's
does.
a relief to hear. I mean, the XMEM is not legislation itself, and it might be something that a judge or a commissioner would look at when they're trying to interpret it, but
Sure.
Be great to see that actually in the legislation.
So you're probably going to be incredibly relieved to hear too that yesterday there were government amendments agreed to in the House which have delayed the commencement of the fixed term provisions for 12 months.
Good. Good.
So were you aware of that?
I was not, no.
No, okay. So you're relieved to hear that?
Well, marginally. I mean, the reality
why
is...
don't they give you 12 months
can I
to
answer
do
the
all-
question, Senator?
Sure, go for it.
Marginally, but a delay in the implementation doesn't actually address the core issue with the potential issue with the legislation. And I think the fact that I'm not aware of it, it demonstrates how fast this stuff is being pushed through. If there'd been consultation in advance, then I would have known of it, and I would have been able to comment on
Sure.
it now, sensibly.
But don't you feel some relief that the government has listened to you and listened to other people, and they're giving you 12 months to consult. So to put your point of view, go out to your members. I used to be in an organisation that was a federation. I hear what you say about what you have to do, but now you're going to have 12 months to go out, talk to people and expand on how that may or may not affect. Talk to the Ag Minister, talk to government. Isn't that a good thing?
It's not a bad thing, but consultation
It's a
should
good
take...
thing, isn't it? What's not a bad thing?
Okay, it's a good thing. It's a
Exactly.
marginally good thing. But consultation should take place before the legislation comes into effect,
but-
not after the
but
fact.
Let me get back to
cart before the horse.
you agreed with me that sometimes there are emergency situations and difficulties, like in your own industry, where varroa mite and foot and mouth disease are on the doorstep, and sometimes you have to act urgently. You agreed with me that? If we're in a situation where, as we are, where for 10 years a whole bunch of people have not had pay rises and the system is broken, isn't that an emergency?
I think you're comparing apples with oranges, frankly.
Pears.
Yeah, I mean,
It's all the fruit industry. There you go. It's all the fruit industry, and it's the same thing. The difference, isn't it, is that varroa mite and FMD affect you directly, and things that are being put here you don't like. And so you are going to distinguish the emergency for workers. Isn't that the situation?
The concern was that varroa mite would have a devastating impact on the sector, so we wanted action there. The concern we have here is that these changes will have a devastating impact upon the sector. That's probably overstating it, to Senator Sheldon's point, but we are concerned about the impact upon the sector, which is why we don't want it rush through. It's apples with oranges as far as I'm concerned.
But doesn't, for ordinary Australians, the fact that they're finding it difficult to make ends meet, that they haven't had a pay rise for 10 years, is that not devastating for those individual people?
Didn't they have a pay rise of 15% 2 months ago?
In some
Aged
sectors,
care workers they fought for a pay rise in a case before the Fair Work Commission that took 2 years plus to get. And they haven't got it yet. And they haven't got it yet. They're not getting it to next year.
I mean, I guess the
Apart from
response...
that,
I got it.
I guess
So
the response
that's one
is this
sector.
change going to take immediate effect? Is it going to mean that workers will, the day that the bill is proclaimed, get a pay rise? No, it's going to take a long time. That's built into the system, and in some ways it might take it longer because enterprise bargaining is going to be much more complicated, in my view, in my suspicion, under these arrangements, where you have to consider the interests of not just one employer and one group of employees, you have to consider the interests of a whole bunch of people. It's going to take much longer.
well, let me put to you this. There were concerns raised earlier in the inquiry about supermarket suppliers, such as farmers, being brought into the single interest multi-employer agreement with the supermarket, even if their own workers did not want to do so. Some of those concerns were raised. There were amendments introduced requiring the majority of agreement of each employer's workforce. So now no business can be brought into the single bargaining until a majority of their own workers work to do so. Do you support that amendment?
Yes.
So, I'll leave it at that.
Sorry, I just...
Does it go far enough to...
Perhaps my misunderstanding, or perhaps your misunderstanding, is it's not the direct consequences that are affecting farmers themselves that this bill is. It is always the consequential effect of what the supply and processing sector may get roped into. We want to digest and work out exactly what the implications are in terms of cost. And to remind you that an increase in production costs of 30% is a cut in pay as well, in terms of a farmer that's looking at perhaps unviable cropping programs next year.
That's all my questions.
Senator Payman.
Thank you, Chair. My question is on, actually, I'd like to ask about one of the reforms that hasn't been widely discussed, but that is particularly relevant to your industry, and that is the provision of the bill which will prohibit employers from advertising jobs with pay rates that are below the legal minimum. Does the NFF support that?
Yes.
Yes.
Okay. And to go on to some of your recent public comments about multi-employer bargaining, you've reportedly made some outlandish comments about these reforms supposedly crippling supply chains and creating food shortages. Do you have any evidence or independent experts, data modelling or overseas examples to support that claim?
We don't. I mean, we can see what's happened in the past, and we made reference to that, I think, extensively this morning as evidence of what the future might hold. But, I mean, I can come back to my point, which is we haven't been given the time. How could we go out and get an academic report about the consequences of this bill when we've only seen it 2 weeks ago? I mean, it's just not realistic.
Can you just do a follow-up point? Mr. Rogers, you're addressing allegations of things that happened, I gather, 20 or 30 or 40 years ago. It's a very different world, isn't it? And,
not entirely.
wouldn't you
And,
suggest?
I'm also-
wouldn't you suggest that that there is a multitude of research out there regarding the issues that you're asserting about that period? So, you know, why aren't you relying on that research, or does it just simply not exist?
I'm not aware of that research,
That's
Senator
right.
Sheldon, but yeah. I mean, we're talking about potential consequences, we're talking about a lack of consultation and the fact that we haven't been able to reach a conclusion on these points.
My apologies, Senator Payman, I took your...
No, that's okay. Thank you. So I'm asking that because we've had numerous academics and others appear at this inquiry now, pointing to other countries where multi-employer bargaining is common and has delivered better wage and employment outcomes without widespread industrial action. And on the other hand, we've had over-the-top rhetoric from some employee groups about the sky falling in, but with no actual evidence to support it. Do you have anything to add to that?
I mean, well, it's difficult to comment on academic reports that I haven't seen, but my understanding is that there are conflicting reports. There are academics who say just the opposite to that. And again, I think you might be comparing apples with oranges when you're saying that the multi-employer bargaining in other countries has not had a disastrous impact, therefore it won't happen here, because there are different industrial relations systems, there's a different history, there's a different social expectation. It's just not the same context. Now, I'm not saying that wouldn't be useful and you wouldn't be guided and influenced in your thinking by what's happened overseas. I'm not saying it's completely irrelevant, but to say that it hasn't happened overseas, ergo it won't happen here, I don't think it necessarily follows.
I don't have anything else to say, Chair.
May I have a follow-up question?
If you have a follow-up question, by all certain...
I just want to,
and then we'll
I think
move
we're...
on to the next witness.
Yeah, no worries. I think we're missing the big picture here. I'm extremely worried about the government of the day selling these wages when the problem here is on supply chains. When you are looking at the price of fuel and energy, that has an effect all the way down the supply chain. Doesn't mean your fruit and vegetables will go up and all the rest. So where do you think this is actually going to fix the problem? Because quite frankly, I don't understand when you have those two big things and if there's going to be more strike action, how that is going to help in the future.
Senator, I have to agree with you. It's the risk is that we're poking fuel onto
Yep.
the fire. So absolutely, we're just
you.
extremely nervous about the consequences.
Thank you.
Can I just ask one, because we talked about cultural change you raised that in one of your answers, Mr. Rogers. It sort of goes to the heart. Do you expect that there's all of a sudden that farm workers are going to have multi-employer bargaining where bargaining doesn't exist?
I mean, I think we've made the point that our most pressing concern is around the supply chains. So my point is this, that a number of those workers are both migrant workers, Australian workers,
that have been here for many generations. Some, I'm sure, have been here, some of our First Nations peoples. So what makes those people different from other industries? Because it goes to the heart of this issue that all of a sudden there's a hysteria being built that workers in all industries, like Australians and migrant workers that work in the agricultural industry, all of a sudden are going to have industry-wide strikes. Like, it's just sort of, isn't it quite ludicrous?
Well, I don't think we were making, if we've been making that impression to you, I think that's a misnomer. It's never been a concern about what might happen on farm. It's always, as I've
All those
repeated.
same, sorry, Mr. York, but I'm sorry, I was making the point that your point is, I'm taking your point at face value, the point you just made then. I'm saying those same workers are working in industries right across the country. Similar workers are working right across the country in different aspects, different skill sets, same level skill sets in very different industries right around the country. Why would those workers be all of a sudden different and all of a sudden going out and strike? Because on your logic, that should be happening in every industry. I'm saying your logic, Mr. Rogers' logic, that's going to be happening everywhere. This hysteria that all of a sudden that... Because in actual fact, every piece of evidence internationally on multi-employer bargaining demonstrates that industry gets together, they get together with their workforce, they have proper systems to turn around and negotiate, they have proper systems to turn around and actually reach settlements. They do spend more time on productivity, more time on engaging, training and skilling, and particularly industries that are that are price takers means that they can actually go and put to the price makers, here's what we think is a base standards that we should have to improve our industry. And those sorts of things, because I respect the agriculture industry and many farmers, because I've had my battles in my life, and I still have them with major retailers about what happens in supply chains. Where industries can come together, where they want to pay their workers more pay, make them more productive. There is a need for actually the capacity for those workers across that sector to come together and cooperatively in multi-employer agreements to find those sorts of answers when they're dealing with these very powerful companies right at the top of the supply chain. The same ones that you deal with.
A perfectly rational argument. We just need time to digest whether this mechanism is going to be the effect and that consequentially has the effect that you're proposing. We just do not have enough confidence to digest that, yes, you're right, it's nothing to worry about. However, all of those processes, if you can demonstrate that there's productivity that's coming through that multi-enterprise bargaining process, then that's great. But we're not seeing that the productivity benefits are there as a given. So we need time to digest it.
And just on the principle of that cultural question, every piece of evidence of multi-employer bargaining, in actual fact, the European Union has now extended some of their multi-employer bargaining rights in Europe. They've just announced it in the last number of days. And we're behind the time. We're behind the time, and the workers in this country can't wait any longer, and quite frankly, good employers can't wait any longer because they're being bargained against by employers that are ripping off their workers or poorly paying them. And I'm not making aspersions against your operation, Mr. York. I personally don't know it, and I'm not going to make any observations whatsoever. But that is what's happening. This is a multi-employer bargaining is a principle of cultural change. This is the critical thing about getting wages moving. It's a substantive, important piece of opportunity to get the country and those wages moving across the country. And every piece of evidence across multi-employer bargaining is telling us that this works. So, it's how long do people have to wait for their wages to go up?
Perhaps we're getting a bit distracted, but I'm very confident that what happens in Europe cannot easily be duplicated and presumed to be able to be applicable across the board in Australia. I would only make the point that agriculture in the European Common Market is subsidised by the public purse to the tune of about 30%. There is no such subsidy in existence in Australia. So in terms of being able to accommodate arrangements across the supply chain, it's going to be a lot easier to do that in the European context than it is in Australia.
Well, if I can reassure you, it's countries across the world, and there's 19 OECD countries that are doing it. So it's not only Europe. My point was Europe is just a Europe-wide decisions were just been recently proposed and agreed to be put into their parliament. So, but thank you for your time. I have no further questions, and the answers you've given us have been helpful to us. Will help us with our deliberations in our final report, and have a very good still morning. Very good morning. Thank you.
Thank you very much.
Thanks for feeding Australia.
Well, the workers feed Australians, yes, that's right, along with their employers.
Yes, and well, that's the industry, correct.
That's right, absolutely.
We've got to stop at 11, don't we?
Now welcome via video conference representatives from the Centre for Future Work. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today? Oh, we can't hear you, Dr. Stanford.
Apologies. I'm Dr. Jim Stanford, economist and director of the Centre for Future Work.
Thank you.
Dr. Fiona McDonald, Policy Director for Industrial and Social Issues at the Centre for Future Work.
Thank you. I now invite you to make a short opening statement. In the conclusion of any remarks, I'll invite members of the committee to ask questions. If you're not speaking, if you could mute your machinery. There you go. Over to you, to Dr. Stanford.
Thank you, Senator. Thank you to the committee for the opportunity to meet with you. The Centre for Future Work is a Labour Economics Research Institute. We work under the umbrella of the Australia Institute, the major research institute based in Canberra. And I'm joined by Dr. Fiona McDonald. She's our Policy Director for Industrial and Social Issues. We have lodged a written submission with your inquiry today. Touches on many aspects of the proposed legislation, but as a labor economics think tank, I will acknowledge that our expertise does not cover all of the topics that are raised in that very important piece of legislation. Let me just very quickly list the topics that we addressed in our written submission. We provide summary evidence of the abysmal performance of Australian wage growth over the past decade. Uniquely bad by historical standards, the worst wage growth in the post-war era, and by international standards. Australian wage growth in both nominal and real terms has been among the worst of any OECD countries. And that wage growth was experienced regardless of whether the unemployment rate was high or low. It also bears no relation, we show, to the rate of productivity growth. The traditional market determinants of wages cannot explain why wages have performed so badly at the expense of working households, consumer demand, household financial stability, and macroeconomic performance. So this crisis in Australian wages requires an institutional and policy response. And in our judgment, this bill is a good step in that direction to create new regulations and institutional arrangements that will support the growth of wages. And those significant and enforceable responses are going to be much more promising than waiting for market forces to solve the problem, because we have been waiting for a long time and we will continue waiting for a long time. With respect to the previous witnesses, we also shouldn't wait for a process of bottom-up cultural change in the minds of employers to fix this problem. That isn't going to happen. We need strong regulations, including strong regulations to rebuild collective bargaining in Australia. We noted in our submission a very specific and strong correlation between the weakness of wage growth over the last decade and the rapid collapse of collective bargaining coverage in Australia's labour market. The number of workers covered by a current federally registered enterprise agreement has fallen by about half in Australia since 2013, down to just 12%, and less than that in the private sector. The correlation between the collapse of bargaining and the weakness in wages is very strong since 2010. Clearly, the erosion of collective bargaining is a major causal factor in explaining what's happened with weak wages. The decline in coverage accounts for over half of the change in wage growth in this period. And we show that each 1 percentage point drop in the coverage of the collective bargaining system translates into a 0.15% decline in the rate of wage growth. Very strong correlation there. The multi-employer bargaining reforms contemplated in this legislation, including the supported and single interest streams in particular, we would judge as a cautious and incremental step, together with other measures in the bill, to try to rebuild collective bargaining coverage in Australia. We do note that both the original bill and now amendments to the bill preserve many restrictions on the application of multi-employer bargaining, which in our judgment may end up frustrating the goal of multi-employer bargaining becoming a more common feature in Australia's industrial relations regime. At any rate, this is clearly a modest and incremental shift in how multi-employer bargaining is handled in the Fair Work Act, and in our judgment, not remotely justifying the extreme and fear-mongering claims of critics of the legislation. We review international evidence about multi-employer bargaining, and it's strongly correlated with the high levels of collective bargaining coverage. We do think that if multi-employer bargaining does become more common in Australia, that will contribute to a rebound in collective bargaining coverage and have significant value in lifting wage growth. Our submission does also mention other issues in the bill, including the new limitations on employer terminations of enterprise agreements that have expired while they're still being renegotiated. In our judgment, that practice has been an important factor in the erosion of collective bargaining coverage. And as an example, our submission includes quantitative evidence from our analysis of one instance of this strategy by employers, which was the effort by Qantas, the airline, to apply for unilateral termination of enterprise agreements covering its international cabin crew. And we quantified the losses that those staff members would have received if the agreement had been terminated, and if those workers had then been placed back on the Modern Award. Huge losses, life-transforming losses in wages in any given year, 25 to 70% cuts in wages, losses of hundreds of thousands of dollars of lifetime income, and over $100,000 in superannuation. So it's little wonder that those workers were coerced into accepting a very unfavorable agreement from Qantas after that threat was made. And we strongly support this legislation's efforts to close off that very aggressive tactic. We also address the initiatives in the legislation that would strengthen gender equality, including particularly parts 4 through 9 of the legislation, embedding gender equality as an object in the Fair Work Act and as an objective of the Modern Awards and the minimum wage, the stronger equal remuneration provisions, and the creation of expert panels. So on sum, this legislation is a wide-reaching, multidimensional effort to address a crisis in wage determination in Australia that has dramatically undermined household standards of living, our macroeconomic performance, and our social stability. And as a step in the right direction, we see this as very positive. We'll leave it at that, Senators. I look forward to your questions, and thank you again for having us.
Thank you. Senator Barbara Pocock.
Thank you, and thank you for your research and evidence and being here. I have a few questions. Firstly, will the bill before us deliver? Will it work effectively to lift pay for workers, not just in the low paid stream, but who are outside the bargaining system generally? I'm thinking of my own state, which I think your figure of bargaining was about 14% across the country at the moment. In South Australia, it's 4%. So can this work?
Well, Senator, this is the multi-employer stream of this legislation is one of many features in the legislation. I think taken as their whole, the overall package is positive and heading in the right direction. It is not going to single-handedly solve the problem, that is for sure. And the multi-employer provisions in particular still have very significant restrictions on them. One that gives us great concern is the idea that an employer who has an enterprise agreement with its current workforce would automatically be excluded, at least for some period of time, from the single interest multi-employer stream. Part of the problem, of course, is that too many workplaces don't have enterprise agreements, period. But another part of the problem is that some of those enterprise agreements are very low quality. So merely having an enterprise agreement isn't proof that enterprise agreements and the enterprise-based system is working. So that's one example of, I think, a restriction on how the multi-employer stream is being contemplated here. And I know that there's still a process of refinement and amendments to this legislation, but we would want to stress that for the multi-employer streams to work, they do have to apply to the broadest possible segment of the labor force, including some firms which have enterprise agreements today, but which are not very potent or successful enterprise agreements in actually lifting wages and conditions. So I think it can work, but this is not a magic bullet, this legislation, and I think we'll still have more work to do when it's done.
I wonder if you could comment on the industrial action elements of this bill and their consequences. We've heard some quite alarmist, I consider them alarmist given the changes in our world since 30 or 40 years ago, but there have been concerns that we'll see sudden spikes in industrial action of the kind that might have shown up in the statistics 30 and 40 years ago. We're in a different world now. I wonder if you could comment on, and also comment on the provisions in the bill and how they change the capacity for industrial action.
Well, the overwhelming empirical fact is that industrial action hardly occurs at all anymore. The frequency of industrial action measured by days lost per, say, 1,000 workers per year, that's a common way to measure it, has declined by over 95% since the 1970s. And I know that many of the responses to this legislation are hearkening back to somehow a time machine that we're going to enter and end up back in the 1970s. And that just isn't realistic at all, both because of the decline in enterprise bargaining period. You don't have protected industrial action if you don't have bargaining in place, and the vast majority of workers don't have it. But also because of how the economy has changed and how bargaining itself has become a more sophisticated and data-based process. So in Australia, like other countries around the world, bargaining does not imply strikes or lockouts. And frankly, we've had a big increase in lockouts in recent years, not strikes in Australia. So I would say that the continued restrictiveness of the Fair Work Act, even after these reforms, is going to very much limit the incidence of industrial reaction. But the idea that you should somehow prohibit industrial action, period, in whether it's in a multi-employer stream or in any other aspect of industrial relations, is abhorrent, frankly. First of all, it's an internationally recognized human right that workers have the right to come together and withdraw their labor collectively. Secondly, if there isn't some kind of ability to impose a cost of disagreement on the other side, and this is true for employers just as much as it is for workers, then bargaining becomes a dance with no obvious way to settle it at the end. There are some cases, of course, emergency services and other essential services where industrial action is generally not prohibited, but in those cases, you have to have some kind of binding dispute settlement resolution mechanism in order to ensure that a fair agreement is reached. If all you do is say to workers, you can talk to the employer and that's it, then bargaining is not going to produce the gains that we're hoping for.
Thanks, Dr. Sanford.
Senator Lambie.
Do you see, what are the unintended, you've obviously had more time than what we certainly have to go through the bill. What sort of unintended consequences have you picked up through the whole bill, everything? I'm not even going to go from part to part. Is there any unintended consequences that you have picked up from the bill itself?
Fiona, do you want to mention any if come to you, perhaps?
I think some of the unintended consequences, well, it's hard to know if they're unintended, I think, going to what Dr. Stanford was just saying about industrial action, in some ways it's actually going to be harder. There are more obstacles to industrial action than there were before. I think in an attempt to allay concerns about widespread industrial action, I think that the limits around the multi-employer bargaining in the single enterprise stream and the processes that unions would have to go through actually are going to make it extremely difficult for much bargaining to take place at all through that stream. So I think it is a step in the right direction in terms of recognising the need for multi-employer bargaining, but it's still really difficult. And I know my knowledge is strongest in relation to how the low-paid bargaining stream has worked in the past. And while the new stream opens up that through widening access in an attempting to make it easier to access, I'm not sure that it will really, it could go a lot further to ensure that the low paid bargaining stream really does do what it intends to do and assists the workers that it's been designed to assist. So I think I'm not sure if that's an unintended consequence, in that it just doesn't, it is a step forward, but whether it actually fixes all the problems that were there, I'm not sure that it does. And Senator Lambie, I'm speaking from the point of view of my particular knowledge. My knowledge is around the low paid bargaining stream, and it's also around the gender equality and secure work provisions. And I don't think that there are many unintended consequences in those at all.
Yeah, that's okay. I don't think most of us don't have any problems with those. That's not a problem. There's just 3 or 4 things on the table. My other thing that I'm hearing a lot of, and is about the Fair Work Commission. So when industrial action has been taken in the past, some people can do this really quickly, but they're taking months and months and months because of the complexity of the Fair Work, because of the Fair Work Act. The complexity of that's actually slowed things down incredibly over time, because there is so much to it. Basically, the Fair Work is going line to line to line to line to line to make sure they're getting it right. I haven't heard any academics talking about this any of you academics talking about this. Do you know if anyone's actually looking into it? Because that seems to be a lot of people saying we're making agreements. It's taking months to get them ticked off. From Fair Work itself. Have you heard anything about that from the Fair Work Commission at all? Have you looked into that? I would actually really like it if somebody would look into that. It would be very valuable if a lot of these agreements have been made and they've been done pretty quickly, and it's taking us up here so long to tick them off. But I don't think anyone's done any studies on that. Do you know anything about that at all?
Gee.
Sorry.
The Fair Work Commission has heard that the delays in approval of enterprise agreements were unduly long. They do track the average and median times that it takes for them to process and approve them. The ones that are the hardest are the ones where there are undertakings attached to make sure that the employer hasn't used the enterprise agreement as a tool to basically do an end run around some of the minimum standards in the modern award or the national employment standards. So those ones with undertakings take longer, but the way to solve that problem is to just make sure that the enterprise agreement does what it's supposed to do, which is lift standards, not trade off one thing against another. The Fair Work Commission has...
Do you believe it's doing that? Do you believe this bill will do that?
Yes, this bill has some important changes in how the Better Off Overall test would be applied and how enterprise agreements would be approved. So even without this bill, the Fair Work Commission has made significant progress in accelerating the approval process. Their data confirms that. But this bill will have additional provisions that simplify the application of that test and other administrative hurdles that you go through. And I'm optimistic that it will lead to measurable increases in the speed with which enterprise agreements are approved. And I think that will be one of many features in this bill, including the terminations aspect that we talked about, things like the small claims avenue for resolving disputes of enterprise agreements that are in place, and other changes that, taken as a whole, in a kind of composite way, significantly stabilize and strengthen the whole apparatus of collective bargaining in Australia, which is going to be very important if we're going to turn around the stagnation in wages that we've seen in the last decade.
Could I just add to that? I think, that goes to the heart of the need for collective bargaining at the level beyond the single enterprise. With single enterprise bargaining.
We're about to just go to 11 o'clock, which we'll have a minute's silence. If you'd like to join us, that would be appreciated. So if we could stand. If we suspend for the next minute. Thank you. Thank you. Well, now back on broadcasting. Thank you, and thanks everybody. It's important mark of respect for our servicemen and women, and for all those that have served in the past and are serving now. And thank you for also showing respect for that as well. So back to you, Dr. McDonald. I think Dr. Stanford or Dr. McDonald.
Thank you, Senator Sheldon. I was just saying, I think it goes to the context why the unbalanced nature of the single enterprise bargaining system has led to bargaining around very minimal wage increases, trading off conditions. And that is probably, part of the broader context that requires the Fair Work Commission to spend so much time examining agreements, because it has been about assessing whether the boot has been undermined, and in that sense, it's incredibly important. These changes should lead to some efficiency if they can prevent that happening.
I've heard from, thank you so much for that. I've heard from RMIT this morning. I would like to ask you some questions about the universities, if that's okay, because we are a bit concerned about, especially the split with the Big Eight, and then we have the rural and regional areas, and usually the rural and regional areas, universities end up worse off. So I just wanted to say universities are often receive 3 to 5 year grants of funding for research, and community legal centres and other non-government organisations also receive short-term grants to carry out their important work, and the Indigenous community, they have a lot of these, in supporting the most vulnerable in our community. Do you have any concerns about the proposed prohibition on fixed-term contracts and how this would affect the work of such organisations? We are terribly worried about the grant system and how it runs, how it stops, waiting for more grant funding. We've seen, especially when it comes to grant funding, especially big ones with the Indigenous communities out there, that they end up losing employers over the next 6 months because they don't know if their grants will get ticked off again. They go looking for other jobs. That's already a significant issue out there. So do you see, do you have anything you'd like to add to that?
I've got a couple of things I'd like to add to that. In the university context, the soft funding of grants is one issue, and I think there is a great deal of capacity within the universities to change the way they deal with that. Often the staff on soft grants are the staff who are doing the most valued staff in many ways, the staff who are actually producing the outcomes that the university's measured on in terms of its research performance. The other side of that is that there's hard funding, there's ongoing funding. We've seen casualisation of teaching staff who are ongoing. There's an ongoing requirement for them, and what's the response to criticisms of casualisation has now been to use fixed-term contracts. Now, those are for ongoing requirements, and the ways in which those positions are structured could readily be accommodated through ongoing positions. I'm not so sure that there's an issue of competition around the regional and other universities. I think the Sandstone universities are kind of, the group of 8 are based in very different regions. Mainly in major cities, but they're I know you have one in your state, and I'm not sure what that issue is there. In relation to community legal centres and organisations like that, that has been a really difficult problem, and I know that a lot of state governments have put their heads to thinking about that one, and there is capacity within the way that states fund some of those organisations, so that I don't think that those concerns, the answers to some of those concerns lie in the industrial relations system. I think they rely in the funding bodies needing to actually take those on in some instances. And I think a broader multi-employer bargaining actually gives those sectors, the university sector and the community sector, a better chance to actually tackle some of those issues with the funders.
Okay, thank you. Thank you. Could the proposed prohibition on fixed-term contracts have the effect of preventing these organisations hiring employees on fixed-term contracts because they can't afford to move these staff onto full-time contracts?
I'm sorry, Senator Lambie, I didn't...
Sorry.
You mean could it prevent them employing people at all?
Yes, especially in the rural and regional areas. Is that going to have any unintended consequences?
Well, I think I would not think so. I think there's provision if there's absolutely no capacity for an organisation to
Will it have unintended consequences of it's them having to rejig their universities in those rural and regional areas to actually be able to offer the courses that they're offering now? Will it reduce the courses, do you think, if that was to happen? If they're going to have to pay full-time instead of the other way that they're doing it?
No, I can't see that it would happen, no.
Okay. Thank you. Thank you, Chair.
Senator David Pocock.
Thank you, Chair. Thanks for your time this morning, and thank you for all the great work you do. I was just interested, I hadn't realised that you'd done a submission, so I don't actually have that many questions, but I was interested why your submission only was put in this morning.
Well, our apologies, Senator, that we couldn't get it in faster. The timeline for this process was ambitious, and we worked we worked to the timeline and submitted it in time for the deadline. So I apologize that you don't have it earlier.
Okay. No, I understand it. It is a tight timeline. Does this submission take into account the 150 or so amendments that were passed yesterday? It does?
Senator, as I mentioned at the outset, we're a labor economics think tank, so we have expertise in a certain number of areas, but not covering the full bill. We have looked at the amendments as far as they impact some of what we spoke about in the submission, but we have not attempted to cover either the whole bill or the full range of the amendments. We have tried to focus on the aspects of the bill and the amendments that are within our area of expertise.
Okay, thank you. I just have a few questions I'd be keen to get your thoughts on. There's been talk about an aspect of the bill where unions have to approve agreements, and I'm wondering whether in your reading, if that applies to just the multi-enterprise streams or also the single interest stream.
Do you mean unions have to approve agreements going out to a vote?
For them to, for agreements to be finalised, my understanding is if unions aren't happy, they can. I guess it's been talked about the union veto, where they can say no, we don't approve of this agreement. I'm just wondering if that also applies to the single interest, or is it just for the multi-enterprise streams?
We would have to look at that in a bit more detail. I think, as I understood it, Senator, it is about a question about when an agreement is put out to a vote, and both the union and the employer have the opportunity to say, we don't want it to go to a vote yet. And the idea there is to facilitate negotiations to try and reach an agreement before it goes to a vote. What happens in practice is that oftentimes in the course of negotiations, an employer will want to put the agreement out to a vote of the members as a way of undermining the bargaining position that the union is trying to advance at the bargaining table. And we've seen that happen many times, and it does frustrate the negotiations because it disrupts the opportunity to maintain the rapport and the relationship between the two sides at the bargaining table when the employer tries to go around the union and put a matter to the workers directly. Now, usually there would be a safety valve or a final option to put something to a vote, but as a routine practice, this is not conducive to effective industrial relations.
Thank you, Mr. Stanford. I was interested in your reading if that also applies to the single interest, the single enterprise stream. But you can take it on notice and have a look.
We could take that one on notice and investigate that and send you a response.
One of the other...
Senator,
yes.
can I just clarify? Are you wanting to know whether it applies to the single interest, multi-enterprise bargaining stream or single enterprise bargaining?
Either, if you can clarify.
Please.
And my other question I was keen to clarify from your reading of the bill is what happens in instances where there are two different unions involved? I know of an instance with a university where one of the unions had a glowing endorsement for their EBA, and the other union said, "No, this isn't good enough." Under this bill, the union that disapproves, they could potentially hold it up.
Sorry, can I just jump in there? I was at the union that's got the most members.
I don't think it doesn't mention membership.
There is a provision in the single enterprise bargaining, single interest, multi-employer bargaining stream for the Fair Work Commission to consider whether the number of bargaining representatives is manageable. And I think if there was a major conflict, there were different groups of employees in any instance that would be considered at the beginning of the process. But,
Okay.
I mean, I'm not sure that that fully answers your question or that I'm able to.
Okay, no problem. If I can just move on to universities, clearly casualisation of teaching staff is an issue in the sector, and then they're grappling with that, and this bill aims to address that. I'm interested in how this bill deals with research positions that are tied to research grant funding.
As I was saying to in response to Senator Lambie's question, what we see is researchers put on short-term contracts tied to specific research grants, and that is extremely problematic. I think those researchers, as I'm saying, are often the researchers that the university relies on to meet its performance indicators. For example, I was on one of those grants as a recipient of an ARC discovery grant, a early career researcher discovery grant, and those grants are extremely attractive to universities and give them lots and lots of brownie points in terms of their performance. And there's a lot of rhetoric about highly valuing the staff that they put on those grants. I don't think there are a lot of barriers to universities restructuring some of their research funding to make those ongoing positions. There's plenty of capacity to do that within universities, is my understanding.
But would it allow universities, if they do have, say a 2 or 3 year grant where they need to bring in an expert in that field, would they be able to do that, or how does?
Yep, they would be able to do that. They would, if they believe they're bringing in an expert in that field, they've got capacity to bring that expert in on a longer term than position than the short term grant funding that.
Okay, no,
I'm saying I think there's a capacity there to engage those researchers that are currently coming in on short-term positions because they're tied to grant funding, to engage them on a longer-term basis.
Okay.
The universities have that ability now.
They have that ability now, but with if this bill passes as is, would they have the ability to have someone on a 2 or 3 year research grant contract, and then they get another grant and they offer them another 2 or 3 years? Is that possible?
Well, I'm suggesting that if they have somebody who's tied to a 3-year grant, that they should be employing them on longer than 3 years in the first place. Because those positions are extremely important to the university in the longer term. They're choosing to tie them to the short-term grant funding, and that's a choice that the universities make, while they're relying on that research capability in the longer term for the university's reputation and performance, yet they're choosing to tie the positions to the grant funding.
Okay, yeah, I hear what you're saying. I guess from a university's perspective, and I think a lot of the more regional ones that aren't the big sandstone unis, if you don't have that certainty of funding, then it throws up a whole bunch of issues.
And there are issues around research funding, but I don't think
that's not addressed in this bill, though. Yeah,
and that is not part of this bill. And those are issues that need to be addressed within the research funding framework and the university management.
Thank you. Just finally, to stay on universities, it's my understanding that there's a bunch of universities that offer PhD candidates casual employment to sort of supplement their stipend, which we know is not really adequate anymore. Would this bill affect that at all?
I don't think so. There are always short-term opportunities within universities. Too many, in my view, where there are ongoing requirements. I think the the evidence shows that when you look at the contracts on which most staff are, but there will still be plenty of very short-term opportunities.
So if I've got a PhD candidate who's studying ring-tailed possums or something for 3 years, and I say to them, I know your stipend isn't enough, so over the next 3 years, I'm going to do whatever I can to just keep giving you some casual work as it comes up, that would still be able to continue over those 3 years?
I would certainly think so. I would think if there was an identified, if within a school or a department there had been an identified need for ongoing part-time researchers for a period of 3 years, there's capacity there to make those ongoing part-time positions, but there are always casual positions also.
Okay. Thank you very much. I will have a look at your submission over the next few days. Thanks for your time.
Thank you.
Thank you.
Senator Payman.
Thank you, Chair. Thank you for being here this morning and your contributions. Can you please outline what are the benefits to employers of engaging in bargaining?
Enterprise bargaining and multi-enterprise bargaining offer significant advantages to employers. It allows them to establish a template pattern of pay and conditions, compensation, and working conditions that apply across the workforce in an efficient way. It allows them to create a culture of fairness and transparency in their workplace so that everyone knows that they're being treated fairly under the terms of an agreement that everyone is aware of, rather than a situation where individual deals are arranged with individual employers. And in that context, frankly, there's advantages of a multi-employer or broader-based collective bargaining approach, because then you're establishing those same conditions potentially to apply across a broader population of businesses. So in that way, an individual firm can sign on to this multi-enterprise arrangement without worrying that it's going to be somehow priced out of the market relative to competitors that aren't following the same pattern. So in general, I think collective bargaining can be an efficient tool for businesses. The primary goal, of course, is to give workers some collective representation and collective bargaining power that otherwise they don't have. Without collective bargaining, the negotiating field is very much weighted in employers' favor. But even for employers, I think there are important benefits that arise from collective bargaining.
And so on that, is the current Australian bargaining system working to realise those benefits?
I don't think so, because the vast majority of workers are falling through the holes of the current system. So in the private sector, barely 1 in 10 workers are now covered by current enterprise agreement. Firms, many firms might think this is a great idea. Many employer bodies may say, well, this is good. I don't have to deal with the union. I don't have to negotiate. I can sign one-off contracts with individual workers. I can treat people differently, however suits me. But I think that kind of is a short-sighted approach to it. And for firms that are interested in developing a stable and satisfied workforce, addressing some of the recruitment and retention challenges that are out there today, I think that there are many benefits to collective bargaining. And countries in the world that have succeeded in innovation, research and development, mechanization, successful exports, countries like Germany, Korea, Japan, etc., welcome collective bargaining in those key sectors of the economy, and firms do very well with them by, in a way, being encouraged to treat their workers with more value and more respect.
Thank you. So if I've understood it correct, would you say that increasing wages will increase access to enterprise bargaining, creating a framework of sustainable and incremental wage increases, which is obviously tied to productivity.
I think that increasing collective bargaining will support the attainment of higher wages, sustainable, steady wage growth over time, not the stagnation that we've experienced in the last decade. The stagnation of nominal wages in Australia since about 2013 has now tipped over into very rapid declines in real wages because wages are growing slowly and now prices are growing much faster. So the real standard of living of Australian workers is falling, and this will have macroeconomic implications. It means a more precarious household financial stability, weaker consumer spending, and ultimately it destroys the relationship between wage growth and productivity growth, because if workers don't see any benefit from productivity, and they haven't in the last decade, they're going to stop caring about productivity, and they're not going to be committed to helping their firms succeed and helping technology and productivity advance.
Thank you so much. Chair.
Oh, thank you, Chair. I just have a, could you tell me how many academics you've had working on this bill over the past week?
We don't have any academics at our centre. We have a team of 3 staff. Myself, Fiona, and Greg Jericho, who's our policy director for labour markets. And none of us are professional academics. We're all trained academically, but we all work as policy researchers for the centre.
Oh, sorry. Yeah, I'm not having a go at you. Please don't get this wrong. I'm just trying to work out, has it taken all 3 of you since this bill come out to go through it and work on it?
No, we have Lily Rains, our fellow, has worked on one piece of it that she had already worked on. We all put in our time, particularly on things that we had already worked on. So me on the gender equality and Lily on the terminations and Jim on the broader area.
Have you seen...
We've not all by any means worked full-time on this, any of us. We've got lots and lots of other things we do.
Okay. Have you asked for assistance or gone on the outside of you 3 in relations to anybody that's an expert in IR law?
Well, Senator Fiona McDonald herself is an expert on IR law. She's not a lawyer, but she's an expert in industrial relations. That's why she's our director of policy for industrial and social issues. And with our small research team, we do what we can. We've drawn on a body of research that we've published over the last several years, but we state explicitly in the submission, and I mentioned it at the beginning of this appearance, we do not pretend to have covered everything in the bill, certainly not. We've drawn on our research and our expertise to address aspects of the bill that are relevant to stuff that we know, but we would not claim that we know everything.
Senator Lambie, I have relied on on distinguished Professor Anthony Forsyth and Professor Shay McChrystal's submission, which I think provides a really good overview, a detailed overview of what the multi-employer bargaining provisions do, and I think is actually an excellent reference point for anybody trying to understand these provisions. So,
thank you, Fiona. Thank you.
Good, thanks very much. So, again, thank you very much for your time. The evidence you've given will be helpful to the committee in its final deliberations for its final report. So we wish you both a very good morning, and we'll now suspend until for 10 minutes, just before, we'll come back just before 20 to 12. Thank you. We now welcome via video conference Associate Professor Meg Smith from the Western Sydney University. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Thank you, Chair. My name is Meg Smith and I appear today in a private capacity.
Good, thank you very much. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you, Chair. Thank you to the committee for the opportunity to appear this morning. I acknowledge in appearing before you that I'm on the lands of the Wallumattagal people of the Darug Nation. My comments and submission focused on the proposed amendments that most directly address gender equality, most particularly in the area of wages. So my submission, together with Dr. Michael Lyons, addresses changes to the objects of the Act, the equal remuneration provisions, the modern award provisions, the minimum wage provision, and the expert panel provisions.
Thank you.
The gender pay gap is a persistent feature of the Australian labour market. Wage gaps are evident in hourly, weekly, and annual wages. Addressing the gap has been slow. It does not reflect the educational attainment of Australian women. Regulation is important to women's wages, but there have been limitations in the equal remuneration provisions of the Fair Work Act and its predecessors. In the last 20 years, there has been only one successful application for equal remuneration orders, an outcome that reflects regulatory limitations. Similarly, there has been limited use of the capacity to vary awards on the basis of gender-based undervaluation. The amendments positively address a number of these issues through changes to the objects of the Act, the equal remuneration and modern award provisions. The Bill's provisions recognise undervaluation on the basis of gender. In my submission, I briefly note areas for further development and consideration by the committee, which are addressed more fully in my written submission. But in brief, they include 5 areas. The first one of which was that the reference to gender equity would be enhanced by reference to gender equality, but I understand that matter has been addressed. The second was that proposed amendments concerning the absence of a requirement for a male comparator in equal remuneration proceedings should more directly reflect the language of the explanatory memorandum. Third, in addressing equal remuneration and the variation of minimum rates in modern awards, the Fair Work Commission should be able to address the consequences of women's lower access to enterprise bargaining. 4, there should be explicit provision to assess gender equality in enterprise agreements. And 5th, the Commission's functions would be assisted by a gender equality principle. Thank you, Chair. That's my opening statement.
Good. Thank you. Thank you very much for that. I'll now go to, excuse me. Now go to Senator White.
Thanks very much. What are the limitations on achieving successful equal remuneration orders within the current Fair Work Act?
Thank you, Senator White, for the question. The limitations most recently have been that the Commission has made a requirement for a male comparator and a precondition for the granting of equal remuneration for an equal remuneration order. So an application on behalf of a female-dominated industry or occupational group of workers must demonstrate that equal remuneration for work of equal or comparable value, that objective is not met by explicit reference to a binary and gendered, and in this case, male comparator. I think this has limited the capacity of the Commission to assess quite simply whether the work is undervalued, whether the objective is not met simply by virtue of the fact that the work is undervalued on the basis of gender, and then to properly remedy that by affixing rates of pay that reflect the value of the work.
So how does the bill address these limitations?
I think the bill makes it clear that a comparator is not an evidentiary precondition. I have made a suggestion about how that language may be strengthened, but it also recognises explicitly that there may have been historical gender undervaluation of the work, and that in addressing whether an order should be granted, the Commission can have regard to that.
And why do you think multi-employer bargaining is important to closing the gender pay gap?
Well, I think just more generally, Senator, the women have had low access to enterprise bargaining per se, and so they have been reliant on the minimum wages that are in awards. There is evidence to suggest that some enterprise agreements do not provide for a significant increase in wages upon those minimum rates. And so if awards are to remain in the realm of a safety net of provision and of minimum rates, which has been the case for some time now, the capacity to bargain and the capacity to obtain increased wages by way of enterprise bargaining would arguably be improved by way of greater access to enterprise bargaining. And I also make that comment in light of the lack of success in low wage bargaining orders. So for a number of women, their rate of pay is the minimum award rate.
Yeah. So can I? We just had some discussion this morning about, the aged care work value case, and that is, which is different to an equal remuneration order. Are you able to explain what the differences, as you see them, are currently?
Certainly. So currently for an application for an equal remuneration order, and that's under Part 2.7 of the Act. And as the Commission has noted that a successful application in that case must demonstrate that the objective of equal remuneration is not met by reference to a male comparator. That section of the Act, however, is not confined to minimum rates of pay. So the Commission is not obliged to have explicit regard to the minimum wages objective in remedying any successful application in that regard. Now, the aged care case was different because this was an application to vary a modern award on work value grounds, and so it's varying the minimum rates in that award. It was made separately and on the basis that the minimum rates of pay did not reflect the value of the work and had been impacted by gender. But the Commission, in addressing that application and by way of its recent interim decision for a 15% increase, is of course only increasing the minimum rates of pay in that particular award from the prospective due date.
Thank you.
Senator Pocock.
Thank you, and thank you for your evidence and for your large body of research and experience on these issues. I wondered if you could just give us your opinion based on that experience on whether the bill and its provisions in relation to equal remuneration, the changes in the objects and so on, will be able to deliver a systemic lift in the pay rates of undervalued feminised occupations. Will it work?
Thank you, Senator Pocock, for your question. I think it's certainly a positive step. I think widening the object to gender equality is a positive amendment to the bill's provisions. I would like the Commission to have the capacity to be guided by a gender equality principle so that they can, it would assist their assessment in what constitutes undervaluation on the basis of gender. What does it, what might that look like in terms of characterisation of the work, the absence of appropriate skill descriptions, poorly developed classification, structures, the lack of recognition of particular skills. And there may, in terms of other sections of the Act, of course, there may be working time provisions that may also be relevant here. I think that would be a beneficial instrument to both the Commission and the parties, so that the consequences of gender-based undervaluation, some light can be shown upon, how do they express themselves in particular industrial instruments at present. I think that would be a useful matter. And I note with regard to the provisions concern the object of the Act, I think it would be a positive development, Senator Pocock, if it was clear that an assessment of gender equality may also form part of the Commission's approval of an enterprise agreement. While those provisions are, of course, subject to the objects of the Act, it's not explicitly noted in those provisions at present. So I would note that. And the additional matter I would note, and recognising the impediments to bargaining that have occurred in the past, there have been decisions in Queensland in the past where the Commission has recognised women's lower access to bargaining to ensure that the remedy in a gender equality matter could recognise that lower access to bargaining. I note those as additional points for consideration to achieving a systematic address of gender inequality.
Thank you for that answer, Dr. Smith. I'm wondering, just to make sure I understand this correctly, we have an object of now gender equality, not gender equity, which I totally endorse your support and that of other witnesses we've heard and has been moved and accepted in the bill as it stands as of yesterday, I think. But you are looking for stronger infrastructure within the bill to enable that object to be expressed. I just want to check, though, if such infrastructure is not built into the bill as it becomes an act, are there barriers to gender equality, or would a fulsome reading of that object by a properly skilled and informed commissioner prevent them from, for example, exercising judgment about whether equality is advanced through an enterprise agreement before them or any other matters that they're dealing with? I just want to make sure there's no barrier to it. I understand what you're doing, if I get it correctly, is providing explicit reinforcement.
Yes, that's. I'd characterise my comments under that matter. A fulsome reading of the objective would imply that in approving an enterprise agreement that there would be attention to the objects of the Act and consequently gender equality. It's not explicitly there at the moment, but it was more a safeguard. I would characterise my comment as Senator Pocock.
And we've heard yesterday, or this week I should say, it's been a blur, in estimates that there is a budget allocation for expanding commissioner positions to enact and bring to life these provisions. I understand there are 4 new commissioner positions that are being discussed or will be offered. Do you think that kind of infrastructure response is going to be able to meet the objects and the intention of the bill?
I think it would be beneficial. I think it's beneficial, Senator Pocock. I note also, of course, the ability to bring experts onto the panel and potentially research expertise by way of those appointments. But I also note the importance of the Commission having access to research that it may commission in this regard, and access to data that it may commission in this regard. So noting the provisions in the Act for a commission to initiate assessment of an equal remuneration order, for example, it would also be beneficial for some research capacity to support that infrastructure, as you've noted. Yeah.
And I'm wondering, building on that, what about, I talked to the ABS yesterday in estimates, they have no new allocations for review of how such a significant change might unfold. You know, it's a big change, why wouldn't we undertake some research to see how it works in all its different elements? What's your view about a point for review and for some research to analyse the outcomes if this bill is passed?
I think that would be advantageous, in particular, Senator, through some additional capacity for the employee earnings and hours survey, which at the moment is a biennial survey. It excludes consideration, as an example, of managerial hourly earnings. It has other restrictions, which and it's a lesser survey than once was, if I can make that point. I think that's a potentially a survey or an instrument that ABS utilise in addition to those that are assessing coverage of particular industrial instruments, where potentially with additional resources it could be utilised to support the review mechanism that you've noted in your question.
And that might go to the items in that particular ABS publication and its frequency.
Yes.
Thank
yes.
you. Thanks, Chair.
Good, thanks very much. Senator Lambie, you.
I don't have anything. Thank you, Ms. Smith. I don't have anything for you. Thank you.
Thank you, Senator. Thank you.
Senator Payman.
Thank you, Chair. It's just two short questions. How should the pay equity expert panel and the care and community sector expert panel operate to ensure that they contribute to closing the gender pay gap and lifting wages? I know you've spoken extensively on gender pay gap. You can choose to just speak on lifting wages.
Thank you, Senator, for the question. I think those panels, as I understand them, would be constituted around particular applications, whether they're clearly equal remuneration applications or applications for increases on the basis of work value in modern awards. So to a significant extent, the panels are convened to address applications to vary wage rates or other aspects of the relevant industrial instrument, potentially in the majority of cases a modern award. And I think the ability that an expert panel can bring is the ability to assess the research evidence to complement the expertise that's in the Commission, to also suggest potential areas of relevant research that may assist the panel's deliberation. In particular, I would note also the ability to understand the implications of gender-based undervaluation and how it may express itself in modern awards in particular, or other forms of industrial instruments. I would note in the community and care case also to address some of the disamenities of current working time provisions. Thank you, Senator.
Thank you. And finally, which are the measures within the Secure Jobs Better Pay Bill which will best enhance gender equity and job security?
In my view, potentially the measures are the amended objective of the Act to put gender equality as a primary objective, the changes to the equal remuneration provisions, and the changes to the modern award provisions that make it clear about for the capacity for the Commission to address applications that focus explicitly on the gender undervaluation of work.
Thank you. Thanks, Chair.
Senator White.
So how many successful equal remuneration orders have there been in the federal system currently?
One, Senator White, that was in the social and community services sector case by way of a two-stage decision of the Commission. So there's only been one, but I date that back. Also, the capacity for equal remuneration orders has been evident in federal legislation since 1993, introduced by the Industrial Relations Reform Act. So the capacity to issue orders has been evident since 1993. And in that time, there's been one successful application.
And do you know how long that case took to run?
Well, I know that the original application came before the then Fair Work Commission, I believe, between 2010 and 2011, but I stand to be corrected there, Senator, on that. And then with a final decision taking place towards the start of 2013, with wage increases phased in over multiple years. So the wage increase, it might have been
8 years.
8 years, yes. Yeah.
And in relation to the aged care case, so that's a work value case, which is
yes.
a different kettle of fish. How often are those sort of cases successful?
Well, I note in this, I answer that question, Senator, by reference, I guess, to the modern award provisions of the Act. So in the first instance, if we think of the Fair Work Act from 2019, award modernisation occurred broadly over 3 terms, phases. The first phase was simply converting, if you like, the 1,022 former federal and state awards into 122 modern awards. So the capacity for that case wasn't evident in that particular phase. The second was an assessment by the Commission of the transitional provisions to see whether the initial collapsing of industrial award-like instruments into 122 modern awards was working well. And again, there wasn't the capacity to address these types of applications there. And the fourth was a 4-year review of awards. And it was only by way of the Commission rejecting a case for an equal remuneration order and the reference that the work value provisions may be utilised for an application on work value grounds was that provision taken up. It's been utilised only in 2 decisions thus far. The aged care case we have spoken of, and in early childhood and care, but for teachers employed in this sector, not for other workers in that particular sector. And I note also that prior to the Fair Work Act, that the provisions concerning work value that had been evident in the Commission's wage fixing principles writ large, they may have, of course, been called different things, that the focus on work value was only on changes to work value, not on substantive assessment of work value. So I'm sorry, Senator, that was a long answer to your question.
But the point you're making is, and it wasn't a long answer, it was quite a short answer for a very difficult area, but the point you're making is that, can I paraphrase it, is that just because there's only been a couple of cases doesn't mean that there isn't significant work value cases that should be run, nor does that mean that there isn't equal remuneration orders that should be run as well. It's just the barriers that the Act, as it currently stands, and even the previous Acts. I mean, one case to be successful in equal remuneration since 1993. I think there's been about 27 run, and one is successful. That is a systemic problem that needs significant addressing, isn't it?
I would agree, and I would note that in the small number of cases where those matters are addressed, any remedy only applies from the prospective date. It doesn't address the historic undervaluation in wages terms of the work. It's a prospective address.
Well, and in the one successful case, back to 8 years phase-in of the pay rises. It didn't happen overnight. Thank you.
There was no further questions. I'd like to thank you, Professor Smith, for your evidence today. We're great deal of assistance to the committee in our deliberations and the preparation of our final report. I think I wish you a very good afternoon.
Thank you very much.
Thank you. Thank you, Chair. Thank you.
We'll now suspend until 1 o'clock. Good, thank you. I now welcome via video conference a representative from the Franchise Council of Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Thank you, Chair. My name's Mary Aldred. I'm the CEO of the Franchise Council of Australia.
Thank you, Ms Aldred. I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions.
Thank you, Senator Sheldon, and good afternoon, Senators. I'd like to begin by thanking the committee for the opportunity to present before you today. The Franchise Council of Australia is the peak industry body for the $172 billion Australian franchise sector. There are about 1,300 franchised networks across Australia, with an estimated 94,000 individual franchise outlets, employing just under 600,000 jobs. Importantly, the majority of franchisors and nearly every franchisee is a small business. So effectively, the FCA is a voice for just over 90,000 small businesses. We regularly engage with our members, and the message we've received recently is very clear. They are deeply worried. In the face of global uncertainty, small businesses seek economic leadership at a national level to build confidence and stability. This was recently underpinned by the Treasurer in his budget speech, where he said that, quote, "Our best defence against uncertainty around the world is responsible economic management at home." We could not agree more. Small businesses represent nearly 98% of businesses in Australia, and they are indisputably the engine room of our economy. 2 years of COVID-induced disruption has not only drained financial resources, but it's had a profound impact on the mental health and emotional well-being of small business owners. Any regulatory overreach now is a direct threat to the confidence and sustainability of businesses across Australia. The government's legislation proposes the most significant changes ever introduced to the Fair Work Act. In its current form, this legislation will have a widespread and detrimental impact on small businesses, which could result in staff reductions and business closures. The FCA is not the only concerned representative organisation. The BCA, ACCI, COSBOA, the Australian Industry Group, the Minerals Council and the National Farmers Federation all share a similar position. Understanding the legislation and its impact on small businesses is very low. A FCA litmus test that we did just a couple of days ago with our franchisee forum showed that just around 70% of respondents did not understand the proposed changes. Of those who felt that they did understand the reforms, nearly 60% were concerned about the legislation, particularly the multi-employer bargaining provisions. These figures reflect the low level of consultation undertaken ahead of introducing this legislation to Parliament. There are some worthy elements of the legislation that we support, notably the provisions prohibiting sexual harassment and introducing gender equity as an objective of the Fair Work Act. However, in its current form, the FCA cannot support parts of the legislation given the detrimental impact on small business and our broader economy, principally the multi-employer bargaining regime. This legislation opens the door to strikes at workplaces across the country, as long as businesses pass an extremely broad common interest test. widespread industrial action would have a devastating impact for many businesses and would undermine the security and sustainability of hundreds of thousands of jobs. This critique is shared by University of Adelaide law professor Andrew Stewart, who advised the Rudd government on the Fair Work Act, saying recently that multi-employer bargaining is, quote, not in a fit state to be passed, and that it's impossible to answer a single question about who it's meant to cover and what practical effect it will have. Beyond this, the FCA has made a submission last night which details our significant concerns around several additional parts of the legislation. Given the potential impacts of this legislation on our economy, employers and employees, the FCA's position is that the parliamentary process should not be rushed. We call on the government to delay consideration of this legislation by the parliament and embark on a more comprehensive consultation process with the business community. Failing that, the FCA requests the government increase the small business exemption threshold linked to the multi-employer bargaining regime from 15 to 100 employees. Small business owners are not adequately prepared or equipped to navigate a new complex industrial relations process. Take, for example, a franchisee like Dan, who has 5 stores which employ up to 70 staff. Some work full-time, some work part-time, and some are casual. Working long hours to keep his business going, Dan is a CFO, the marketing manager, the head of HR, the list goes on. Under this legislation, Dan could be compelled to bargain with other employers with no consideration of the unique challenges facing his business. This would add unnecessary burdens into his already complicated life. There are hundreds of thousands of Dans across Australia who will be in this exact situation if this legislation is passed without significant changes. In closing, the Australian economy faces serious challenges. Weighing it down with the most significant changes ever introduced to the Fair Work Act is the antithesis of responsible economic management and will hurt small businesses and jobs. Thank you very much. I'm happy to take questions.
Good, thank you. Senator Cash.
Thank you very much, Chair. Thank you, Ms Aldred, and thank you for your submission. At page 4 of your submission, in the final paragraph, you say, furthermore, the government's amendment, which outlines that an employer cannot put a proposed multi-enterprise agreement to a direct vote of their workforce without the relevant union's written approval, makes multi-employer bargaining more wieldy. Can I understand why you say that, please?
It really undermines the initial intention of the Fair Work Act and certainly principles brought into a modern and innovative economy which encourage enterprise bargaining between employees and employers. It stifles innovation and we don't feel that it's upholding democratic principles that underpin all of those other foundations.
You mentioned in your opening statement the fact that, and you referred to Dan, who may be compelled to bargain, even though the employer themselves does not want to, with other potential competitors. What is the impact of businesses if they are forced or compelled to bargain against competitors?
We're very concerned about this. So, for example, if Dan has a business that operates a lunch, breakfast, lunch and dinner business that has very specific rostering systems, supply chain processes, he may be compelled to bargain with another business that's not a 24/7 operation that only does lunch and dinner, has very different rostering systems, supply chains, and is a direct competitor of his, and that really undermines I think fundamental competition principles and would be really detrimental to Dan. And if that undermines the sustainability of Dan's business, ultimately that undermines the sustainability and security of his employees' jobs.
Could you just take me to how many of your members have applied to the Fair Work Commission for the single interest enterprise agreement as it currently stands?
I'd have to take that on notice, Senator. A lot of our members are in industry sectors like hospitality, retail, QSR, and so are on the award. Certainly as part of an overall review of the industrial relations system, we would think that a review of the award system is necessary. And certainly this moves away from enterprise agreement principles as well.
Were you consulted at any point by the department or the minister on this bill?
It's been a very rushed process with just this week, I think about over 130 amendments in one day, and then significant number of amendments a few days later. We've only just put in a submission yesterday, given that rushed consultation process. We did have a meeting with the Minister's office last week, which we appreciate, but other than that, there's been very limited consultation.
Again, you made a comment in your introductory remarks that this is regulatory overreach, it could have widespread detrimental impact, which could result in staff reductions and business closures. Given the bill is all about secure jobs, could you take me through why you say the bill could result in that?
We've done an extensive amount of consultation with our members, survey work, face-to-face meetings, and engagement on broader IR issues, but as well as just day-to-day business challenges with our members. And essentially they're coming back to us with 5 key issues. The first is crippling skills and labour shortages. The second is the cost of doing business, CPI increases, inflation, interest rate rises, commercial leasing challenges, single-use plastics bans in different states that they're having to get their heads around. There are a whole range of really significant business pressures that they are facing, and on top of that, after 2.5 years of grappling with COVID, with state government business restrictions, they are depleted emotionally and financially, and many of them just cannot bear the thought or the additional resources that they would be forced to invest with additional regulatory and compliance imposts on them that this bill would force.
In your submission, you express concern about the expanding capacity of the Fair Work Commission to arbitrate in bargaining disputes. Can you please explain how increased arbitration is a concern for your members?
There may be circumstances where that has a role to play, but certainly for our members, the majority of whom are small businesses, arbitration is costly. It's a very legalistic and complex process. Small businesses don't have in-house legal counsels or large compliance departments. They're often by themselves or with a very limited amount of resources. So being faced with this sort of process is really cumbersome, it's really costly, it's quite daunting for many of them, but it also takes away from the first principle, which should be for employers and employees to negotiate with one another, and that's diluted significantly through this process.
And in terms of the capacity of your smaller businesses or your smaller members, I mean, you've said, I think it was 1,300 members, 94,000 franchises, 600,000 employees. If they are compelled to bargain, do they have any experience in dealing with the intricacies, for example, of industrial and strike action?
No, many of them don't. Most of them don't. And I think, the survey that we conducted this week, where 70% of small businesses that we surveyed weren't even aware of this bill or the main tenets of it, is a great case in point to show that small businesses right now are just flat out keeping their head above water, of grappling with the day-to-day challenges that they're presented with following COVID, focusing on their road to recovery, focusing on a whole range of other red tape complications and obligations that they're faced with. And so they really are not set up or resourced to be able to deal with those situations that may be visited upon them by this bill.
And could you also tell me, and I've got one more question and then the call will go to another senator. In the event that they are compelled to bargain, and in particular given, and I will be exploring it with the department, at the moment, the limited guidance around what is a common interest. If they are compelled to bargain with people who are much bigger players, what capacity do they have to bargain? Will it even be bargaining for them?
It presents a significant power imbalance for a small business owner. The common interest test is so broad that it's difficult to understand how that will be defined beyond a particular geographic area or industry. There's scant detail on that. and small business owners that I have spoken to about this have really significant concerns about what that presents to their individual business, their employees, and how they would deal with that situation.
Thank you.
Thanks, Senator Pocock.
Thank you for being here and for your evidence. Do you support the supported bargaining stream?
That is one area that we're still working through the detail of, but certainly refer to ACCI and AIG's position on that.
So you're not sure?
Correct.
Don't workers, whether they're working for Dan, your example, or for someone, his competitor down the road, deserve a common standard of wages and conditions and a similar pay profile, a pay rise, for example?
Depends what industry sector they're in, on what kind of wage and condition that they're employed with. But as a starting point, if there's not a business there to employ someone, it's hard to guarantee security or sustainability of their job.
Seems a little one-sided in terms of your argument that we look after Dan, but we don't look after the workers who work in the industry down the road from Dan, or perhaps even for Dan's own employees. That's a comment.
Well, I
really.
think if Dan's forced to close his business, then that has a significantly detrimental impact on his employees as well.
And do you think businesses should always stay open, be able to stay open regardless of the level of wages they offer?
No, they should be compliant with their wage obligations, compliance obligations, whether they're on an award or through an enterprise agreement process.
And final question to you, how does enterprise agreement making stifle innovation? What evidence are you using for that claim?
If there are too many imposts or complexity added, which deter employers away from enterprise agreement making, that ultimately does not have a good impact on productivity, on innovation, on modernising workplaces.
That's an assertion, that's not evidence. Do you have any evidence for that proposition? Because it's a strong proposition that even making agreements stifles innovation in a whole set of industries covered by franchisees.
That's my response to your question, based on conversations on input from our small business members through a range of forums.
Thanks for your evidence. Thanks, Chair.
Good, thanks. I just want to clarify something. I understand that a committee chaired by former Liberal Minister Michael Sukkar had a majority of coalition members, and on top of that, the report was a bipartisan report, Parliamentary Joint Committee on Corporations and Financial Services. And to quote from the executive summary of that bipartisan report, the FCA, your organisation, does not appear to provide a balanced representation of franchisor and franchisee views, and it is likely because of its membership composition. It further on went on to say there are almost no franchisee members of the FCA, and membership of the FCA is dominated by franchisors. In effect, the FCA is captive of the interests of franchisors. Ms. Aldred, at a hearing of that committee on the 21st of September 2018, can you confirm your membership comprised of 483 franchisors and just two franchisees, or has that changed?
Thank you. That has changed, and that was nearly 5 years ago now. Since then, we've implemented a range of reforms. We have franchisees on our board. We have a franchisee advisory committee. We have a franchisee forum. We have an employment relations hotline for wage compliance and assistance and advice. We have a range of avenues in which franchisees have a direct role in the governance of our organisation, and the strategic direction and interest that we promote and pursue on their behalf.
But large members of yours are companies like McDonald's, is that correct?
We've got a large range of different brands, including McDonald's through to
7-Eleven?
7-Eleven, through to dog groomers, home maintenance, professional services, accountants,
Are you aware that the Shop Distributor of Allied Employees Union has a claim against one of your major members, influential members, McDonald's, both through, of course, as we know, McDonald's has corporate-owned stores and franchisee stores, deprived the allegations 250,000 workers of paid 2-minute breaks, and in some instances paid them with water or soft drink in lieu of breaks. And the amount of money is running into substantial sums. Also, there's been a number of franchisees that have been on the public record about the pressure that McDonald's applies when they're trying to apply decent wages. They said that that's part of the difficulties they have with companies like McDonald's because of the pressure that the franchisor applies to franchisees. Are you aware of those comments?
So I won't comment on that specific business, one, because I don't work in that business, so I'm not able to speak directly to those issues, plus it's a matter before the courts, but generally...
You can certainly make comments about matters in the industrial relations sphere if you wish to. If you don't wish to, that's your prerogative.
I won't comment on individual businesses, but what I will say is that every business should adhere to its employment relations obligations and compliance. We've got a range of really comprehensive resources, because one of the things, especially small businesses, say to us is that industrial relations is really complicated and complex, and so we provide compliance support to them on a range of best practice, wage compliance, webinars, other materials to make sure that they've got information, support and resources to be able to achieve that.
Ms. Aldred, I need to pass on to Senator Lambie, but on this question of McDonald's, that just exemplifies the same sorts of issues that were raised in 7-Eleven and the inherent conflict between franchisees and franchisors because of the predatory behaviour of franchisors, which have been found in a whole series of inquiries. So. Thank you for telling people that that what they might be entitled to, but the franchisor, if they're not paying enough to cover wages, Domino's, 7-Eleven, where franchisees have complained, it seems you have a very one-eyed view about how these issues occur, or you have no view except what the franchisors are particularly concerned about. But look, I'll hand over to Senator Lambie, and then I'm sure there's some more
if
questions.
I may just respond.
Absolutely welcome to.
No, what I've said is that every business should adhere to its wage compliance obligations. More broadly, it is a complex and complicated area. The ABC, through to state government departments, have also, with compliance issues in that area. I think it just illustrates that even if you're an organisation with significant compliance departments and resources, if those large organisations are struggling with those issues, then it illustrates that small businesses find that very challenging as well.
No, they weren't struggling. They were found to actually be carrying out wage theft on a number of occasions. And 7-Eleven's a prime example. But how many? Just to clarify, one quick thing: how many franchisor members do you have, and how many franchisee direct members do you have?
I'd have to take that on notice. Out of our overall of about 350 member businesses, some of them are bookkeepers, accountants that provide specific advice to the sector. Some of them are franchisors, some of them are franchisees. Certainly with franchisees that belong to a member franchisor, they've got full access to all of our member resources as well.
And franchisors, obviously, you would appreciate have a substantial amount of, which obviously are major organisations of that 350 odd you said. It seems that those major organisations would have a substantial influence on your organisation, but it would be important that you come back to this committee so we can actually clarify actual direct franchisees, actual direct franchisors, and who those franchisors are. Over to Senator Lambie.
Thank you, Chair. I just have a question about, we've just come out of COVID, me being in a rural and regional area. They did it really tough. I see many of them close their doors. They have not recovered or reopened. What is going on with those, and I'm just specifically small business, you're 15 and under, give or take, most of them, 5 or 6 employees or whatever, if they're lucky to have that. What sort of state of affairs are they in right now, and especially coming in? What's really bothering them? Because I'm already 3 weeks ago went out and around those businesses. They're not getting that trade ready for Christmas. That's not booming in. People are getting to their money. Their money is tied out there already. What sort of a situation? What's the situation look like for you with those small businesses? What are you hearing back?
They're under massive pressure at the moment. I think the last 2.5 years particularly has left them financially and mentally exhausted, emotionally exhausted. There's recognition of this in the recent federal budget with the allocation of about $15 million specifically for small business mental health resource and assistance. But they're saying to us that, pressures like shortage of skills and labour. Many of my members say to me that there's not been a month in the last 2 years that they haven't had an ad in Seek trying to secure staff. And all of those issues are putting additional pressure on small business owners to keep their head above water right now.
So with this legislation, firstly, I'm gathering that there wouldn't be many that could afford to get legal advice on it.
No, and it's a costly and complicated process. Many of them, even medium-sized businesses, won't have in-house resources. Small business owners certainly don't have chief legal counsels or in-house compliance resources. So they need to get external industrial relations, employment relations support and assistance. They often feel like they're on their own, and this can be, quite a confrontational and complicated process that many of them are pretty daunted by.
So can you please let me know how are small businesses knowing about these IR laws coming up? I'm not sure how much money you guys operate on, but ads not cheap to put in papers. I'm not sure if you would have had time yet to put out anything to them unless it's by an email. What does that look like?
It's really really significantly challenging for a lot of small businesses. Some of them are members of peak bodies like ours where they get compliance information and support. But even with that information, they still need to, if they're engaged in a process like this, secure legal advice, legal assistance. That's extremely costly. And they just don't have the resources right now to be able to have to add that to their list of everything else that they're being significantly challenged by.
So I'm assuming the government has sent them out something in their emails or reached them all. No, they haven't.
I think it illustrates, it's a very rushed process. There's a huge volume of information for people to have to get across, and certainly for small businesses, there's a really significant lack of understanding about what's coming under these proposals.
So I'm supposing that because there's maybe all of about 4 weeks left, by the time this hits, if it was to get up, these businesses won't know what's hit them until it actually plays out because they wouldn't have had a clue what was going on.
No, Senator, and that'll be smack bang in the middle of Christmas, end of year, Christmas trade period. Which is especially for businesses in retail, hospitality, that is their best goal of the year. To try and recover. So it's a huge volume of information and pressure that they're staring down the gauntlet at.
I'll just have one more question. What do you believe are the unintended consequences and the impact of this bill will have on them?
Huge amount of pressure emotionally and mentally. I think they're already under significant strain. Potentially, it will have, I think, some threats to competition, particularly around the common interest test associated with the multi-employer bargaining clauses that they need to get across, and it's a huge volume of complex and costly information that will be required of them.
Thank you.
Thanks.
I'll now go to Senator White. I just want to clarify something, because it may help the committee, because in light of the last line of questioning, which is appropriate, but to help the committee members, and if we've got time, I'll certainly come back to people. But I'm just trying to ascertain again, You had less than, in 2018, you had less than 0.017% of your membership were franchisees. The rest were franchisors. Is it more than 10% of your members franchisees?
I have to take that on notice,
You're
Senator.
not seriously
and,
telling us, Ms Aldred, that you don't know how many are franchisees and how many are franchisors?
We've got about 350 members, and there's a breakdown of advisors, suppliers,
So you don't really know who you're meeting?
franchisees.
Sorry, I didn't mean to interrupt you. You can repeat
I
the
want to
answer.
give you a specific. I want to make sure I give you a specific and accurate answer on the exact breakdown. So, as I've agreed previously, to take that on notice and come back to you.
Thank you. I'm not asking for a specific breakdown. I'm just asking for an average. You don't know how many people are franchisees and franchisors, but you're representing them, and you know there's a basic conflict of interest between franchisees and franchisors. And one of those conflicts of interest...
I don't agree with that.
Well, 7-Eleven, which since 2016 had paid $176 million in wage theft back to workers and has also been forced to pay $98 million back to its franchisees, I would say that's a conflict of interest.
I'm not going to comment specifically on,
Of course you aren't.
individual
Thank you,
businesses.
Ms Aldred.
But, when
Senator White.
When franchisors and franchisees work constructively together, that helps the overall health and productivity of their business.
But you don't know who your membership are and what the numbers are, so you wouldn't say how. I don't know quite know how you. And in that case,
Yeah, I've
the
just explained that to you.
$98 million that was ripped off from franchisees, you've got no comment about it, and I've noted that you don't want to make any comments about that issue. I noticed that. Well, I don't think Ms Aldred's taken on notice. She has taken on notice about the numbers, which she doesn't want to disclose here, or rough percentages, and she says she doesn't know. And she doesn't have a view about the fact that 7-Eleven franchisees were ripped off $98 million.
I think she was trying to answer the question, to be fair, Chair. I think she was. I don't know if you want to.
No, I think she said she didn't want to. Sorry, Ms
no,
Aldred,
I think
I
she was
understood.
trying to, yeah.
Ms Aldred, I understood that you said that you did not want to talk about specific cases because that would have blown your argument about that you're it's one big happy family
No, I think
representing a lot of franchisees. Because I deal with a lot of small businesses. I deal with a lot of small businesses, and I know over many years that they get stood over by franchisors.
Chair, I think you're putting words in my mouth.
Well, I tell you what, the inquiry in 2018 had a very similar view to how the FCA operates, and the 7-Eleven example gives another example about what actually happens between franchisors and franchisees. So I find your answers very intriguing, Senator White.
And as I've responded to you, the FCA has made a long list of reforms since that time, nearly 5 years ago, to better represent the interest of franchisees, which I'm happy to take you through again.
The numbers would be really helpful. I appreciate you've taken on notice, but there are questions being asked because you're representing yourself, that you're representing 7-Eleven, including the $98 million back payments to franchisees, but you won't comment about it. So I'm just saying that it's clear, until you give me contrary evidence, I could only ascertain that you have a large organisation that is represented by franchisors.
It's not a large organisation.
And it's dominated by franchisors, like McDonald's and others that many franchisees have complained about, including 7-Eleven.
Actually, we're a relatively small organisation that represents all facets of the franchise sector. When franchisors do well, when franchisees do well, when participants in the supply chain do well, that helps the community and the broader economy.
Yeah, and when workers go well, and I absolutely agree that when everyone's going together, but I'm trying to ascertain who you're actually representing here, and I haven't been able to do that yet. So I'll hand over to Senator White.
We represent the franchise sector.
Well, that's what you assert. That's what you assert. Over to Senator White.
Yeah. And what Senator Shollin's trying to do is just test who you represent, right? Because we've seen that. And so let's just look at your submission. On the front page of your submission, somebody who had a cursory look at this would think that you had 94,000 small businesses as members because you say you represent them, but you don't have 94,000 small businesses as members, do you?
The first page of our submission does is set the scene for the
I
franchise
get that.
sector.
No, sorry.
We're
can
not
you just,
claiming.
yeah, I get that. But just ask.
We're not-
I'm trying to ascertain how many members you got. You do not. You say you represent, and I've been in a union for a very long time, and I know the difference between having members and who I represent. Right. So you do not have 94,000 small businesses as members, do you?
I'll read you directly what our submission says.
I'm reading it. So the FCA represents an
Yeah, but I'm
estimated
sorry, you're putting-
94,000 small businesses.
Point of order, Chair, please. Point of order.
I'd be happy to respond if you'd give
The
me
unions
the
claim to represent all workers.
Can I?
All workers.
Can
No,
I?
they don't. The ACTU
Unions
says
claim to
1.3
represent
million.
all
Sorry,
workers.
Michaelia. Sorry, Senator
have-
Cash.
I have called a
unions
point
say
of order.
1.3
There's a
million.
point of order.
Ms Aldred was answering a question. We've just been through estimates where this committee has been able to respect the witnesses and giving them time to answer their questions not being spoken over. I think we should continue with that pattern.
Senator White, could you ask your question and then we'll allow.
Sure, I'm quoting-
then we'll allow.
I'm
Ms.
quoting
Aldred.
from the second page under your introduction, where it says, importantly, the majority of franchises and almost all the franchises are small businesses. So the FCA represents an estimated 94,000 small businesses. My question to you is, you do not have 94,000 small businesses as members, do you? Because your evidence and answers to Senator Sheldon was that you have 350 members.
We're not claiming to represent 94,000
No.
small businesses. We're representing the views and the interests, the challenges, the issues, the problems of a
Yes.
broader small business sector.
But if you're
and I
not
think
members,
that's
it's
pretty
hard to
self-evident.
represent their views, isn't it?
I don't think it is, actually. Small businesses are remarkably consistent with their feedback to us.
Okay.
We conduct extensive... I'm sorry, I'm answering your question, if that's okay. They are remarkably consistent in the feedback that they give us on key issues, from skills and labour shortages to supply chain challenges to the cost of doing business to commercial leasing issues and other green and red tape issues.
But you can't tell us about franchisees that have been ripped off by franchisors that have been forced to underpay their own workers to try to meet the franchisors' demands. I appreciate you can't tell us what that interaction is at your organisation and the legitimacy or otherwise of your organisation in that space, because you've said quite clearly you do not wish to answer any of those sorts of questions. So
My
I take
response
that.
to
I've
you-
noted that, and thank you. Your response has been very clear.
You're not actually giving me the opportunity to respond.
I'm very
responded
mindful
to
that
you.
we have, Ms Aldred, I'm very mindful that we have a limited amount of time. You have given those answers before to that question. I'm just repeating the answer you've given. In my interpretation, it is on Hansard what you've actually given. People are more than welcome to read Hansard. You've given a consistent response to that proposition I've put to you. I've heard it, I don't agree with it, and I don't think it's logical, and I appreciate that you have a different view to mine.
Can I ask a couple more questions? Your submission refers to a survey you conducted of franchisees to inform your submission. How many franchisees were involved in that survey? How many made answers?
There was about 60 on Tuesday.
So how many people have answered?
That was about 60 businesses this week.
So 60 franchisees, or did that include franchisors?
No, that was exclusively franchisees as part of our franchisee forum, who are all franchisees and all small business owners.
So 60 franchisees of 1,300 possible franchisee networks, of which you say there are probably 94,000 individual franchise outlets, 60 have replied to your survey. Is that right?
I think your question actually illustrates the broader point of the rushed process of this bill and the consultation period. This week alone, there have been a historically high number of amendments rushed through. We, on Tuesday, consulted our franchisee forum on their awareness of the bill and what it was proposing. And in the time available this week, we had about 60 respondents to that.
No,
Small businesses are very...
I'm just trying to get the facts, right? You can give
Sure.
me... I'm just asking you. So 60 of potentially 94,000 individual franchise outlets made a response. Can I ask you also then, that's the fact, isn't it? I'm not misrepresenting you?
Well,
Right.
Senator,
No, well,
small business owners are flat out working in their business.
Yep.
It's been a very rushed consultation process, And in the space of the couple of days that we've had to get across key amendments and parts of the bill, that is the number of franchisees in the space of an hour that were able to provide us with a response on that issue.
Thanks. Your submission states that you're opposed to the provision of the bill which increases the monetary cap on the amounts that can be awarded in small claims proceedings under the Fair Work Act from $20,000 to $100,000. This was a recommendation of both the Migrant Workers Task Force and the Senate inquiry into wages theft. It's also expanding access of victims for victims of wage theft to access a lower cost, less complex and less time-consuming method of wage recovery. Why are you opposed to that?
Raising the threshold of that to $100,000, we're just unclear about the case that the government is trying to make to support that amendment. It hasn't really been clearly stated.
Well, it was recommended by the Migrant Workers Task Force and the Senate inquiry into wage theft. That is the amount, and so you've opposed it because you don't know anything about it. Is that right?
No, what I said is the government haven't, in our view, made a compelling case about the increase in that threshold.
So you don't think the Migrant Workers Task Force and the Senate inquiry into wage theft made a good enough case on this?
We don't think the government at this time has made a good enough compelling case.
To Senator O'Sullivan.
Thank you. Thank you very much, Mr Aldred, for your time today and your submission. In your submission and in your early evidence, you did say that most of your businesses are small businesses. Can you tell us of them, what percentage of your member base are unionised?
It would be hard to provide an exact figure on that, but I would suggest for small businesses that are members, there would be a small proportion. In other larger businesses, especially for example in the retail sector or hospitality, there would be some union membership in those segments.
Okay. So the government has stated that the purpose of this bill is to drive up wages. In your view and your members' view, those that you've been able to survey so far, and appreciate that you've had limited chance to be able to canvass their views because of the rushed nature of the introduction of this bill and our deliberations, who stands to gain most with this bill? Will it lead to an increase in wages for employees or an increase in union involvement in small businesses?
We would suggest union involvement in small businesses. Ultimately, it may undermine the sustainability and viability of many small businesses, which undermines the viability of jobs. And so we have grave concerns on that basis.
Thank you.
Thank you. Senator David Pocock.
Thank you, Chair. Thank you for your time this morning. And appreciate your submission. I'm interested does your submission take into account the 150 or so amendments that passed yesterday?
No, it's very difficult to get across the huge volume of information and amendments that have been rushed through. I think it's a historically high number of amendments this week, and so it's been very difficult for stakeholders, organisations like ours, to get across that and give it proper consideration and review in providing our input.
Okay, thank you. Do you know sort of what the average number of staff the businesses that you represent would have in terms of full-time equivalent and also headcount?
Yeah, franchising is a very diverse and dynamic sector, so it very much depends on what industry sector a particular business is involved in. That can range from sole traders, home repairs businesses that might just employ one or a couple of people, right through to very large businesses that employ hundreds of people.
Thank you. You mentioned that you've got 60 franchisees to respond to the survey this week, and I'm hearing concerns about the timeline. what sort of timeline would allow you to do consultation?
Look, I think there's a number of non-contentious elements to the bill. So our view would be split that off from the most contentious aspects of the bill, multi-employer bargaining aspects, to provide that with an opportunity for full and comprehensive review, consultation, debate and scrutiny. And so that should be held over until next year.
Okay. Thank you very much for your time.
Thank you, Senator. Senator Hayman.
Thank you, Chair. I just wanted to inquire whether you support the amendment made to the bill, which requires a majority vote of each workforce before an employer can be brought into the single interest stream of a multi-employer bargaining.
We broadly have concerns where a union could come into a workplace and they don't represent employees in that business and can initiate or reject or force the employer to amend that process.
Sorry, so do you support that? Do you support the amendment or no?
No, we don't.
Okay, because from my understanding, your submission says you do. But you're still
Sorry,
opposed
can you
to single interest?
No, not single interest.
Yes, but, okay, I think that's it from me, Chair, because I'm, getting really confused here.
Yeah, just one quick supplementary question quickly.
So you gave the example of Dan, the franchisor, who had, I think you said 5 employees?
No, he's a franchisee, actually.
Franchisee. He has 5 employees, I think you said, is that right?
No, he has 5 outlets.
5
as a
outlets.
franchisee,
So
and he has about 70 employees.
So if he's doing well and his employees are happy in their situation, what is wrong with them voting not to be in a multi-employer agreement? Because that's what they could potentially do. They're the ones that are going to vote, not a union.
But a union can intervene and interfere in the process, and that's what we have concerns about.
The union can give advice, just like you give franchisors advice. The union can give advice, but the employees will be of their own mind and can make a decision. And if they like Dan, then
we're not a registered organisation.
They'll listen to Dan, won't they?
Overall, our concern is that it takes away from the primary focus, which should be employees and employers as a starting point, bargaining together.
So I'm just going to ask a clear question. Are you aware of Ms. Aldred of the International Labour Organisation Convention on the right to become a member of a union or not?
Absolutely.
So you're saying that the fear that somebody might actually decide to become a member of a union is something that you're concerned about?
No, you're verballing me.
No, I'm not verballing you. You just gave evidence. Look, I'll let the evidence stand, Ms. Aldred. You know, you've clearly said that you're worried about third parties coming in and speaking to workers. Well, they're not third parties, but if that's a concern that you hold,
where they
then
don't have
I appreciate
members in that workplace.
Chair, I just want to point out the time. We do need to move to other witnesses, if that's okay.
Well, I've got to say I appreciate the Deputy Chair's quite rightly asked me to move on to the next witness. I found your evidence particularly interesting. We don't know whether how many franchisees or franchisors you represent. We clearly don't know whether there's some concern about people being represented in negotiations, and there's some concern about a majority of people deciding after getting advice from a union that they might want to have a collective agreement. So, I am deeply concerned.
To be fair, Chair, perhaps then Ms Aldred might be given the opportunity to review the Hansard or to review the audio recording and provide a response, given we have had limited time with her to the propositions that you've put forward.
And I just remind all witnesses that they have the opportunity to do that. And Ms Aldred, as Senator Cash has raised, you certainly have the opportunity to respond to that in writing.
Thank you.
I'll move to the next witness. And thank you for coming and joining us. It was
Thank you.
interesting. If you've taken any questions on notice, could you please return the answers to the Secretariat by close of business Monday, the 14th of November 2022. If you find some problems in some of the answers, then some of your franchisors, some of the biggest companies in the country might be able to assist. I mean, that considering the fact that they're so substantial.
Thank you.
Thank you very much.
Thank you.
I now welcome in person a representative from the Master Builders Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to a Senate committees has been provided to you. For the Hansard record, would you please state your full name and the capacity in which you appear here today?
Thank you, Senator. Good afternoon to the committee. My name is Sean Schmidtke. I appear for Master Builders Australia and I hold the position of Deputy Chief Executive Officer.
Thank you very much. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thanks very much. Senators, as always, Master Builders Australia is grateful for the opportunity to assist the committee with its inquiry into this bill. Senator, before I get into the substance of the bill, I just would like to make a comment and acknowledge that there has been a very, very truncated timeframe with respect to this bill. I won't labour that point, but as an IR practitioner, when we go to sort of starting to disrupt common bipartisan elements of the industrial relations system that have been in place for 30-odd years, we are going to need a little bit more time to get through the detail of this bill. There are fundamental big changes here, and I think more than 30 days or so potentially before we vote on this bill. I think we need a little bit more time. And certainly the nature of the change, regardless of whether it's agreed by Master Builders or not, deserves a little bit more consultation. But that said, Senators, Master Builders has filed a submission with the committee. We sent that through this morning. I do hope that it got to you in time. I do apologise for not being able to get it to you prior. But as you'd appreciate, and I think as other witnesses have pointed out, there's been quite a few changes to the bill. I've tried my best to accommodate those in the context of the written submission, but I do indicate that I might have missed a few things here and there, and I've also noticed some typographical errors, so I will send a replacement submission at an appropriate time. So overall, Senators, despite there being a number of positive elements in this bill, it's not one that Master Builders can support. Now, I'm happy to take any questions on any element of the bill or any of the matters in our submissions. So I won't go into it in too much detail, but I will say this. Master Builders does not support any law or change to workplace law that gives unions more of a right or more of a say over the conditions of employment than the actual workers to whom those conditions will apply. We're never going to support laws that take the enterprise out of enterprise bargaining or the agreement out of enterprise agreements, which is exactly what this bill does. We don't want to open the door for a return to industry-wide deals or industry-wide strike action, which this bill does, and obviously Master Builders Australia will never support any legislative change that seeks to abolish the Australian Building and Construction Commission, which this bill does. Now, I do want to just focus for a moment, Senators, on the ABCC. I'm not going to go through the sort of normal approach that Master Builders might adopt with respect to the evidence, the data and the long-standing history of problems we have in our sector. But instead, I just want to say this. Everybody knows that the building and construction industry is home to a certain cohort of individuals and certain associations who, for whatever reason, think they're above the law. This is not a group of people who are operating in a normal way, like a normal union might operate. This is a completely different kettle of fish we're talking about. They have a general attitude and approach which has been part of our sector, regrettably, for 50 years, as far as I can tell, probably longer, and it's forensically documented. So over that period of time, it's certainly since 1983, I'm aware that we've had the Giles Royal Commission, the Wyniki Royal Commission, the Cole Royal Commission, we had the Hayden Royal Commission, there's been the Wilcox Report, there's been numerous other reports, dozens in fact, of reports and reviews and inquiries about what happens in the building and construction industry. All of those reports note the same thing. We are home to a recidivist union. We have judges, federal court judges, who say that we have a union which brings the entire labour movement into disrepute. I almost lose track of the number of penalties that the union I'm talking about racks up each year. The last count I have is approximately, well, around 1,800 separate breaches of workplace laws since 2016, with $16.2 million in penalties. I've done an analysis about 12 months ago where I looked at right of entry breaches over a 2-year period dealt with by the federal court. It's the CFMEU. In fact, if you add them up, senators, the CFMEU is 45 times more likely to break right of entry laws than every other union in this country combines. Now, senators, I've got to say, this is something we're not proud of. The conduct of this union in our industry gives our industry a bad name. It contributes to an extremely poor culture, and it's a group of individuals who seem to be operating like it's 1960. It's not 1960, senators, but at the same time, these people are still operating. They honestly make a mockery of the entire industrial relations system. I understand that there are good unions. Master Builders understands that there are good unions that operate in this country, and Master Builders has always held the view that they're an integral part of the system. If a worker wants a union to represent them in their workplace, that's excellent, and they should have that right when it's requested. But that's not the case in this bill. And again, senators, I just simply make the point that everybody knows this. We all know this, and it's been like this for a long time. In fact, their own divisions within the CFMEU know this. We have 2 separate divisions who want to get away from the construction and general division. We have the manufacturing division and we have the mining and energy division. Now, what they do in relation to their union and whether they want to amalgamate or disamalgamate, whatever the case might be, that's up to them. But I do note that there's 2 cases on foot that deals with this amalgamation question. And in the proceedings, the one element of the union that wants to disamalgamate has had to file evidence. In fact, I've got it here, which includes a list of all of the breaches that they say their own union had breached, or cases of breaches of workplace laws. It's my only copy, Senator, I'm sorry, but I'm happy to...
Mr. Speaker, you are, as a chair, thank you, Senator Cash, you are welcome to table it when it's convenient, so the whole committee can have
yes,
those
so,
copies when
yeah,
it's convenient.
We'd
encourage you to do it on request of Senator Cash.
Yes, I'll certainly do that, Senator. But the thing is, this document that's been filed, in response, the other division of the construction division has filed evidence to say, well, you are just as bad as lawbreakers as us. So we literally have 2 divisions within the one union in a legal proceeding, and what that legal proceeding is going to turn on, essentially, is who's broken the law the most. And I sit there, senators, as an interested person, obviously in industrial relations, but also as a representative of the building construction industry, and say, what's going on? That's the type of thing that we have to deal with in our industry. Now, against that backdrop, where I can if you want, I'm happy to give you some examples of cases that are very recent, where we get the type of conduct that we just don't expect in modern workplaces, don't expect in our community, don't expect it on our sporting fields, don't expect it in this place, but it's okay in construction. I can give you stacks, almost limitless numbers of examples of that type of conduct. So even if we put that to one side, and even if we think, oh, well, it makes no sense to keep the ABCC and let's get rid of it, the question I have for this committee is, what do you think that the CFMEU is going to do when there's no ABCC? We have had building industry regulation over the industrial relations in building and construction for 25 years now, and that's gone. The Rudd-Gillard government kept the Fair Work Building Commission. There's been all sorts of regulation that we've had, but the important point to note is that we're going to lose that for the first time in 25 years. And I don't know what the CFMEU will do, senators, but I can tell you I don't think it's going to be good. I don't think they're going to become model industrial citizens. So I simply say to the committee, it is not too late. It is not too late to not proceed with these elements of the bill, because it's bad for our industry, it's bad for our culture, it's bad for the industrial relations system, it's bad for unions. I just do not accept or understand that that's the right decision. In terms of multi-enterprise bargaining, it's the other area I wouldn't mind mentioning.
Mr. Smith, I don't want to stop you in full flight. I'm sorry, I just did, but just the intention is, I'm sure you're fully aware that a number of committee members will probably ask questions right to the points that you're raising. I don't want to cut you off. I've been quite liberal with others that have given evidence. Might be going a little bit longer than others, but I'm not. If you want to continue to take the time, so it'll be less time for questions, and I'm confident that the questions that will be asked will go to the issues that you want to raise as well.
Certainly, Senator. Well, look, I won't press on, but I do just want to make one observation, actually. The bill is aimed at getting productivity and getting bargaining happening in workplaces and getting wages going. The bill, we say, is not going to achieve that aim, and I do think we need to have a fundamental rethink about the overall complexity of these workplace laws generally. It is becoming an extraordinarily complex situation, and I actually did, Senator, all senators, I had cause to go back and look at the industrial relations law that applied when I first started in industrial relations in 1998. And at that point in time, I was covered and working under a piece of legislation where the collective agreement making provisions ran for a total of 8 pages. 8 pages. The length of the Act, which was the New South Wales IR Act 1996, was at that point 256 pages long. I thought that was an excellent piece of legislation, and it was a good system. However, we've now got a situation where we have amendments to bargaining provisions which exceed the total length of the entire Act. So that in and of itself should send this committee a message that if we're going to improve bargaining, let's take the complexity out of it, let's focus it on the enterprise, and let's focus it on productivity. Thank you, Senator. I appreciate your forbearance.
Thank you, Mr. Smith. And I was around in '96 as well, and I do think that was a great piece of legislation.
Happy to talk to you about Chapter 16 today, Senator.
and people had the right to strike, and arbitration existed, and a whole series of things. So over to Senator Cash.
Thank you, Chair, and thank you, Mr. Schmicki. And time is short, so I will ask you if you could keep your question or your answers as tight as possible. But I do want to just preface my questions will be in relation to, in particular, the abolition of the ABCC and an article that I referred to at Estimates recently by David Pemberthy of November the 7th, 2022 in The Australian. State of alarm as John Setka-led CFMEU flexes its muscles on building sites. An Adelaide property developer has threatened to pull the pin on a $27 million apartment project amid the growing militancy of the South Australian CFMEU under the leadership of John Setka. 3 months after Mr Setka took formal control of the branch, a picture is emerging of the impact the Victorian takeover is having in the historically calm SA construction industry. Just in terms of the abolition of the Australian Building and Construction Commission, am I right to say that unlawful picketing will no longer be an offence under this bill? And can you, if that is so, can you take me through what gave rise to the need to have it in the former BCIIP Act?
Thanks, Senator. Yes, the answer to your question is that this bill does remove the unlawful picketing provisions from the BCIIP Act. The reason that those provisions were included in that legislation was as a result of what we used to experience in building and construction called community pickets, which is all of a sudden you would have a dispute or a problem in a construction workplace that would subsequently and magically be the subject of a picket, apparently arranged by the community, some community-minded individuals who were very concerned about the particular issue of that workplace. Obviously never been arranged by the relevant union, even though a lot of the time it had. And of course, those pickets stop people getting into that workplace. Now, it's interesting, when I talk about community pickets, it's not the sort of cake stall type arrangement that might come to mind. These were fairly hardcore picket lines. And often they featured lots of individuals who you might ordinarily assume would belong to motorcycle clubs. And this particular type of conduct was a common feature. The worst example, Senator, that I can recall in relation to a community picket and a picket line related to the building of the Little Creatures, I think it was, brewery site in Geelong. Now, that community picket was so intense that they actually had to use a helicopter to get the staff onto the site because of the nature of the picket. That's what's happening in the building construction industry. That's why we needed the BCIP Act.
Can I just go back to, though, am I right to say that unlawful picketing will no longer be an offence?
Yes, you are.
So what will happen if this situation occurs?
Nothing will happen.
Why?
Well, because I'll tell you why, Senator. Because it's happening outside the workplace premises, you will ring the police, and the police will arrive, and somebody will say, well, this is an industrial relations matter. Police has got no issue here. This is all about industrial action. It's all about we're taking strike action, whatever the case might be. So the police will say, oh, OK, we've got nothing to do here. We must be powerless, so we're going to leave. But of course, you then ring an industrial relations regulator, and they say, well, we can't do anything. This is not industrial action. We're powerless to do anything about it. So that is exactly why.
So what impact would that, though, have on the industry? Given that the abolition of the ABCC is going through, we understand that. What impact will just that small change alone have on the industry?
It will be very significant, Senator.
Is there an economic impact?
There will be. I can take on notice that question and see if I can get you something that might give you an indication of the extent of that impact. But can I just say, if you might recall, Senators, there was the dispute in the Myer Emporium matter in Melbourne CBD a few years back, and it featured, again, community picket, but actually it featured a lot of people punching police horses, scuffles, threats, abuse, all that type of stuff. That was one example of it. So there will be, I've got absolutely no doubt that will increase. And Senator, I'll take the specifics of that note.
I preface my questions to you referring to the article in The Australian of November 7, State of Alarm as John Setka-led CFMEU flexes its muscles on building sites. As you understand, the ABCC is being abolished. The FWO effectively becomes the replacement for the ABCC. I questioned the forward estimates. How many inspectors do you have? It's approximately 194 inspectors. I asked them, what is the majority, male or female? The majority are actually female. So in saying that, can I ask you, given your history within the industry, given your history in terms of industrial relations and industrial relations law, will the FWO be an effective replacement for the ABCC? You've already said unlawful picketing will no longer be an offence. But given I prefaced my questions with the state of alarm as John Setka-led CFMEU flexes its muscles on building sites, can you also tell me about the CFMEU's attitude to women?
Senator, in answer to your first question, no, the Fair Work Ombudsman won't be anywhere nearly as effective.
And I do need to ask you why.
Okay, as the ABCC.
Yep.
Now, there's a range of reasons for that, but effectively, the powers, the function, the role, the capacity to gather evidence and information that exists with the ABCC does not exist with the Fair Work Ombudsman. The obligation for the ABCC, for example, to take action and try and enforce workplace laws and seek breaches for, compliance seek penalties for non-compliance with those workplace laws. The Fair Work Ombudsman does not have that same absolute obligation. The building code, for example, contained within it an obligation for all building and construction industry participants to notify a regulator when they see misconduct and something happening on a building site that could be against workplace laws. It also required them to proactively take steps to try and stop whatever was occurring in that respect. And again, that is not anything that's going to be available to the Fair Work Ombudsman. They won't know. Building and construction industry, it has no incentive when we're dealing with the CFMEU to put up our hand and say, they're law breaking, we better ring the Fair Work Ombudsman. Absolutely not.
Why?
Of course they won't. Well, because of the threats, the intimidation, it's our way or the highway. And I can tell you that as soon as the building code was amended earlier this year, the conduct started straight away, Senators. I was actually really surprised that it actually happened so quickly, but it did. And it started in Western Australia and South Australia, Senator, as you rightly point out. Now, in relation to South Australia, it's my home state. I've always had a soft spot for South Australia. I will live there again one day, but the sense that I get from the members down there is absolutely worried because they've seen what's happened in Victoria and they think, is this coming our way? They've seen what's happened in Tasmania because Tasmania has been taken over by the CFMEU a few years ago and it's starting to impact down there and they're absolutely petrified. And this is not right for modern workplaces. If I'm an employer, I shouldn't be worried or concerned that a union official is going to come walking through my door.
Can I also then ask you, in terms of, you have been around a long time, you have represented this industry for a very, very long time, the estimated economic impact of the abolition of the ABCC, will there be an economic impact, but in particular in terms of productivity, the impact on productivity, the impact on job losses? And I know there will be some, if you refer to the EY report, that say it was commissioned by a biased industry potentially, the master builders. So could you also justify the basis for the report?
Well, Senator, we've linked to a copy of the report in the submission we filed with you. Paragraph 25 of our submission provides you with an indication of the findings of that report. I would be happy to take on notice any questions that the committee has with respect to the report. It was written by very smart economists. I'm not a smart economist at all. But what I can say, though, Senator, is that in relation to the impact that unlawful conduct has in our sector, because of the way our sector exists and operates, where you have a very minor disturbance at one part of the construction chain, it creates a massive disturbance elsewhere. For example, Senators, anyone that's doing Commonwealth-funded building work or undertaking a building project for the Commonwealth at the moment, if they don't get that project finished on time, they may well be subject to $150,000 per day liquidated damages. So it is very easy for a union to disrupt a concrete pour or engage in some other conduct which completely disrupts that site on an ongoing basis. You can't just say, oh, we'll resume work in an hour's time. You've got to push people back, you've got to rephase the work. There is a significant cost. The CFMEU know this. Unions in our industry know this, and they exploit that day in, day out. So I heard this morning some earlier evidence being given about days lost through to industrial action. In our industry, all you need to do is block a concrete pour for half an hour and you've knocked that project back by a day. You can have some trucks in front of a fence or a gate or something like that to stop people coming in. If it's a particularly important part of the project, well, you might not get that opportunity for another week. When you see big buildings being constructed in CBD sites, for example, all of the massive equipment comes in very restricted timeframes because of council rules and things like that. If you target at the right time, you can cause huge amounts of damage. That's what we experience. So it is extremely easy to create extreme, significant financial havoc within building construction if you are somebody who wants to disrupt a building construction workplace.
So in case we have gone over time on other questions, but if you are welcome to ask one last question.
My last question then, Ian, is it was something I did pursue at estimates, and I do have genuine concerns. The 194 inspectors that the FWO have, the documented, well-known abuse that many of the ABCC inspectors have had thrown at them, the harassment, the abuse, the spitting on. I won't say it here because it is too vile for words. The the new National Construction Forum and the FLOW, are they adequate to ensure that there are safeguards in the industry to protect them from this type of behaviour?
No, it's a short answer. The long answer is, or the slightly less short answer is that the construction industry forums a welcome development, but it's no ABCC. The Fair Work Ombudsman, we strongly support the Fair Work Ombudsman, but they don't stand a chance when it comes to our industry. Walking into a busy construction site to talk to a member of the CFMEU or a CFMEU official about a potential dispute is very different from doing a wages or underpayment audit in a small cafe. The Fair Work Ombudsman, I wish them well, I hope they do well.
So we all wish them well, especially given the majority of their inspectors are female.
Yeah, but I hold little hope that they're going to be effective, Senator.
Thank you, Chair.
Good, thank you. I now go to Senator Lambie. Sorry, my apologies. To you. Senator White. My apologies, I've just broken my own list.
That's okay. Mr Schmidt, as part of the NBA's ongoing campaign against the bill, I think your boss, Ms Danita Warren, appeared on ABC Radio National Breakfast on Tuesday this week. When asked by the host, Ms Cavalis, when the host, Ms Cavalis, asked if the NBA, what the NBA's position was, I quote, she was asked, does the NBA support any part of the government's industrial relations bill? And Ms Warren answered no, and we oppose it in total. Is that correct? You oppose every single thing in the bill?
No, Senator. We oppose the bill overall. There are elements we've identified in our submission that we think are good changes. There are elements where we don't have a position because we need further information. And there are elements that we know are terrible. And there's elements that we know have been recently amended, but regardless of that, we don't support them.
So do you oppose making gender equity an object of the Fair Work Act?
I don't. No, Master Builders does not oppose that element of that particular amendment. The related part regarding secure employment, we do, on the grounds that there is lack of clarity provided in the EM, and there's some core definitions that we need to know before we understand or can develop a position with respect to the objects. The objects of the Act play a huge role, very relevant role in the way the Commission and the Act is administered. So we need to get that right. It's very important we get that right.
So you don't, well, so you sort of oppose it.
Well, you asked me about gender equity.
I'm asking you about that, and I wasn't clear. So you said, so as an object of the Fair Work Act, you do not oppose that?
That inclusion, no.
That's right. That was all I asked you. I didn't ask you about the rest.
Yeah.
You oppose do you oppose the additional protections against sexual harassment at work?
If you are talking, is that part 19? Is that part 19?
I think that's right, yeah.
No, in principle. There is a concern, though, we do have with that provision, though, Senator, and that is in relation to the duty that's imposed on employers and the positive duty. There's an inconsistency with work health safety laws. Look, to be frank...
Do you oppose a pay equity expert panel being set up in the Fair Work Commission?
No, Senator, and in fact, I think in our submission we've said that Master Builders is very keen to increase the amount of female participation in construction, and to the extent that those changes in some way help, well, then we support that.
So when Ms Warren said on Tuesday that we oppose it in total, that wasn't right, was it?
It wasn't right from the perspective of what has been put in the submission to you today. However, Senator, can I just say this? There is, I think, 23 separate distinct parts of this bill. It is a significant bill. The reason I'm sitting here looking completely dishevelled and bleary-eyed is because we're still working through all of this. It's a significant change. At the point in time when my boss made those comments on that radio interview, she did not have the benefit that I did have of sitting there with each element of the bill going through hundreds of pages of EMs. However,
wouldn't it have been open to her to say, look, I haven't read the bill in total. Sorry?
But what I can say, Senator, is that we had fully briefed, to the extent I could, misworn on the core elements of the bill, and the position overall is that we don't support it. And we're not going to change that position. If it's got anything that abolishes the ABCC, we're not going to support it.
So we oppose it in total is correct?
Yes.
Thank you. So I just want to clean up some of the misinformation that the NBA has been putting out there in its talking points. You've been talking about productivity. Are you aware that both the ABS estimates of Industry Labour Productivity Index and the ABS estimates of Industry Multi-Factor Productivity Index show that productivity in the construction sector has been lower since the ABCC was reinstated in 2016?
Lower when compared to what periods?
Well, compared to no ABCC period. So if you look at the table 6 in that estimates of industry labour productivity, it shows you what the productivity was in the construction industry in 96-97 and compares it with periods when there was both the Fair Work Building and Construction Board and the ABCC, and you can see there's a drop in productivity.
Senator, I'll take that question on notice,
Thank
but
you.
what I can add is that I'm aware that there has been drops in productivity in the building and construction industry. And I'll find this data for you. I do understand that when it comes to ABCC and covered jobs, the reduction in productivity has been half the reduction in other parts of the sector. But I will take that on notice and confirm that.
I'm just relying on the ABS. I'm happy for you to give us a critique on that. If I could talk to you about the report, that Ernst & Young report that you were mentioning before.
Yes, I'll help you to the extent I can, Senator.
Yeah. In that report, it calculated the economic impact of abolishing the ABCC. That report asked...
Mr Smith, you're nodding your head. I gather you were confirming that that was the essence of the report.
Yes, sorry.
That report asked 49 people. Is that right?
No, that's not right.
How many people did it ask?
I don't know how many people it asked, but there were 49 respondent companies.
Respondents, okay. So it might have been organisations?
Yes.
Thank you. It says people in the report.
So, well, that might well be the case. What I do know, though, Senator, is that when that survey got sent around, it got sent around on the basis that one person per company would answer it. It got sent to companies that were code-covered entities under the ABCC, and those companies are fairly large companies, so that was a fairly significant part of the sector that responded.
Okay, so but I guess your report says people, but you're saying they represented organisations potentially, sure. It didn't examine any actual existing ABS data on the construction productivity, did it?
I understand that the author of the report did a literature review. They took account of a few of those items, but I understand that it's contained elsewhere within the report, yes.
Yeah. Are you aware that the University of Sydney economist Dr Philip Toner analysed the EY report and concluded it is, I quote, effectively anecdotal, empirically empty and useless as a basis for analysis and modelling?
Yes, I am aware.
And what do you say about that?
Well, we disagree with that, obviously, and Mr Toner is a well-known critic of many reports and many issues that are advanced by master builders or indeed any employers in building and construction.
So he says this methodology for data collection is utterly unacceptable. It's effectively anecdotal, empirically empty and useless as basis for analysis and modelling. It is not based on a large random stratified sample, and the term industrial dispute was never defined. Duration, type, numbers of people involved, etc. Is that a fair criticism?
I don't. If Mr Toner wants to make that criticism, that's fine. That doesn't change what the report found, and it doesn't change Master Builder's view that abolishing the ABCC is not a good thing for the economy.
Further, an analysis of the data in Table 1E, EY respondents' assessment of the frequency of industrial activities at work sites reveals that nearly 2/3 of the 49 respondents reported they never or rarely experienced industrial action at their work sites, implying they had no direct factual basis for making any assessment of the impact of industrial action. Is that correct?
I think that was in relation to direct industrial action on their work sites. But that does not mean that they're not affected by industrial activities on other work sites.
They never or rarely experienced it.
Well, that's what the report says.
Sure, but we can all write reports. If then they are not factually correct or don't provide evidence that we can rely on, are they not worthless?
No, I disagree with that, Senator. I disagree with the premise of the question that you've just put to me there. That report, we went to a great deal of trouble to ensure it was written, created at arm's length. The methodology behind it was done at arm's length. As I said to the committee, honestly, before, I'm not an economist. We have to leave it up to those people. I'm happy to take on questions, on notice any other questions you have there, Senator, but I have no reason to believe that that report is not anything other than completely appropriate and reflective of the modelling that was commissioned.
Well, perhaps what you might want to do is ask EY whether what their response is to these criticisms. Perhaps, you know, and I would have thought they would regard themselves as a reputable organisation, and that they would want to respond to those significant criticisms of their methodology on which you seek to rely. But I can't tell you what to do, but it would seem to me they might, for reputational reasons, want to think about what they do about that.
I'm happy to take those questions on notice, Senator, and I will relay them to EY.
Thank you, Mr Smith. Senator Lambie.
Thank you, Chair. Can you explain to me what your thoughts are, or why you believe the building construction industry requires a separate body to monitor unlawful conduct in the workplace?
Well, Senator, it's simply because we have had a history of it in our industry. The nature of the building construction industry is unique. As I described earlier, it's very easy to cause disruption within our industry, and we have been home, regrettably, to this type of conduct within our sector for decades. And as I repeated, or as I indicated earlier, there is a mountain of evidence that justifies and has forensically examined the types of conduct that we get in building and construction workplaces. Its work is not yet done. The ABCC needs to drive generational change in the culture in the building and construction industry. And I say generational change deliberately, Senator, because if we look at the CFMEU today, most of its senior officials, including I think Mr Setka and a few others, are former BLF officials. That was the union that Bob Hawke deregistered, Senator, because he recognised, the government of the day recognised, that they were not holding up their end of the deal in relation to, I think it was wages and prices accord or whatever it was at that point in time. So if Bob Hawke kicked them out and deregistered them, they've ended up in our industry again as the CFMEU. So these characters are still out there, and we all know who they are. If we have an ABCC in place, it needs to be there so that it has time to do its work and that all of a sudden it doesn't get reefed away again. If you look at the history of construction and regulation, we had a Building Industry Task Force, then we had the first version of the ABCC, then we had a watered-down version of FWBC, we had another ABCC, and now we're not going to have anything. And throughout that point in time, even though we've had some consistency of coverage and core, I suppose, obligation, it has waxed and waned. But we need it, and it needs to be in place for quite a while. Otherwise, it can't affect this generational change. There's this culture within the industry. People just think they're above the law.
Oh, sorry, I'm just a little bit concerned. I'm a bit confused here, because I thought they've taken $6 to $7 million out of the ABCC, put it into the Fair Work. What are you telling me, the Fair Work's not going to have near the same powers?
Yep. Yes.
What?
No, the Fair Work Ombudsman will have nowhere near the same powers, Senator, as the ABCC. The Fair Work Ombudsman is not an appropriate replacement for the ABCC. ABCC had specific laws, specific powers. It could enforce the Fair Work Act provisions. It also could enforce its own provisions, but it is tasked with ensuring compliance with the rule of law in the building and construction industry. It is obliged to take action when it sees wrongdoing. The Fair Work Ombudsman's compliance policy or enforcement policy, I think if you look at it, I haven't looked at it for a while, but it's discretionary. It says, well, we don't have to take action if we see law breaking. If a small subcontractor in building and construction industry is being coerced, intimidated, or the subject of that type of action by a union, the ABCC is obliged to step in, and if that means providing representation to help that small subby, well, that's what they do. The Fair Work Ombudsman doesn't represent business. It can't represent
Okay,
business.
just remind me, because I remember doing this many years ago, what happened, and there was a lot of these subcontractors until that ABCC, well, really, something was going on with them. Can you just remind me? With the subcontractors, until that ABCC was brought in, that what was the issue with those subcontractors out there with the obviously the unions are a bit bigger than the subcontractors. They weren't getting the contracts or something. I just can't. Does that?
Yeah. Okay. So I think
Sorry,
Senator,
it's been a while.
Yeah. No, Senator. The situation is if you have a small group of subcontractors or smaller subcontractors in the industry, if they do not have the union EBA, if they aren't considered a good employer by the union, they don't get on construction sites. The reason they don't get any work on construction sites is because the CFMEU put pressure on the head contractor and they say, you employ or engage that subby, or that subby, there's hell to pay. And therefore, the head contractors say, okay, well, we'll use whichever particular contractor you like. However, under the ABCC laws, Senators, they can't do that. That is a breach of freedom of association law. They would be obliged to tell the ABCC, I'm being coerced in relation to the use of particular subcontractors because of either the instrument that they're employed under or they're not employed under, or they've chosen to be union members or not union members, and the ABCC would have to act. None of that will exist. None of that will exist now.
Mr. Smith, sorry, just when you're hitting the table, it's sort of interfering with the...
Sorry, Senator. I'm a passionate man about
No,
industrial
I remember you in 96. You're as passionate now about your position as you were in 96. Thank you.
As are you, Senator Sheldon.
As we all are.
As we all are.
Okay, so what's this look like considering we know working's slowing down, me talking to the tradies by March, April, you know, those home loans, they're all finishing up, everybody's holding their money tight. What does that mean for the subcontractor over there? We know the CFMEU has moved into other states. They're just standing there near the door, not even behind it, basically waiting for all this to go through for whatever reason that is. They're so excited about it. Why don't you tell me what's going to happen to those subcontractors out there? Just tell me what you believe is going to happen.
Well, from an economic perspective, Senator, there's a lot of pressure that's going on in the industry at the moment. We've had almost like an industry version of long COVID. We were not able to get building materials in the country for a long time, combined with fires, particular disasters and things. You have all of a sudden a big call for roofing, for example, I think here in the ACT at one point. So we've not been able to get those products through. We've had obviously delays in shipping and things like that with metal, concrete products. I mean, that's all shipped around the country as well. The impact, and I know from a Western Australian example, the impact of all of those shortages meant that the cost of building a new home, a 3-bedroom home, increased by about 20%, just because of the lack of availability of materials. We are starting to get across that sort of shortage, and the prices are coming down. But what it meant is that if you were a small subcontractor building a small residential house, for example, or a residential house, you might have said, I'm going to enter into a contract, I'm going to build your house for $500,000. Because of COVID and the delays and the unavailability of materials, all of a sudden, if you've got a 40% increase in the price of steel or timber, then that cost to the builders would actually put that project up, all of a sudden might be $600,000. So the builder's going to make a loss. And because of the way some contract laws operate, they can't get out of it. So they literally had to go and talk to clients and home builders, the individuals, to say, look, there's a real issue we've had here. And the good news has been, Senator, that on the whole, within the industry, even amongst head contractors and subcontractors, they've actually just realised fair's fair. Like, no, this is no one's fault. We're just going to have to deal with this. Let's get on with it, right? And that's been a pleasing part. But there's a lot of pressure that's going on in the sector. Labour shortages is one of the biggest issues we've got at the moment. I had a look at SEEK this morning for construction jobs in Sydney. and not that I'm looking for another job, but who knows. A project manager, site manager, minimum $230,000, $240,000 a year plus a car. A tradesman, $180,000 a year. A labourer, $50,000 to $80,000 a year. We are that caught short of staff in this industry at the moment. I'm aware of situations where literally one employer will try and entice a good tradie away from another employer by offering them a free Hilux. Like, that's a pretty big incentive. That just goes to show the problems we've got at the moment. So that's putting heaps of pressure in terms of the cost of doing a business. But it also means that some of the concerns that are often put to me about things like, underpayment of wages or people having their, getting paid below the award wages, I say to if anyone says that now, ring me. I don't think anyone in this industry right now is being underpaid. The market rates are very, very, very good, very good. So look, in terms of the smaller subcontractors moving forward, they're always the ones that take the brunt of these type of changes. They're always the ones where the pressure is applied. It's either applied from the top down or from the bottom up. Even though they are our members, the larger building companies are effectively project managers. It's the subcontractors that do all the work. They're the ones that have to put up with all of these types of changes. They're the ones that will have to ensure that they're compliant with all these types of laws. And they are the ones who really do struggle with the ongoing compliance in this sector. Senator, I'll finish my answer with this. If I can relay to you a conversation that I heard recently. I was at a forum where one of our members said that they have a staff of 50. They, in the space of 2 years, went from having one person whose half their job was compliance to now having 4 people whose role specifically is ensuring compliance with all various laws and regulations. That same company said that over the last 12 months, they had done double the amount of work they had done the previous year, but their profit was half the amount of the previous year. So the industry is sort of working harder, but the margins are very, very tight. Very, very tight. And look, there's always a degree of volatility in the sector. And regrettably, Senator, it's often the smaller contractors that suffer first.
The other thing I want to know, and I don't know why I haven't picked it up, what is the National Construction Industry Forum? Because it sounds to me like it's a forum at a table. What is that?
That might be a question better for the government, Senator, but
what do you believe it is? I'm just a bit confused. It looks like we're having a forum.
Yeah,
it's a substitute for the ABCC or something. Do you know anything about that?
So, look, it was an announcement made at the Jobs and Skills Summit, Senator. I understand it was a forum that's designed to look at some of the common issues in the building construction industry. Mental health was obviously one. Workplace safety is another. The commercial conduct in the sector. I mean, there's a lot of particular features of our industry, which aren't good features, that we need to tackle. There is a great deal of merit, I think, in getting people in a room and talking these issues through and seeing what can actually be proactively done. That said, I know that the remit of the committee is fairly narrow. It's got the capacity, from my reading, to make recommendations to the government, but that's it. And look, it's not going to be an ABCC in any way, shape or form, Senator, number one. I hope that it does good work. I hope that the people involved in that committee can actually talk to each other. And I do think that that's a big part of why there is such an ongoing significant cultural issue in our industry. So putting them in a room to talk about it is something we're not opposed to. We just hope that it actually achieves something.
Senator Lambie, do you want to do a last follow-up question?
Oh, just one question. I won't do a follow-up, but this is just a quick question though. But is it true in Victoria that unless you're unionised, unless you're a unionised construction company, when it comes to getting state government contracts, more than likely you're not getting one?
That is something that's put to me on a regular basis.
Okay. Does anyone have any numbers on that? Does anyone looked into the Victorian government in the last 4 to 6 years or 8 years to see how many of those have been in that area and how many of them have been normal people out there that haven't been unionised?
So, Senator, the problem we have is that if you do state government-funded building work in Victoria,
yes,
you are subject to a procurement code. That procurement code requires that you have an enterprise agreement with a registered employee organisation. It requires that you put in place measures, well, it doesn't say that you can't employ casual employees, but it says you have to have in a plan your strategy to remove casual employees, and it requires a whole raft of additional sorts of obligations, which effectively mean only people who've got enterprise agreements with the union can meet those obligations. There is a very similar system that operates here in the ACT.
Right.
It's called the ACT Secure Local Jobs Code, and there's a very similar one in Queensland as well. That's called the Queensland Procurement Best Practice Principles. In that particular situation, when you talk about the best practice industrial relations principles, in the explanatory or the guidance material, if you click a particular link, it takes you to the Fair Work Commission's decisions on union enterprise agreements. So it all but says you've got to have a union EBA in order to get work.
And that's all happened in the last 6-8 years or something, has it? With
That
that stuff
happened-
in ACT
Victoria-
and Queensland?
Yeah, Victoria has always had one, but it's been substantially sort of updated recently with a whole raft of new unreasonable impositions, I would say. The ACT one's been in place for about 5 years now.
Right.
And I can tell you in relation to the ACT one, Senator, there is in fact an investigation going on by the local or ACT Crime and Misconduct Commission because it's understood or it's alleged that a particular contractor was knocked back from a job simply because of the role that they held within master builders. And I understand that investigation is ongoing, and I'll make no assertions whether that's true, but there is an investigation ongoing.
And Queensland?
And Queensland was in place it's probably in the last 3 or 4 years it's really been updated. I know it's been updated
So it's all
twice.
under Labor?
Yes.
They're Labor governments. Thank you.
Senator O'Sullivan.
Thank you, Mr. Secretary, for your time and your submission. I just want to go to something you've said in your report in your submission on page 4. I read, the bill contains several elements that will give unions a greater say over workers' terms and conditions that are available to those actual workers to whom the conditions apply. Why do you say that? This bill is, from the government, said to be aimed at driving up wages, yet from this statement it seems that all it's driving up is increased union involvement in workplaces.
Well, we say that because there are several elements within the bill. The one that comes to mind in the first instance is the changed boot test, proposed boot test. It requires that the Commission give consideration to the views of those that are going to be covered by the agreement in determining whether it meets the boot, but it must give primary consideration to the common view of an employer and a bargaining agent that is a registered employee organisation, effectively a union. So what that means in practical effect is that if you make an agreement and you submit it to go past the boot, if the union says, we don't think this is going to meet the boot, but the employer believes it does, well then the Commission will go through the existing process, which is extraordinarily detailed and complicated, and that's what will always happen unless the union says that they believe it passes the boot. So it effectively means that a union can veto any type of enterprise agreement or at least stall it. And I can tell you, Senator, from being involved in this directly on numerous occasions, there's nothing more frustrating than spending a lot of time negotiating an enterprise agreement, filing it with the Fair Work Commission, and then having it held up, delayed or whatever because of a minor technicality or some other particular application of a hypothetical, which is never going to happen. There was one matter I'm aware of, Senator, where the Commission knocked back the approval of an enterprise agreement on the basis that they thought it was not genuinely agreed. The reason for that, or included a number of reasons, but one of those was that when the employer conducted an information session with the workers, literally did a page-by-page turn of the agreement versus the award. Here's all your legislation. It was all there for 2 hours. And at the end, the manager or the site supervisor said, is there any questions? And nobody put their hand up. Now, after 2 hours, probably there might be a reason why you want to put your hand up. That said, the Commission said, oh, well, just because they didn't put their hands up didn't mean that they understood the agreement. So I don't know what you would have to do to actually get someone to genuinely agree. Now, that is the second part of this particular concern here, is that there are elements in this bill which are expressed sometimes as unnecessary technical red tape, but only when it involves a union. If a union's not involved, those same red tape and rules become safeguards all of a sudden. The whole sort of feel of this bill is workers and employers, who we say should be the most primary and important parts of the employment relationship. They should be the focus of the system. It's almost like they're left to one side. It's all about focusing on unions. It's all about focusing on compelling people to bargain. I was looking at the supplementary explanatory memorandum for the amendments moved earlier today, and I think I remember this one, page 41, actually has a title that says ensuring genuine agreement of the employer. It's like, well, hang on. Enterprise bargaining doesn't operate that way. Enterprise bargaining operates in a way where you have a minimum set of conditions or a safety net like we do when you have awards, and then workplaces, if they want to, can genuinely agree to negotiate and put in place arrangements that suit themselves, subject to meeting the law, right? I mean, that's the way enterprise bargaining should be. It needs to be focused on the enterprise level. I think 10 years ago, 15 years ago, I suppose now, we had Julia Gillard and Kevin Rudd standing in front of us, all IR practitioners, saying, I will never ensure...
Mr. Smith,
sorry.
If there's additional matters you want to put to the committee, then you are very welcome to put them in further submissions. If there's a question asked by the Senator, in light of the amount of time that we have, we're well over time, but I'm not saying that's your fault, it's the system. I'm not taking responsibility for it, or the Deputy Chair or anyone else on the committee, of course. But if you could just contain to the question, if you want to put further submissions to the committee, you are certainly welcome to.
Certainly.
Is there a final follow-up question?
I don't mean to be rude, Chair, but I haven't been up here as long as this. I haven't done IR law, and it's actually interesting to hear what's gone on in the past. I'll be honest with you, I think it's extremely valuable to listen to what he has to say in this area.
I respect your views, and certainly if there's questions that need to be asked from the committee members, as I've allowed Senator Lambie for additional time for committee members, including crossbenchers, then I'll continue to do that.
Thanks, Chair. Look, I certainly concur with Senator Lambie. I'm finding your input very valuable. I think I got the substance of my question answered, though, so thank you very much. Chair, I'm happy to pass on.
Good, thank you. Senator Barbara Pocock.
Choose your Pococks.
Sorry, David Pocock. Senator David Pocock. My apologies.
Thank you, Chair. Thanks for your time today. Appreciate the last 24 hours would have been big getting across the amendments in the House. I'm interested to learn about what employment instruments are sort of used by your members in the workforce, the EBAs, awards, individual contracts. What does that look like at present?
At present, it's either the award or enterprise agreements. The enterprise agreements tend to feature on larger building sites, CBD sites, and a feature of commercial construction and civil and engineering construction, the freeways, the hospitals, things like that. There is the residential sector that is not renowned at all, really, for having enterprise agreements. They tend to use the award. They tend to be small employers, and they're working in small cohorts. And many people have put to me, Senator, that the reason why the residential sector doesn't use enterprise agreements is because it's too hard to organise on residential building sites, but it's very easy to do that on CBD building sites. And once you have I can't think, to be honest, Senator, of any major project in a CBD in Australia for the last 5 years that not had an enterprise agreement. So it's the sort of bigger projects.
And do you have an idea of what wages have been doing, potentially in those two different sectors?
So they are kind of, it's hard, I should say, Senator, one of the things about construction is there's no neat delineation between the various subsectors. So it's not easy to say, well, you work in residential, you're in engineering, you're in civil. whatever, people tend to work in between. I mean, you could be a specialist window installer. One day you could be doing a commercial job, something like this. Then the next day you could be on a reasonably sized residential job. You're sort of moving in between the various parts of the sector. The rates of pay have been consistently increasing, obviously, in our industry over the last 5 years. Over the last 5 years, it's been probably about a 5% standard increase in enterprise agreements.
Year on year,
5%.
or is...
Year on year. Yeah, that's 5% each year, cumulative. I'm aware that at the moment we're getting in the industry some reports of EBAs that are providing 7% a year increases cumulative year on year. But I should also tell you, actually I might be able to show you this, Senator, it might just be perhaps useful. This is just using the ABS data, and I'll provide this on notice. This is average weekly ordinary time earnings for construction, full-time, from 1995 to 2002. So that's a fairly significant trend, and it's always going upwards, Senator. I've not heard of a building construction worker that goes backwards in this industry. So everybody earns. It's not easy work, but it's rewarding work, and it's well remunerated.
Okay, thank you. And just a few questions about your reading of the bill as it stands. Does your reading of the latest amendments confirm that residential and commercial construction would be exempt from the single interest multi-enterprise bargaining stream?
So that is an important question, Senator. Our reading of that particular amendment is that it will create some practical difficulties if it proceeds in the way it's drafted. It also is drafted in a way which captures a lot of work which is primarily undertaken in construction but might be covered by a non-construction award. But it is our view that it appears that the attempt or that the intention of that particular change is to, for lack of a better word, carve out commercial construction, but also on our reading carves out residential, but that is something which we're still working through, to be honest, Senator. And yeah, so my understanding is it's broader than just commercial construction.
Okay.
Yes.
And to move to the how common interest is defined, do you have concerns around that, particularly geography?
Oh yeah, because I mean, look, if you're it's a competitive, very competitive economy sector, building and construction, and if you're a tier one a company and you're tendering for a big job, well, it's absolutely important that you know, or to try and work out what your competitors are doing. So there is an extreme anti-competitive element here. The very fact that we could be compelling big businesses or even small businesses to bargain together when they are direct competitors, that is a concern. It's a concern particularly when you're in the same geographic location. Your earlier question, Senator, about the rates of pay, I mean, there's always the sort of slight regional variations. But it would be a disaster if, for example, we had two competitors, one who was doing well, one that wasn't. They're compelled into something. One can afford the wage increases, the other one can't. But on the reading of the bill as it was first introduced anyway, that second employer wouldn't have any choice to escape that situation. And even with the bill as amended, I don't think it necessarily changes that either. This is, Senator, actually, I won't.
Okay.
I was about to make a further submission.
Just lastly, thank you, Chair. I understand we're running over. One of the provisions in there, as I understand it, is a limitation to 24 months of fixed-term contracts. I'm interested how are fixed-term contracts used in your industry? Is this a concern at all?
Yeah, look, I don't think that we are opposed to that element of the bill. It's not necessarily a common feature of our industry. To the extent that it is, I think it would fall within the existing exemption or the exemptions in that section of the bill. But look, I mean, I think I understand what that's designed to target. I am aware that that occurs. I'm not aware that that occurs in building and construction.
And is it your reading of the bill, is civil construction captured or not captured in the new multi-enterprise streams?
Not captured.
Not captured. Yeah. Thank you. Thanks, Chair.
I'll now go to Senator O'Sullivan has got you have a brief question? Sorry. Senator Barbara Pocock.
Thank you. I hate to call myself the second Pocock, but I am in this instance. Thank you, Mr Schmidtke, for your evidence and for being here. I wanted to pick up the question of productivity, which both Senator Cash and Senator White have talked about. I wanted to just ask about the EY study. When was it released?
It was released in, I think, May of this year. I don't recall the exact date.
In an election?
Yeah, it was in an election campaign.
Period?
Yep.
And ballpark investment in that study? What, how much did it cost?
I don't know the answer to that question, Senator, but at the same time,
Less than 50,000, more than 50,000?
I can't honestly tell you, Senator.
Would you be able to give that to us?
Well,
It's not-
Senator,
I'm just curious about how big it was.
well, I'm hesitant to take it on notice, Senator, because it's not necessarily a matter that relates to the bill.
You rely on it in your evidence?
Yeah, no, we do rely on it, but I'm not sure of the costs of the amount of expenditure. It certainly wasn't cheap. I'm aware of that.
Wasn't cheap.
Mr. Smith, can I just suggest if the Senator's asking to take it on notice, you'll either respond or not respond, and you'll give a response that is your response. So appreciate if you took it on notice. If you
yes.
what we derive from the fact you don't respond or what the response is, the committee will be a matter for the committee.
Understood.
So was that yes or no?
I will take it on notice.
Thank you, thank you. Wasn't cheap though. You described the EY analysts as very smart economists.
That's how they came across to me, yeah.
And did I hear you say you're not a smart economist?
You did hear me say that,
That was a joke, I assume. Are you an economist?
I'm not an economist either,
okay,
no.
Okay. I am,
Yes,
and
I'm aware.
I've sat on your side of the table a lot in the last 30 years, wave after wave of industrial relations reform, and I have had my reputation attacked directly by Senator Betts, for example, declaring that I was an unreliable researcher, and I'm concerned that you have made disparaging remarks about Dr. Toner, who I know personally, and you said his research was not to be relied on, that he was a well-known critic, and you dismissed and questioned his reputation. And I just want to give you an opportunity to walk that back. Dr. Toner, who I do know, has done work for the OECD, for the World Bank, for the ILO, for APEC, for most government departments in the federal relevant spheres of effect. He's published in every significant international journal in relation to employment and in Australia, and he's published books as well. So I just wanted to say that someone who spends their whole life in this field, and I'm going to go to his report in a moment, but just wanted you to have the chance perhaps to revisit your comments, because they will be a concern to the community of researchers that their research is undermined by a personal comment about their seriousness as a researcher.
So, Senator, the observation I made earlier, I can't recall the exact words. I certainly did not.
Well-known critic. Yeah.
Well, I think he is. Dr. Toner is.
Like the MBA is a well-known
Yes,
critic.
that's
That
right.
does not make them relevant people to listen to.
No, that's not my point, Senator. My point is that there are certain academics and researchers that I'm aware of, obviously not to the extent that you are, who, when it comes to building and construction, will often be brought into the fold and into particular debates. Now, after a while, I think to myself, when I can predict to some extent who is going to be the critic of a particular position that we adopt, it does naturally make me think, well, that criticism is always going to come, right? I'm not saying that it's not valid criticism. I'm not saying that we don't expect criticism in any way, shape or form. I'm not questioning Dr. Toner's qualifications or his experience or anything like that, but I am aware that a lot of the research that he produces is not supportive of building and construction, and does in fact contradict a lot of and cut across our positions. That's simply an observation of fact. It's not a question of his.
Mr. Toner is not a hired gun.
No,
he
I'm not
is
suggesting.
a very well-respected researcher, and this
suggesting
committee and all the preceding committees of various political complexions have relied on the research of people who had paid nothing to do their research. So now I want to go to his response to the EY report. He points out, and these are the words in the EY report,
Yes.
that the report represents solely the interests of the MBA, and it does not have regard to other evidence. And he points out that the modelling outcomes in the study are contingent, quote, on the collection of assumptions as agreed with the client. That is a very unusual form of modelling. There's no economic theory that would suggest you should ask your client for the assumptions that should be built into your model. The EY report, he goes on, appears to characterise all industrial action, including completely valid lawful industrial action, as illegitimate and as a cost. And he goes on to point out that the model, as Senator White pointed out, relies on a survey of 49 people of the 350,000 businesses in this area to construct what he describes as a very unreliable assessment of the productivity outcomes consequence on the abolition of the ABCC. And there's more. He quotes EY as saying they prepared the report for the benefit of the client, and that this is EY's words, and has considered only the interests of the client. Accordingly, Ernst & Young makes no representations as to the appropriateness, accuracy or completeness of the report for any other party's purposes. Now, that never gets in to the newspaper report in the middle of an election campaign about what the productivity costs of the abolition of the ABCC are. And I want them to be on record. I'm glad they are now on record, because this is not a reliable assessment of productivity changes consequent on the ABCC. But we do have, fortunately, a really good, reliable assessment of the productivity impact of the ABCC from our own very reliable ABS. The ABS national accounts, looking at output per worker in the construction industry over the 7 years immediately before and during the tenure of the ABCC, and I'm quoting from Dr. Toner's paper, between 2015 and 2021 fell by 6.3%. Over the preceding 7 years, 2008 to 2014, productivity increased by 25.6%. And I just want to hear your response to this very thoughtful and lengthy critique of the EY paper, including its assumptions and the fact that it's clearly a client-influenced piece of research, and your response to the ABS data about productivity.
Well, yes, I'll take that on notice, Senator.
Thank you. I'm done.
Senator, I would like to help you. I'm not an economist, so I didn't have those figures, write all those figures down. But what I can say, though, Senator, is that I am aware that the EY report did disaggregate protected industrial action versus other types of industrial action. So to the extent that that provides some clarity, I hope you can take that for what it's worth, but I will confirm that on notice.
Thank you, Chair.
Good, thanks very much. Mr Smith, there should be an article which I think I'm circulating to the committee. Gives us a chance to peruse it. Are you aware of that article?
No.
You have a chance to peruse it, have a look at it. If you could look at page 2. As you're considering that, the article's from the AFR reporter by the name of Hannah Wooten on the 5th of September 5th of September 2022. You'll note on the page 2 of that article, and this may be a very important point to the committee members, this is in relationship to Mr Brown, who wrote the report for the MBA whilst working for EY. Could you just read the four last sentences in that report?
Well, Senator...
Are you able to read it?
What sentence are you referring to?
It's from It's Not.
On page 2?
Yes.
Well, I can read that, Senator, but
Could you read it for us? Thank you, for Hansard.
Well...
We can all read it, Chair.
Senator, I'm not sure what benefit that's going to do.
Well,
if you want to put this into the Hansard...
Mr Smith, If you don't wish to read it, I'll read it for you.
Sure.
I understand why you don't wish to read it.
Oh, no.
It's-
Well, I'm happy to read it, Senator, if that's what you want to
Go
read.
ahead.
It's not the first time that Brown has twisted numbers for a client either.
And yes, and the rest of the sentence.
Oh, sorry. His economic assessment of an open cut mine in Rocky Hill, New South Wales for Gloucester Resources in 2019 was slammed by a New South Wales judge as incorrect for lacking evidentiary foundation, plus totally at odds with government guidelines.
So when you're making an assessment, about the CY report, which was only September 22, and you were working for the NBA at the time, is that correct?
September 2000. Yes. Yeah.
That in this report, quite clearly, as you've just read out, and you're saying you need to have an assessment and take it on notice. I can understand why you're taking it on notice, because quite clearly in this report, there's a damning response from that particular journalist in repeating allegations, and in actual fact, it slammed the credibility of Mr. Brown by a New South Wales judge. And as you've said, lacking evidentiary foundation, plus totally at odds with government guidelines. So I'm just saying, when you're looking at reports and the NBA is making submissions to this inquiry in other places and relying on those reports, I'd look at the validity of those reports that have been put forward and those that have written it. The second question is, this week, the Leader of the Opposition, Mr Dutton, introduced a proposed amendment to the bill that was soundly rejected by the House. Mr Dutton's amendment was that we revive the Morrison government's attempts to suspend the Better Off Overall test, which would mean, for example, a part-time level 3 retail worker would allow their hourly Boxing Day rate slashed from $50 to $22, or a part-time level 2 hospitality worker aged over 21 would allow their pay on New Year's Day slashed from $46 to $20. Do you support Mr Dutton's amendment?
I haven't seen Mr Dutton's amendment, Senator.
You were also verbally Mr Dutton, as you know.
He's not here for retail.
No,
This is ridiculous.
Senator Lambie, I thoroughly...
I object to the questioning. I just do not. This has gone way. This is getting ridiculous.
If you, no, so you can take a point of order and I'll
His
respond.
opinion on retail.
Senator Lambie, I respect that you have a view about asking questions on, and you've been aware there's been a number of witnesses by everybody in this inquiry today that have asked questions of witnesses that have on matters that are beyond their core industries. In actual fact, this particular witness has talked about issues that impact across different industries, as other witnesses have. I haven't stopped senators from asking those questions. There's a number of comments that Mr Smith has, within his own right, made comments about on the legislation very broadly. And it goes to this question, and that is, do you support, because I would expect that there will be, and maybe the opposition can tell us now that they're not going to put the Dutton Amendment to the Senate. That's a matter for them. But there was an amendment put by the opposition of this country that we should get rid of the Better Off Overall test, which will have substantial impact on many workers in many industries that rely on the award, and will reduce and slash wages in a number of circumstances by more than 50%.
Chair, with all due
We'll give that
respect,
opportunity.
that was not the amendment put by the Leader of the Opposition.
That is the effect.
It was not,
That is the
Chair,
effect.
and you know it. It was
That
a
is the-
second reading amendment in the first instance.
If you
which
want to take
set
a
out
point of order,
a
then
number
Senator
of
Cash, I will be more than happy to
I am
take
taking a
it.
point of order. I
Well,
would
that's not a-
prefer you
what's the-
actually
what's your point of
table
order?
you are verbal
You don't like the
leader of-
question.
Not at all. You can ask questions, but they should be questions that are actually based on fact. That is not. You are verbally the Leader of the Opposition.
Senator Cash,
and this,
after I finished asking my question of Mr Smith, I will allow you to ask him a question about the fact that of what your view is of
I
the
think
Better
you
Off
are
Overall
putting to
test,
him a question
and
that is
Mr
not based
Dutton's
on fact.
and the opposition leader Mr Dutton's position regarding and the LNP's position about amendments to this bill, because they are pertinent to this bill, they are pertinent to this inquiry. There have been a series of amendments put forward. This is an amendment that was put forward by the opposition, and the effect of that will be slashing wages for workers right
again,
across this
Chair,
country.
I'm happy that it's your time to shine. I've got no issues with that. That's what this committee is all about. But you are verbally the Leader of the Opposition, and what you have stated
If
is
you wish to, I've put that
factually
question to Mr
incorrect.
Smith. If he doesn't wish to answer it, that is his matter. If he wishes to answer it, then that is his matter. I will take as a result of that answer, what my view is about the validity or otherwise of what that answer is. Now, if you wish to ask a question of Mr. Smith, I'll allow that, even though we are at overtime, and I will allow that.
Chair, by way of process, Mr. Smith did say that he hadn't. Schmidtke, sorry, he hadn't seen the particular amendment.
Mr. Smith, I don't know what he is.
So
I don't know what you're talking about either.
Mr. Smith is, but
Nobody gets
he
it
did
right.
say that he hadn't.
Nobody gets.
He did say that he hadn't seen the particular amendment. So Ms. Schmidtke can respond if he wants, but he did say he hadn't seen it.
So, Mr. Schmidtke, are you aware that then I'll put you in this phrase on the basis that you've said you haven't seen the amendment. Appreciate the opposition didn't refer to the MBA before they put the amendment forward, which is disappointing. So there was no conversations with you or your organisation about that amendment?
I don't know what amendment.
So there was an amendment put very clearly put by the opposition to this bill, and they did not talk to you about it.
Do we have a copy of that amendment?
which
Because I don't know
amendment
what
are you
amendment you're
referring to,
talking
Chair?
about either.
Because even I'm now confused.
So
and
can you produce the document? Because
are you
I've
saying
got
the
no
amendment
idea.
that we don't believe that we should abolish the Australian Building and Construction Commission? That's been our long-standing position. We took that to a double dissolution in 2016 and won the election.
There was amendment put to this bill regarding the boot test by the opposition. It was an amendment regarding the boot test. Did you have any discussions with the opposition regarding an amendment to this legislation concerning the boot test and
No.
the substance of that amendment?
No.
Right, thank you.
In fact, Senator, if I can add, I was head deep in massive bits of legislation, and to be honest, I have not watched much of the debate on the bill. I've only read parts of the Hansard.
I respect the fact that you've said to me that the opposition unfortunately failed to consult with you about that amendment.
That's not what he
honestly
said.
becoming
And I didn't say
That's not what he said.
Chair,
And I'd
you were
also-
actually
and I'd
doing
also-
a really
That's
good
'cause
job.
And I'd also,
Everybody was behind- now it is
excuse me,
becoming
I am asking the
farcical.
questions. I know this is your time to
This goes
shine
to
as
show
well,
exactly why
Senator
no one's
Cash,
got
and
time.
and I'm shining is one thing, but actually allowing me to ask my questions is another. Now, I will then ask a follow-up question to that question. Are you aware of the boot tests that was put forward by the then government, now opposition, with the omnibus bill? Are you aware of those changes?
Are you referring, Senator, to, was that November 2021 or thereabouts? Yes, I'm aware of that legislation.
Thank you. And if that legislation was put forward again, would you support that proposition regarding the boot test?
Now, Senator, can I ask you to just be clear, what particular part of that boot test are you referring to?
All the respects to all the matters that were put forward in that legislation regarding the boot test by the then government, now in opposition.
Master Builders did not support all of the amendments contained in that particular bill.
Can you explain to me why the opposition didn't talk to you about the boot test that was put forward in Parliament this week, the variations and amendment to this bill?
I
We haven't had time.
Thank you. And I have no further questions.
Chair, could I just correct you, dear?
I did offer.
Just a
Senator-
correction. No, and I do
Senator-
appreciate that.
I did offer
I will
Senator
say-
Cash
I will
to
behave.
shine for her moment as
I
well.
will, and it's not that I would like to shine. I would just like to ensure that the Hansard record
do
is
shine, no,
correct.
it's all right.
It was a second reading amendment. It contained several parts, and the part that Senator Sheldon is referring to is part 4. And the words commence with, the government should work with the opposition, crossbench and other stakeholders to make improvements to the Better Off Overall test and changes to enterprise bargaining as outlined in the former coalition government's legislation introduced in 2020, which Senator Sheldon, you would know, was introduced as a result of extensive consultation with unions, employers and industry and as a result of COVID. I'm disappointed you didn't want to work with all parties to ensure that we could get legislation into a form that we could all agree.
And that legislation was soundly rejected, as you're aware, Senator Cash. And
It is disappointing that a proposal put forward was not consulted with one of the very close associates of the opposition and then government, the MBA.
Chair, with respect, I think we can debate this on the floor of the Senate. I'd love to move to the department if we could.
I think Mr Smith made his position very clear. Thank you. Now, if you've taken any questions on notice, if you could please provide the answers to the Secretariat by the close of business Monday, the 14th of November 2022. And thank you very much, Smitke. So I will get this right. So, but thank you, and after all these years, my apologies.
All good,
Thank you,
Thank you.
Mr. Mickey.
Thanks, Senator.
You got me stumped.
And now we're just going to have a 5-minute break. So, thank you. We'll just suspend. If we go, yep. I now welcome in person representatives from the Department of Employment and Workplace Relations. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Thank you. Anne Sheehan, Chief Counsel of Workplace Relations Legal Division.
Jodie Anderson, First Assistant Secretary of the Safety and Industry Policy Division.
Greg Manning, First Assistant Secretary, Employment Conditions Division.
Thank you. I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Chair, we thought in the interest of time we wouldn't prepare our opening statement today and thought we would just let the committee get straight into questions.
Thanks, Ms Sheen. Senator Cash.
Thank you very much, Chair. And look, I know that time is short, so I will be placing a number of questions on notice, and the Chair will take you through that process, which you're completely familiar with. So I would ask, to the extent that you can keep your answers as concise as possible as well, it will assist. If I could just go to the overview of the bill, and the explanatory memorandum states the bill would amend the Fair Work Act and related legislation to get wages moving, boost job security, tackle gender inequity and restore fairness and integrity to the Fair Work institutions. So just in terms of wages, if and when this bill passes, when do you expect wages to start increasing as a result of this legislation?
So Senator, the bill is premised on fixing or improving a number of areas of the Fair Work Act that the government believes are holding back wages. Ultimately, when wages increase will depend upon the actions of many different actors, whether they be employer reps, unions, Fair Work Commission. If you go through the separate aspects of it, in relation to bargaining, for example, I don't have the latest Fair Work Commission stats, but I know, for example, they look to approve a simple enterprise agreement, 95% of them in under 3 weeks. There is a number of statutory timeframes that have to be gone through in terms of the bargain itself, which parties might meet, so it might take a number of months. Some other aspects of the bill, for example, those in relation to the equal remuneration panels equal remuneration orders and the gender equity and the care and community sector panels will be in place for when cases are brought under those provisions of the Act.
From what I got, there was no answer to when do you expect wages to start increasing as a result of this legislation. Can I move on then to by how much do you expect wages to start moving as a result of this legislation?
So, Senator, as I said earlier, I don't think your categorisation of my answer was quite correct, in the sense that the bill will put in place a number of measures throughout the Act that will enable those actors in the Fair Work system to take action that make it more likely to get an increase.
What happens
in
if they
wages.
don't take that action, or what happens if that action is strike action? Based on what you've said, they've got to take certain action. What happens if they don't take action?
Well,
no action's taken?
Well, over a number of years now, both employers and employees have said that certain changes could be made to, for example, the enterprise bargaining system that would promote greater bargaining. We have evidence that over each of the last 10 years, the average increase from bargaining is higher than non-bargain outcomes. So if employers believe that they're able to get productivity improvements in return for increased wages in a tight labour market, then you would expect that they would take action to commence bargaining, the bill puts in place a number of measures to improve, for example, the bargaining process, which is what, as I said earlier, many employers and employees organisations have said over a long period of time is needed to get bargaining going. The levels of bargaining has declined quite greatly, particularly in some industries, and therefore increasing bargaining rates will increase wages based on the evidence of wage outcomes as a result of bargaining compared to other sources.
Can you take me through the modelling that was done on the potential level of wage rises when preparing the bill?
So I sort of touched on briefly in my last answer the need for the bill. So as I said, there's been quite a big decline in bargaining. So at the moment, as at June 2022, only 15.3% of employees have their terms and conditions governed by a current enterprise agreement. There's been a 47% decline in the number of applications for approval of enterprise agreements over the last decade, so 2010-11 to 2020-21. There's been really big declines. I think I said at estimates on Tuesday, if you look at the accommodation and food services, the number of current agreements has fallen 75% in the last 6 years. So that goes to the need. As I said earlier, enterprise agreements lead to bigger pay increases. The headline figure is a bit distortionary, I think, in the sense that it's the average weekly earnings of someone on an enterprise agreement is 71% higher than award-reliant employees, and that premium differs across different industries. So, for example, in the health and social assistance sector, it's 25% more earned on an EA than on an award. I've said a couple of times now that the history of wages growth over the last 10 years shows that wage increases have been greater under enterprise agreements than generally. So that goes to the need to do it. Oh, sorry, I've missed some important aspects of the bill. Of course, other aspects of the bill go to the gender pay gap and systemic reasons for underpayment in feminised industries. And so things like, whether it be the objective or the introduction of reforms to the Equal Remuneration Order scheme, or the panels themselves will go to pay increases there as well. In terms of the actual impacts, I think the impacts of the bill will be measured in the same way that improvements to the workplace relations systems are generally, through broad labour market indicators such as employment rates, wages, which I've touched on, closing that gender pay gap.
Well, that's an interesting point. So what you're saying is, if the gender pay gap doesn't decrease, if wages don't go up, and we'll get to wages going up higher than inflation shortly, there might be a bit of a problem with the bill?
Well, one of the aims of the bill is to improve wages.
That's my whole point. You can't tell me by how much wages are going to increase. You cannot tell me when they are going to increase. You have given evidence to the fact that employers will be encouraged to undertake enterprise bargaining because you're taking action in relation to certain parts of the system. Well, the bad news is yesterday, employers across Australia, the AI Group, the ACCI, the BCA, the MCA and the National Farmers Federation put out our joint statement saying the bill won't do that and it is not fit to pass the Senate. So can I ask on what basis you say employers will take action when they have said this bill is not fit to pass the Senate and they are opposed completely to what is happening to the single interest test and multi-employer bargaining?
You focused on one aspect of the
Correct.
bill there.
One aspect.
So,
let's focus on that aspect.
Well, no. Well, I hadn't finished my answer from earlier, in terms of going back to the fact that a point I've made a couple of times now, that ultimately the outcomes of the bill, many aspects of it will be dependent upon the actions of a number of independent parties, whether they be whether they be employers or unions,
so on that,
or the Fair Work Commission. And so, you asked a question about modelling. So,
Yep.
and the point I'm making is
So I was asking what modelling was done, if you could take me through the modelling and potentially table
No, I'm
it.
making the point that given the number of independent actors whose actions and decisions and attitude to the aspects of it would be required, then there'd be so many assumptions that would have to be made about that behaviour that the modelling, it doesn't really lend itself to abstract modelling.
Understood. So if no action was taken because no employer wanted to enter into this or did not want to be compelled into it because they didn't want to actually bargain with their competitors, one would think that would say wages won't get moving.
If I may, Senator, so I think it's important to look at, again, as Mr Manning was saying, there's a range of amendments that are being made to the Fair Work Act. So it's really important to note that, particularly adding to the recent government amendments that were moved as well, there's a strong focus on the primacy of single enterprise agreements within this bill. So there is a strong focus of obviously those that are currently on single enterprise agreements, that they are being encouraged through the bill to stay on those agreements, to renegotiate those enterprise agreements, and certainly there's been amendments that make sure that that's able to happen.
I thought the whole point was to get more people onto enterprise agreements. You're currently referring to enterprise agreements that are already in place.
Sorry, I was just going to also note as well, so in terms of the bill as well, there's been some key changes to the Better Off Overall test. Those key changes have been supported by industry groups. I think in terms of those boot changes, they have been, it's been very clear that both unions and employer groups have been very supportive of those changes to the Better Off Overall test. Having looked at this particular issue over many years now, much of the evidence goes to concerns around the boot and the implementation of the boot, and the department is of the view that those changes to the boot in itself will attract more people into enterprise behaviour.
Well, that's interesting that you say that, because the changes were tabled some time ago, and the statement issued by the employers was issued on Wednesday the 9th of November. So unfortunately, I'm going to have to put it to you that potentially they don't agree with what you have just said, because they state very clearly the bill as currently framed should not pass the Parliament. So they don't agree. They think the bill should not pass the Parliament. It's there in black and white. And they jointly call on the government to permit time for a thorough consideration of the content and implications of the bill. It also states, despite your comments, the legislation as drafted does not reflect broad consensus arising out of engagement with industry at the Jobs and Skills Summit or subsequent consultation. And it is crucial that these proposals are thoroughly examined. They then say the National Employer Associations are particularly concerned that the bill unjustifiably expands the scope for multi-employer bargaining, fails to articulate clear parameters around where multi-employer bargaining would be available, and either the supported bargaining or single interest streams, undermines the system of enterprise bargaining, despite the evidence that has been put forward, of enterprise bargaining that has delivered many significant benefits to Australia over several decades and currently operates effectively and in many sectors. The currently proposed framework for arbitrating bargaining disputes also risks unreasonably subjecting broad sectors of the economy and community to the centralised settings of terms and conditions over and above the comprehensive system of the modern awards already in place. The new laws would not deliver any identifiable path to productivity improvements that Australia so badly needs, and that are the key to delivering sustainable improvement in wages. So, Mr Manning, what modelling was done in relation to the improvements to productivity that this bill will provide? Because clearly the employers are wrong, so we need to correct the record there. What modelling was done in relation to the key productivity improvements, which, as employers say, because they are the job creators of this country, are key to delivering sustainable improvements in wages?
Senator, before I go on to that, I might come back to finish my previous answer.
Let's move on. You've given me enough evidence there. We don't have enough time. But you
just-
can put it on... No, with all due respect, you can actually put it on notice for me.
Just everyone stop for a moment. Senator Cash, you did ask a question. The official's trying to give an answer. I am being mindful that the official gets a chance to give an answer. If it is getting... if it's wavering off, then I will, by all means, make a point of order and we can deal with it then.
I'm coming
Mr.
back.
Manning.
Thanks, Chair. I'm coming back to the question in relation to the aspects of the bill that will get wages going, and we went on to discuss bargaining. There are aspects of the bill in relation to equal remuneration orders, for example, where parties will be able to bring matters to the Fair Work Commission under a revised test where there is a route through to improve wages that are currently undervalued in a way that is consistent with the interim decision in the aged care decision that was handed down last week.
Can I just go on to, again, a different section of the bill? I'll put a whole lot of questions on notice. What level of wage rise would the department consider a successful outcome for this bill?
Well, I might continue on from my current answer. The department's interest is in a framework that permits work to be properly valued and for the system as a whole to work. So that's not a there'll be the outcomes will be different in different industries. Sorry, Senator.
I was talking to Senator
Lamb. Yeah, so it's not for the department to put a figure out, but as I said earlier, it'll be judged by a number of labour market indicators as to how the system's working overall.
Could I now just jump to the effect of new section 2AA in applying paragraph 1862B of the Act? What is the effect of that section? And what does the definition of coercion in section 186 of the Act include?
Senator, are you referring
Was it Amendment
amendments?
119 as passed by the House of Reps yesterday? Now we know how employers feel, especially small business employers. Page 25 of the amendments.
Just while they're getting their paperwork together, I'm just mindful that you've gone over your time, which I'm happy to give you a little bit of extra time, and if you could just confer with your partner.
Absolutely, yep. The point I'd like to make here is, given that there are 15 people, I understand, representing the department, and they are not able to tell me like that, given they would have anticipated there'd be questions on the amendments, God only knows what small businesses across this country are going to.
Senator Cash, you've certainly been in more estimates hearings than I have.
No, but to be fair, that's the whole
I've certainly been in
point.
estimates hearings for 3.5 years, and it is not unusual for people to actually consider their position, let alone questions.
So does anyone have an answer to the this new section? I'm looking for the rationale as to why it was put in.
Ms Sarah Godden, Senator, Assistant Secretary and Senior Executive Lawyer, Bargaining and Coverage Branch. The term coercion is used in other places in the Fair Work Act, as you'll be aware,
Yes.
including in section 343. The effect of new paragraph 2AA is that the Fair Work Commission must disregard anything done and the effect of anything done by a person other than one of the employers who bargained for the agreement that is authorised by or under the Act. So, for example, it would provide that because an employer has been compelled into the authorisation, that does not mean that they have been coerced by the Fair Work Commission in making that authorisation.
So can I also confirm the effect of the amendment makes it explicitly clear that anything done by the employee or the union done under the umbrella of industrial action is permitted when negotiating an agreement?
Protected industrial action,
Yep.
Certainly, Senator, and that is consistent with the position in section 343, for example, which defines coercion in the general protections.
In terms of the beginning of the process is currently voluntary. It could be found that an employer was coerced into join the bargaining process.
I'm sorry, Senator, were you talking about the single interest employer
Yep.
authorisation
Yep.
stream?
Yep.
So, yes, at the moment it is entirely up to employers
Yep.
if they wish to use the single interest authorisation process to make a single enterprise agreement. where the test for the single interest authorisation currently provides that if employers are consenting to go into the stream, that they must not be coerced into consenting.
I'm just trying to work out why this amendment was necessary, and it just appeared. What was the rationale behind the amendment? Why wasn't the current section considered to be adequate?
For example,
Sorry,
Senator...
Before you answer, sorry. Senator Cash, we've given close to 20 minutes, which is, as you know, quite unusual.
I will hand to Senator O'Sullivan.
It's quite unusual for someone to do that, but I wanted to let you get your train of thought.
This is quite genuine, this one,
allow-
because I've got a lot of people asking about...
Allow others to consider what the questions you've asked.
I think we could answer quite briefly.
If you could answer.
I mean, I would describe the reason for the amendment is for clarification, that because the single interest stream now has the ability to enter that stream through an MSD process, we wanted to clarify that if an employer was brought into that stream, otherwise than through consent, then that wouldn't impact on the genuine agreement, the Commission considering the genuine agreement of the employer to an ultimate agreement reached.
I will put some further questions on notice on that particular amendment, and I will put a whole lot of questions on notice.
Thank you, Senator Cash. Senator Barbara Pocock.
For now, I'm still thinking.
Yeah, thank you.
I'm so sorry. I didn't realise that. I'm so sorry.
Senator Lambie.
You've got to go from that. Keep going. Hi guys. Under the section common interests, it lists 3 conditions for identifying a potential common interest: geographical location, the regulatory regime, and the nature of the enterprise. Can you confirm that to satisfy the common interest test, it does not need to satisfy all 3 factors?
Thank you, Senator. One of the criteria that's relevant for entry into that stream is that employers have clearly identifiable common interests, and then the bill gives some examples of a common interest. It's not an exhaustive list. One of the other requirements that needs to be considered by the Commission is that views have been put forward by employers and the bargaining representatives on their views on whether an authorisation should be granted. So they are examples of what could be considered a common interest. There could be other examples that are relevant as well. So it's a non-exhaustive list of what might be a common interest. And the parties would, in seeking an authorisation, the parties would put their views forward on the factors they felt were relevant to an assessment of clearly identifiable common interest.
So you don't need to satisfy all 3 factors then? Is that what you're telling me?
That's correct.
Okay. The legislation says that a common interest between 2 employers that could be compelled to bargain could be a geographical location. Can you please tell me what the government means by a geographical location? How is that determined?
So, Senator, again, as Machine just indicated, that is one factor that the Fair Work Commission may consider.
Yeah, but what is it?
So the intent of including a geographical location is actually intended to I suppose, to minimise those that might be covered by the common interest test. So this is one of the pieces of feedback that we received through consultation, obviously concerns that broad coverage might be, people across large geographical areas might be covered. It's actually intended as a narrowing example.
Why don't you give me an example in real terms on what that would mean? Which businesses, if you just add 2 of them together, 3 of them, what does that mean? Does it mean a shopping centre and all its shops? I'm sorry, no one can give me a clear answer, so if you can just give me a clear answer.
It may help, Senator, if we just highlight, though, in terms of the process of, I suppose, entering into a single interest authorisation process. So there's two ways of getting into a single interest authorisation. One is by consent, or one is by where there isn't consent of an employer. So where there's consent and the employer and the employees, they're keen to go through this process, they will still have to go through the test that's identified in the legislation. So it's not just, yes, we want to go into this single interest authorisation process. They actually still have to go to the Fair Work Commission. They'll still have to go through the test, and the test has got a number of elements to it. The common interest aspect is one element. There's also a public interest element to it. And I think the Minister, in explaining to the House this week, has been very clear in terms of that public interest test. And again, the EM was also very clear about the sort of, I suppose, sectors and issues that public interest test should focus on. And really that's, the EM's very clear that it's about the Fair Work Commission in considering approvals where it might, or, you know, bringing in people into the stream where, or not bringing people into the stream, I should say, where it might inhibit a race to the bottom on wages and conditions. There also needs to be consideration of the views of the parties. So there's multiple factors for the Fair Work Commission to consider, not just this concept of being a common interest in its own.
So, okay, so if two businesses are located within a kilometre of each other, do they share a geographical location under the common interest test? I mean, how many kilometres? You know, how big's the area? What does this look like? Is it each state or each little part in each state? Electorate?
It may assist to look at the common interest test, like some of the other tests that have been introduced, are actually shifting away from a series of very prescriptive rules and trying to give a broader discretion to the Fair Work Commission, which is the expert tribunal in this area, to make these decisions having regard to the particular facts and circumstances of the case. So in your example, if you had those shops that were co-located or within a close distance of each other, the Fair Work Commission, in considering each one of the factors, would get to the common interest test and look at the guidance that's been given in determining, as one of the factors in determining whether it was appropriate for these parties to be bargaining together, look at the interests in which they had in common. They wouldn't just look at, or the Fair Work Commission wouldn't just look at the geographic location in isolation. The examples are listed as various aspects of the characteristics of those parties that the Fair Work Commission would be expected to consider. So they wouldn't just be looking at geographic location, they wouldn't just be looking at whether they shared a regulatory regime or the nature and size of the enterprises. We would expect the Fair Work Commission to take a very holistic view of what those enterprises were, but the legislation is designed to give the Fair Work Commission a broad discretion as the expert tribunal in arriving at that answer, but having regard to each factor in that test, of which the common interest factor is only one. That's why we can't give you a prescriptive answer, because it is a broad discretion with the guidance that's been given in the legislation with the examples and the guidance in the
that will be determined by the Fair Work.
They will have to determine.
So there's no geographical radius. It's not within 5 kilometres. It's not within 10. It's not whether it's in your backyard.
The Fair Work Commission will need to be satisfied that the parties have clearly identifiable common interests.
So if you have retail stores, would any two retail stores be considered as having the same nature?
So again, I think, Senator, it's quite important to, and we can take you through, say, for example, the test at the moment. There's quite a lot of factors that are considered, and they're all considered in a holistic way.
Let's pick some shops out. So let's say we've got a butcher and we've got a news agency, and let's say we've got a chemist. Okay, would they be considered as having the same nature?
So, Senator, all I can do is to explain to you in terms of how the process would work. So, for example, if there was a set of shops that did want to negotiate together, then they would still need to meet a range of all of these tests in together. If they didn't consent, they would have to have their employees do a majority support determination before they could even enter into the stream. So if their workplace decided, hey, we don't want to enter into this stream, then that first hurdle is they're not even considered. if they then say half of their workforce do say, no, we do want to work into this stream, then there is that scope that then they get considered as part of the broad test, but it's not just on geographical location. It has to be, as Ms Godden said, there needs to be consideration of a public interest test, there needs to be views of the party. So this concept that I know people are concerned about just geographical location somehow dragging people into a stream is not how, it's not how it works.
How do I sell that and tell my small business that when they've received nothing in the mail, no emails, and explain all that into technical terms in the next week, when 2 days of these I'm going to be in here with you people?
If it assists, Senator, there is a small business exception to being compelled into the single interest employer authorisation stream that uses the current definition in the Act in section 23.
It's not just small business though, there's other businesses, medium businesses out there. How have you guys reached out to them and tried to explain all this to them? Because nobody else seems to have done in the amount of time we've done.
So, Senator, as with any legislation, obviously we, subject to the passage of any legislation through the Parliament, say within the workplace relations framework, then we have agencies that are responsible for implementing the legislation. So, for example, in the bargaining space, we have the Fair Work Commission that's responsible, obviously, for overseeing the bargaining framework. They have got quite detailed information provided on their website. As part of the budget process as well, the Fair Work Commission was provided some funding as well to specifically support small business. I don't have the figures on me, but Mr Manning might have those figures in terms of how much was provided to the Fair Work Commission. But in terms of small business particularly, we do recognise that, or the government recognises that they may need some additional support to understand the bargaining framework, and that support will be provided to the Fair Work Commission.
That's great when you've implemented it, when you've put the bill through. Wouldn't it be out of respect to these small and medium businesses that they probably know this before? Wouldn't that be respectful of them? Would I have to ring every one of them up and say, hey, go get a lawyer, because this is really bad?
Senator Lambie, I think you're asking for an opinion of the department.
Okay, let me rephrase my question. I'm asking the people that made these decisions, when were small to medium businesses notified that this was the bill going through? Whose responsibility is it to notify them? And please don't come into me there with the small business groups. As a government, whose responsibility is it?
In terms of consultation through the development of the bill and small businesses, we've had a number of meetings with COSBOA. So in terms of interests of small businesses, then there have been a number of meetings with COSBOA as well as other industry and employer associations as well. So we've been consulting through those, I guess, peak bodies. In terms of availability of information for those in the community to understand what the bill is at a simple, high-level nature, there's fact sheets available on the department's website.
That's lovely. Who's put that out to the small and medium businesses so they can get a fact sheet? Did you send an email to them all? There must be thousands of them out there. You must have data on what's a small, medium business.
It's available on the department's
Does somebody
website.
have the information to all the small, medium businesses out there? Does someone have all those? Someone in the departments must know this. So which department is responsible for that?
So, Senator, as Ms Sheehan noted, so we have put fact sheets on our website. The Fair Work Ombudsman, I know, also have put some advisory notes as well on their website as well about the bill itself. Again, the bill is subject to passage of legislation, passage of Parliament, sorry. So with all of these things, obviously we can provide a level of information that's available on the bill as it is. But again, there's always this process. We have to wait till the bill is passed, and then the agencies such as the Fair Work Ombudsman, the Fair Work Commission, they're available to assist. And I know the Fair Work Commission, particularly, as I said, will be resourced to particularly support small businesses.
7.9 million.
After the bill's gone through. Okay. So I just want to go back to the wording of nature. I want to, so if you have mining, let's go to the company. So if you have two businesses or within the mining sector, whether they're contractors or the mining company itself, are they considered as having the same nature, even if their activities are substantially different?
Just before you, sorry.
Sorry.
Senator Lambie, just, you're able to do a follow-up question to this, I think, but after this, but if you could answer the question for Senator Lambie, but there's a capacity to do a follow-up question if you want to before I turn it to somebody else. Someone else to have a chance to ask questions as well.
Oh.
So go ahead.
I was just hoping to get that question. I didn't
yeah.
want a follow-up question.
Okay.
I just sort of wonder if you could just answer that question, because it is one I had asked previously on that word nature.
Sorry, Senator, in terms of the nature of the enterprises, we have given some guidance in the supplementary explanatory memorandum at paragraph 157 that the nature of the enterprises, factors such as the relevant size and scope of the enterprise would be relevant. So, for example, if you have a couple of very small enterprises and a couple of very large enterprises, that would tend to indicate against there being a common interest between those enterprises.
What if you have two contracting companies out there working for mining, which one's doing mechanical repairs and the other one's in there doing cleaning or doing kitchen work? What's the go there?
Well, that is something that we expect the Fair Work Commission would be able to take into account in considering whether there were common interests between them. There's also the factor that the public interest test needs to be met. So if the Fair Work Commission considered that it wouldn't be in the public interest for the two companies to bargain together for a reason that wasn't related to the commonality of their enterprises, there's also the scope for the Fair Work Commission to take it into account in applying that test.
Last question, Senator Lambie. I'll rotate it.
No, I haven't got any further questions. Thank you, Chair.
Thank you. Senator White.
Yeah, please do.
Can you just clarify, when the previous government proposed their omnibus IR legislation, did they send out emails to every employer before that was there, or every employee to tell them what the effect of it was?
No, but we did have a 4-month inquiry.
Sorry, are you with the department? Can I just ask you?
The questions can be and comments can be through the chair. And I'm very mindful of the time. It's and we've been keeping people delayed.
There's been questions about process, so I'm just interested in process. Did they send out emails to everyone to explain what the process was and the various iterations were? Did you do that?
Sharon Hood, Assistant Secretary, Workplace Relations Strategy Branch. No, we did not.
Thank you. Who, in relation to this, can you just detail through us the consultation that you have undertaken prior to the drafting of this bill?
So, this is in terms of the department's perspective, Senator. We have met with, we've had over 50 consultation meetings since I think the first date of that consultation was in August. 1st of July. We've been consulting since 1st of July. So yeah, over 50 individual consultation meetings. We've also had a number of meetings of the National Workplace Relations Consultative Council, which is the peak organisations. We've also met with a range of academics, with a number of women's sectors, I suppose, and representational groups with a particular focus on gender issues. And basically, I think as we mentioned in Senate estimates the other day, we were basically made ourselves available as a department to anyone who asked to meet with us.
May we have a list? Would you be able to give the committee a list of all those people, associations and whatever else that you have met with?
Yes, we've got a question on notice that we can provide to the committee on that.
And so, and that's the sort of process that probably gets done for most bills, isn't it? Things that you've seen in other departments. You consult people on organisations who are often peak bodies. It would be rare that you would hear from some, an individual business, for instance, wouldn't it?
Senator,
unless it was
I think on this occasion it's probably, and I have worked in the workplace relations space for some time now, I won't say how long, but certainly in terms of this process, this is probably the first time in a while that we've had meetings with individual employers, for example. We would often consult through peak organisations.
Okay, so you have met with individuals.
We have quite
If
a
they've
number.
asked, you've met with them.
Sorry, sir.
If they've asked you, you've met with them.
That's correct.
Thank you. So let's just talk about the Fair Work Commission. That's full, isn't it, of fairly expert IR practitioners, some of whom I think have been appointed by Senator Cash. Isn't that right? Is that right? Are they people who have got experience or ability to deal with complex industrial relations issues?
Yeah, it is a requirement that appointees have experience in a number of fields, and workplace relations being one of those.
And so part of the things that, like a body, that although they're not a judicial body, they have to weigh up various evidentiary matters. Is that your understanding of how it works?
Certainly in all of the Fair Work Commission's work, they are weighing up many issues to do with the workplace relations issues across across a number of different areas, from equal remuneration to bargaining to so well placed to deal with workplace issues.
To definitions of words or concepts?
We're applying tests in terms of things like the common interest test, or applying public interest tests. They exist in other places in the Act, and so the Commission is well placed to be considering those factors.
And so how would you describe the guidance that is given in this Act and this bill to them about things that they need to consider, say for the matters that Senator Lambie was asking you about geography and other matters? Are they unusual things that, for instance, that they would have to consider and interpret?
It's not unusual that there would be an indicative list of matters to take into account, and then the Commission would exercise its discretion in doing so.
Yeah. So it's an every day of the week matter for a specialist tribunal like this?
Yes.
Can you also, we've had a lot of discussion about the ABC's functions and the transfer to the Fair Work Ombudsman. Can you just take us through how that's going to work? And what will the absorption of these functions by the FWO entail? And what additional resources has the FWO been provided with?
Okay, I might just start and then you get the figures.
Yeah, that's fine.
So the current situation is that under the Fair Work Act, both the ABCC and the Fair Work Ombudsman have overlapping jurisdiction for matters dealt with in the Fair Work Act. The Fair Work, so it's not a transfer of functions, if you like. The Ombudsman already has the ability to regulate those provisions in the Act, so they will essentially just pick up that function again. The ABCC won't be enforcing those provisions. The Fair Work Ombudsman will commence, and they have been given additional funding, which my colleague can run through.
Yes, Senator, they have been provided with $69.9 million over the forward estimates from 2022 to 2023 budget. That includes 80 ASL, 80 staff per year.
Thank you. So, and just let's go to that overlapping function. So, for instance, the Fair Work Ombudsman and the ABCC have overlapping functions in relation to the recovery of unpaid wages, or as we have described, wage theft, don't they?
The Fair Work Ombudsman, will regulate that for the entire economy now, whereas the ABCC also had powers in relation to just the specific in the building and construction industry. So yes, the Fair Work Ombudsman.
Yeah, and so in fact, the Fair Work Ombudsman is pretty good at that, aren't they? They've recovered about $532 million from everywhere other than construction in the last financial year, so they know what they're doing. Would that be a fair thing?
Well, that figure is...
Yeah, whereas, for instance, I think the ABCC, who did have coverage of the construction industry, only till December 2021 recovered $4,796,383. Are you aware of how much they recovered?
I don't have the figure right in front of
Well, take it to me. There was evidence before Senate estimates in February 2022 where Mr McBurney suggested that. And interesting, just to complete, the CFMEU in the same sector has recovered more than $17 million for wage theft. So, but what we will, my point is that the Fair Work Ombudsman does a lot of wage theft, and that is part of the ABCC's job, but they haven't really been doing it. But we could expect that the Fair Work Ombudsman will be able to pick that up with gusto, one might think.
They certainly are experienced in those matters.
Thank you. Can I just ask you, can you advise us why, what's been the basis for the number of amendments to the bill that we've seen in the last few days?
The Minister indicated in his second reading speech upon introduction that he was continuing to consult with a number of stakeholders, and I would describe the amendments as really responsive to those continuing stakeholder consultations.
So, rather than press on with a bill that people were telling them needed some amendments, the Minister's been listening to that. Is that, you're obviously on the receiving end of the instructions to amend. Is that how you perceive what's going on?
The Minister has been consulting and amendments have been made as a result of that consultation.
And just on consulting, there is ongoing consulting going on now, isn't there? It hasn't all stopped.
There are still a number of meetings that we're participating in.
Yep, thank you. That's all.
Excuse me, Chair, may I beg your indulgence to correct my evidence earlier? I directed Senator Lambie to paragraph 157 of the supplementary explanatory memorandum. I should have directed Senator Lambie to paragraph 161. I apologise, Senator.
No, it's fine, sir. Thank you.
Thank you.
There was, and thanks, Senator White, there were questions asked that was on those same subjects earlier, but in different ways. So the evidence wasn't actually on the record for this hearing. So there have been questions that have also overlapped throughout the hearing. So Senator Barbara Pocock, it's your turn.
And thank you for being here. If you look at wage inequality in Australia in the last more than decade, it's been widening. The top has run away from the bottom. How optimistic are you that these changes will lead to a narrowing of that inequality, or is it hard to predict which way things are going to go?
We might take that in a couple of parts. I might start with some of the systemic changes to the Act, and then my colleague might talk about the impact of enterprise bargaining. But I mentioned earlier in passing the interim decision in relation to the work valuation case for aged care. Mm-hmm. And I think it gives some indication of where it might go in that interim decision. The President spoke about some of the factors that led to work being undervalued in feminised workplaces, whether they be societal attitudes, whether they be more systemic things, so provisions in legislation or indeed the decisions themselves, and also spoke about the value of expertise in truly understanding those factors in order to correct them. Mm-hmm. And so that is a welcome decision, I think, from the perspective of wage undervaluation policy and those statements. But one thing the bill does, I suppose, is takes it from a welcome standalone decision in terms of implementing systemic changes in relation to those matters. So by the changes to the equal remuneration principle and the wage valuation principle to remove the need for a male comparator and to overcome some of those jurisdictional issues that have prevented cases from succeeding, combined with the two panels, one on gender equity and one on the care and community sector, we heard brief briefly earlier, the qualifications with additional qualifications to ensure that those commissioners have knowledge and experience and expertise in those sectors, combined with the budget measure to fund a research unit of 10 people. I think from a framework perspective, those things should mean that there is more likely to be successful cases that will start to chip away and hopefully eventually overcome that inequity in terms of wage valuation for feminised work.
My question is really about inequality, not just feminised work. What scope do you see in, say, the supported bargaining stream for other types of low-paid workers outside the public sector or outside the mainly... I'm thinking of security guards, cleaners, for example. Is there scope for lifting that class of workers through supported bargaining?
Yeah, it's a good segue. I've got my bargaining colleagues to answer that part of it.
Thanks, Senator. So, as you may well be aware, that the current low-paid bargaining stream hasn't been as successful, I think, as I think could have hoped.
Kindly.
And so the government is, in its amendments, are removing some of the barriers to that low-paid bargaining stream now the supported stream. So there has only been to date one authorisation granted that didn't lead to actually agreements being bargained. And in that particular one case, for example, the Commission declined to make the authorisation in part because the majority of those employees in scope of that authorisation sort of fell outside of this concept of low paid because it hasn't been defined, I suppose, in the Act. So in terms of some of the barriers that this bill seeks to reduce is actually by having the Commission consider the prevailing paying conditions within the relevant industry or sector, including whether low rates of pay prevail in the industry or sector. And we think that change in particular should us hopefully allow for more cases to be brought through that stream.
If I may add to that, Senator, the concept of low paid is defined elsewhere in the Act, but it's not defined in Part 2.4 for enterprise bargaining. And one of the
Sorry, I didn't hear that.
Sorry. Low paid, while it's defined for a couple of other purposes in the Fair Work Act, is not defined for Part 2.4, which is the enterprise bargaining part of the Fair Work Act. One of those consequences was that a very narrow definition of the term low paid was taken in one of those previous cases. I believe it was practice nurses that were excluded as not being low paid, which may not really reflect community expectations of what that low paid bargaining stream was really put in place for. That if you look at some of the commentary and some of the media around those who are low paid, there's often a focus on essential workers and those essential workers who were critical to us during the pandemic. And I think a lot of that focuses around workers in the nursing sector, for example, who are nurses who may be in aged care, disability services, in childcare, but that didn't necessarily line up with one of those previous authorisation decisions. I can take the details of that decision on notice if you would like further detail of that.
Thanks for that. And if I can come back to you, Mr Manning, you referred to the aged care decision and aged care workers are yet to receive it, but pivotally, really significantly, the government agreed to pay and that will realise that decision. Any further decisions around supported bargaining where the government is the main funder will require a commitment from the government to enact the decision. That's the case, isn't it?
Yeah, and the government will make its decisions on each case at the time according to the facts and what's going on in those particular sectors at the time.
So it's a critical partner action by government if they want to lift the pay of the carer sector. I'm asking because I had a room full of childcare workers in my office yesterday from across Australia pointing out that it doesn't really matter what happens in this bill, in a sense, for them, unless the government is at the table with the chequebook. Would you agree with that?
Yeah, I mean, certainly in the sectors which are largely government funded, then there'll be a decision that government needs to make in relation to cases to increase the pay in those sectors.
Very important.
Senator, can I just ask something about that, Can they do that already? Can they? If the government can't the government already do that? If the government wants them to give extra pay to those people that are on that are government, like your childcare and stuff like that, they can already do that. If they want to give them extra pay, what's stopping them?
Perhaps I could assist with a bit of detail from the existing low-paid bargaining stream. One of the advantages of that stream is that the Fair Work Commission has the power to provide assistance to the parties, including by directing a third-party funder to attend conferences. They can't direct that third party to do particular things at those conferences, but they can bring someone to the table if the Fair Work Commission is satisfied that the person exercises such a degree of control over the terms and conditions of the employees who will be covered by the agreement that participation of the person in bargaining is necessary for the agreement to be made. So that might go in some way towards the concern you're raising, Senator Barbara Pocock.
Senator Lambie raises a really important point, and the childcare workers that I met with, we had quite an interesting discussion about this, because I said, why not offer, for example, what some employers are suggesting in the childcare sector, which is a wage supplement of 10% immediately. And their response, Senator Lambie, was interesting. They said no. They said what they want they want any pay increase to be reflected in their industrial instrument, because it's so easily removed if it's a one-off gratis payment by the government. I thought that was curious. The other thing they pointed to was the importance not only of lifting existing rates, but unpacking and more accurately reflecting the skills, education, qualifications and experience of people in the sector in a review of classifications. Would that normally or routinely be part of a review of that kind of pay sector, the care sector? Would you think that would be under examination as well?
Certainly one of the factors that was relevant in the interim decision for aged care was the increasing complexity of the industry and the increasing expectations and how that flowed through. And it's an interim decision looking at direct care workers, so there's other workers in the sector who are still awaiting a decision on much the same argument, if you like, that even in not direct care roles, there is increasing complexity that justifies an increase in work valuation. So I would imagine future cases would look at that as well.
I might add, Senator Stephen Still, Assistant Secretary, Employment Standards Branch. The Act allows modern award wages to be varied by reason of work value reasons, which is defined in section 157 to capital A, to include matters including qualifications and skills. And a key factor in the aged care decision was that the Fair Work Commission took a broader view of what skills were relevant and recognised that there's a range of skills that have not previously been recognised, some of which are particularly evident in feminised workforces, particularly around kind of caring, skills involving empathy, helping people who are in very difficult situations, that was quite pertinent in that matter, and may also be relevant to other caring sectors.
It certainly is.
Senator Pocock, if you
Thank you.
close, you're fine.
Thank you.
Senator David Pocock.
One Pocock to the next. Thank you, Chair. And thanks again for your time. I understand it's been a massive week with estimates. Almost 4:30. Just looking at, I think it's amendment number 30, which is to do with 180A, section 180A. And I'm just trying to get my head around this part of it. As I understand it, this bill leaves a lot of the adjudicating to the Fair Work Commission, and we've heard just how expert they are, specialist tribunal, as Senator White said. I'm keen to understand the reason behind the need for a bargaining representative to approve it, to put an agreement to a vote. What's the thinking there? Why shouldn't the Fair Work Commission decide if an agreement is up to scratch?
So if I can start saying this, this amendment applies to the multi-employer streams, and really it's getting at ensuring that genuine bargaining has actually occurred and employers aren't, I guess, rushing off to put an agreement to a vote before that bargaining, I guess, has occurred and has been finalised. for the multi-employer streams, some of the employees that are covered by those agreements need to be represented by an employee organisation. So this is, recognising that special role that employee organisations play in the system to get their agreement before it's put to a vote. It also recognises that in the multi-employer streams, an agreement can be reached and then another employer could be joined to that agreement in the future, either by consent or if a
vote.
A vote or an MSD.
Majority.
If the employees wish to be a part of a future agreement. So because there's not, if an agreement's already been reached, there's not bargaining that's occurring to add someone to an agreement in the future. So it's, I guess, a safeguard that employee organisations have agree before that agreement is then put to a new set of employees, where bargaining just wouldn't have occurred if you're talking about an agreement that's already in place. So at the moment, whether an employer's failure to obtain the agreement of bargaining representatives before putting an agreement out to a vote, in some circumstances it might breach the good faith bargaining provisions of the Act, and so I guess this is just putting in place a safeguard to ensure that proper bargaining has occurred.
And why isn't it left up to the Fair Work Commission to decide if proper bargaining has, given that they're deciding all this other stuff?
So the Commission will decide whether, I guess, there's been genuine agreement reached in assessing an agreement that's ultimately put to the Commission.
So why does it need union approval then as well?
I think really just for those reasons that I've outlined, that to ensure that proper bargaining does occur before. So at the moment, the employer has to request an agreement to be put out to vote. This would ensure that proper bargaining has occurred and agreements not being rushed to put to employees, I guess, too quickly.
I feel like it seems to me a double up of the role. If the Fair Work Commission is able to, because they are expert, decide, yep, this looks good to go, why then also have the union having to approve?
In variation, so where an agreement's already in place and another employer and employees are being added into that agreement, then there won't have been bargaining that's occurred. So that is another reason why.
Could the Fair Work Commission not take that into account?
So it is effectively, as Michelle was saying, it is a safeguard to basically signal to those, particularly employees, I suppose, in another workplace that may be joining that employee representatives do consider that the agreement...
I appreciate the safeguard.
If I could just do a supplementary, if it's okay, because it might assist. I won't take that of your time, but it might assist that question. Are you aware of the Hot Wok Enterprise Agreement matter, which was approved by only a small number of employees agreeing to it? These employees were later found to be company managers. The issue, there's a number of enterprise agreements, and you might be able to make a comment if you're able to identify. There's a number of enterprise agreements that subsequently have been found, not by the Fair Work Commission, but by intervention from unions, that they were misapplied, and if you could, I don't want to say too much because I don't want to take too much away from your questioning, but there is a number of enterprise agreements that have been falsely put forward in the Commission. They're the ones that have been picked up, but I might just hope I won't say any more. But that that may help.
Okay. No, thank you. I understand that. I guess I'm just looking at this. It seems strange that there's a safeguard for this, but everything else the Fair Work Commission is just deciding on, and there's not a second party also. Anyway.
I think, Senator,
could be useful to consider it as essentially a bit of a filter mechanism for the agreements that go through to the Fair Work Commission to ensure that not only the agreement is good quality, but there's been good quality bargaining behind that as well, where employers and employees have had their say. So it essentially operates as a filter before those agreements in the multi-enterprise streams go through to the Fair Work Commission.
And with that filter, what happens if you have two different unions involved and one approves and one disapproves?
In that instance, Senator, the proposed new section 180 A requires the agreement of each of the employee organisations, so you'd expect bargaining to be continuing in that circumstance where only one agreed. To go to Senator Lambie's question, the employer has to request the bargaining representatives to give that agreement. So that is essentially the employer consenting. If the employer wasn't happy with the agreement, you would not expect them to be making that request of the employee organisations who are bargaining representatives.
Okay, it seems that seems a I've seen an example of where one union gave a glowing endorsement for I think it was an EBA, and the other one said no, not good enough. So. Okay, and I guess looking at that, and given the Fair Work Commission is going to be doing a lot of this work, has the department modelled how much additional resources the Commission will need? I heard at estimates that the additional funding is sort of ABCC functions and existing gaps.
That's in terms of the Fair Work Ombudsman, but I might get Mr Manning to take you through the funding that the Fair Work Commission is receiving.
In terms of the budget this year, Senator?
Well, just in terms of the extra workload to make all these determinations.
I think we know the budget. We want to know how many people you're putting on. Is that being worked out?
So there are 29 additional staff being provided to the Fair Work Commission, Senator.
Okay. Thank you. And just following on from Senator White's question about the ABCC, how many of the ABCC staff have been transferred to the Fair Work Ombudsman?
I think there was evidence given in estimates the other night from the Fair Work Ombudsman and the ABCC that's really a matter for those agencies. I can see if any of my colleagues recall what their answer was.
I think that it's a bit of an incremental process, Senator. So I think there's sort of been some staff that have moved.
Okay.
I think around 16 when it was the number, but I would prefer to refer back to the evidence that was provided at estimates on Tuesday.
Sure.
Yeah. So I think that the flow have been allocated 80 ASL for their work in regulating the Fair Work Act, and some of those personnel will come from the ABCC.
Okay.
Just to answer Senator Pocock's question, is it possible, I appreciate that we've got half an hour with another group after this, we've still got some minutes to go here. Is it possible to get that answer from the estimates? Because it'd just be handy, I think, when we're in one place at one time, if you're able to come back to Senator Pocock whilst we're still here, if that's possible.
I think the transcript's up from Tuesday. We can see
Okay,
if we can find it
I'll check that out. I
quickly.
was interested to know. And then earlier, Senator Barbara Pocock was talking about the intention of the bill giving the Fair Work Commission discretion in determining a range of things like low paid, what meets the common interest test, and so on. So there's a whole range of things that are yet to be determined. How do you sort of suggest employers can best navigate the uncertainty while we wait for all those things to be determined? And do you have have you sort of looked at the timeline you think it'll take for there to be certainty around all the new definitions and have some, determinations for businesses to go by?
Yeah, Senator, One of the things to remember is, for example, in picking up the common interest test, we've actually picked up some of the elements that are already there in section 247, which under the current single interest stream, if you're not a franchisee, you're required to obtain ministerial declaration. We haven't picked up all of the factors in that ministerial declaration test. I think it's in subsection 4 of 247, but we have picked up some of those factors. So a lot of the factors that we're using, we've actually pulled from other parts of the Fair Work Act. So in that sense, they aren't brand new.
Okay.
The provisions are, and I acknowledge that. And however, because a lot of the concepts are relatively familiar, we think that that minimises some of that uncertainty. Obviously, the decisions have to be made by the Fair Work Commission as the expert tribunal, but very much having regard to the principles that are set out in the Act. So we have attempted to navigate that path between changing the legislation, but in not throwing the baby out with the bathwater, so to speak.
Okay. I guess my concern is that every time I ask someone what's low paid, it's just, well, it's up to the Fair Work Commission. So there's definitely that uncertainty, you know, geographical location, like to be determined. Do you have a expectation of how long that'll take to be ironed out so that there are those precedents that have been set?
Senator, I suppose I might start and maybe she might continue with part of the answer. But in terms of, I suppose, one thing to take into account is that there's obviously a range of workplaces currently covered by an existing enterprise agreement. So there is a bit of a combination, I suppose, of, you know, with some workplaces, they won't be considering bargaining for, you know, a number of years until that current agreement perhaps is expired, in relation to workplaces that may either have an expired agreement or they may be sort of the earlier tranche of people that might be looking at utilising the new provisions. So there is that sort of concept of not, you know, it sort of washes through, I suppose, workplaces, so to speak. And then as per, you know, any amendments to legislation, there is that sort of, I suppose, that situation where matters get taken through the Fair Work Commission and they are considered by a case-by-case, on a case-by-case approach. But as Ms Gooden said, there is a lot of, we are replicating in the bill a lot of existing principles that are already in there in the Act. And again, that should minimise those sort of uncertainties around case law. But there always is that sort of building up of case law that happens with any new changes in legislation. But we think that a lot of these concepts are well known, at least to the Commission.
Okay, thank you. So people on, you mentioned people on existing enterprise agreements, their wages won't increase until they expire and then they renegotiate.
So most agreements contain usually annual increases.
But there'll be no. It's
so,
kind of, you're
for
locked
example, I think the Fair Work Commission put out some data. I think Mr Manning was referring to it earlier, but I think it's around approximately like 3.6% at the moment in current enterprise agreements. So they would usually have annual increases. So if you've just negotiated an agreement a week ago with your workforce, it will probably have say a pay rise next July, then the following July. So that most agreements work on that basis.
But you can't, if you've already done an EBA, you actually can't do anything if it's 3 years or 6, whatever they go for. Is it usually 3 years? Because you've already made that agreement last week, there's no way you can go and ask for anything else more apart from getting the normal CPI adjustment or the slight wage rise that everybody gets every year. Is that what you're telling us?
So most enterprises agreements do have an annual rise baked in, at least while it's in term, and so you would be bound by that enterprise agreement while it was in force.
So workers across the country who have existing enterprise agreements, this bill, there's no pay rise for them until that agreement ends, and then they can access.
Apart from what they've already agreed on. That's what I think we're trying to say here. Apart from what the agreement they've already agreed on, if it's 3 years, they cannot change that. They've got to suck it up. They're not getting an extra pay rises.
As Mr Manning was saying earlier in his evidence, though, enterprise bargaining, for those that are on enterprise agreements, they are receiving higher wage outcomes than people that are, say, for example, on the award. So they do actually, their wage increases, I think it was on average at 70 across the board are 71% higher than people on the award rate. Obviously that varies between different industries, but again, part of the government's eagerness, I suppose, to get people onto enterprise agreements is for the fact that they do get higher wage rates than those on an award rate.
Also make a distinction, Senators, between being in what we would refer to as an interim enterprise agreement, so one that hasn't reached its nominal expiry date and one that has passed its nominal expiry date. Once the enterprise agreement has passed its nominal expiry date, there's nothing generally stopping an employer and its employees from negotiating a new enterprise agreement, and often the negotiations commence before the nominal expiry date because people are trying to get things lined up to commence. And there are, I don't have the figures to hand, but there are a significant number of employees who are on an enterprise agreement, but it has passed its nominal expiry date.
I can give that. So the proportion of employees covered by an enterprise agreement is 35.1%. These are 2021 figures. But as at June this year, 15.3% of all employees are on a current enterprise agreement. So the gap is pretty big.
I should say, Senators, that parties can always seek to vary by agreement and an enterprise agreement. So that is open to them as well, rather than waiting until that agreement expires.
Thank you. And then the last major Fair Work bill. I'm just interested how long the committee hearings and submissions went for. Do you recall?
I don't have that information to hand, but I imagine it would be a matter of public record in terms of when the bill was introduced and when a committee hearings and report were.
Okay.
Sorry, Senator Pocock, to go back to your question earlier, I'm informed by my team that the transcript is not yet available for estimates. However, their best recollection is that 16 staff are transferring and there may be more.
Thank you. And 16 out of how many?
16 already, and there may be more.
And 16 out of how many were at the
Sorry, my colleague's
at
just
the
looking for
ABCC?
that number.
How
Senator.
many have lost their jobs?
Senator David Kane's Assistant Secretary, Bargaining and Industry Policy. The maximum staffing of the ABCC was 156 staff. The staffing levels have reduced significantly as a result of the reforms being introduced and things like the interim building code being issued. I can't say exactly how many are left, but we do expect further staff will transfer over to the Fair Work Ombudsman when due to it take on the role of regulating commercial building and construction.
Okay. You don't have, you're not, there's no planned figure yet?
So,
see how it goes.
as I think Ms Anderson said, that there's 80 staff been allocated to the Fair Work Ombudsman to do this work. They're recruiting at the moment. We expect further staff from the ABCC will be picked up through those processes.
Okay. Thank you very much.
It's important to note too that the Fair Work Ombudsman effectively did like an expression of interest process to the ABC staff in terms of those staff at the ABCC that work on the Fair Work Act functions as to whether they wish to move to the Fair Work Ombudsman. And I think the evidence provided the other night was that some staff have put in expression interest to move, and then others have decided to either take roles elsewhere. I think the department, we have picked up a couple of staff from the ABCC as well, and then others have taken voluntary redundancy route.
Senator Lambie has a follow-up
I
question.
just have one follow-up question because we're on the ABCC. It has a tremendous amount of powers. What is the difference between their powers and what's being passed over to the Ombudsman and the Fair Work? How much is a difference between the powers?
So it might assist, we took a question on notice at estimates to actually put it in a simple table.
Okay, that's great.
Form, so I think that
just
last
provide
question.
that.
Yep.
So that.
Sorry, Senator Pocock, did you have another?
Can I just have one last?
Absolutely.
Sorry, just one last question that I was keen to get your opinion on. With limitations on fixed-term contracts, what?
Is that another official up at the table?
Thank you. Just interested in are there exclusions or sort of certain sectors that are carved out, or is that across the board?
So, Senator, the bill provides a number of general exceptions to the prohibition on various types of uses of fixed-term contract. They apply to all sectors. Some may be more pertinent to some sectors than others. Sectoral issues are picked up through the exceptions, though, because there's an exception for fixed-term arrangements that are authorised through a modern award. And certain modern awards do contain conditions that allow certain types of fixed-term arrangements in their sector. So there are some provisions, for example, in the Live Performance Award that relate to live performers. There are some provisions in the Tertiary Education Award in relation to academics as well. There's some in the building and construction industry and for meat workers. So there's a range of provisions in existing awards that we picked up. That's one sectoral route. The bill also provides for regulations to be made that would allow certain additional types of works to be prescribed if that became necessary. And so it's open on the bill for the government to decide to make further exceptions if they become necessary.
Thank you. Well, are those regulations disallowable?
All regulations are disallowable, I believe.
Yeah, just to clarify, so it's new section 333 uppercase F, there's 8 categories of exceptions, and then as Mr Still said, and the ability to, by regulation, add other categories.
And so if you're in that category, do you still have to apply, or is it just a...
Apply for the
It's an exception to the prohibition.
That's
If you're in that category, the prohibition doesn't apply.
So for tertiary education, they can use fixed-term contracts?
It would depend on what's permissible under the award. But I'll give you another example. One of the exceptions is for an employee who earns over the high income threshold for the first year of the contract. That would apply to some tertiary staff. So that fixed term, the limitation wouldn't apply to that person.
Okay.
That's for every industry. They earn over it. And as Mr Still said, there are some categories of work in the higher education sector under the award already that permit certain types of fixed-term contracts, which
so like research,
Senator, I think
research tied to grants and those sorts of things.
There's one of the 8 exceptions is if the employer is relying on government funding to directly finance the employee's position. Where there's no reasonable prospect of renewal. So say, for example, there was a research grant for
like 3 years.
3 years of research, and then it wasn't
possums.
a reasonable expectation of being extended, then the limitation, the prohibition wouldn't apply to that, and they could have a contract for 3 years.
Okay.
But there might be other staff, for example, in the research area, admin staff or research assistants whose funding isn't directly tied, and they couldn't be, the prohibition would apply to their employment.
Thank you very much.
Thank you, Senator. I know Senator Fadimond has a couple of questions.
Thank you, Chair.
Sorry, Senator Payman.
That's okay.
There you go.
It's been a long day. I'm just going to have 2 questions just to clarify some things we've already discussed. Can the department please advise the committee if this bill creates additional rights and avenues for industrial action?
So, industrial action is provided for in the supported bargaining stream. So that's currently the low paid bargaining stream. There are also some broader reforms to industrial action, though, to require that conciliation occur before you could take protected industrial action. And obviously that's designed to try to reach agreement on the issues that are currently in disagreement before industrial actions are taken.
So would it be correct to say that it'll make it'll be harder as there are new requirements for mandatory conciliation? It would be harder to take industrial action?
Or you would be required to undertake the conciliation. So it's, not making it easier to take industrial action.
Easy. And finally, can you please take us through how the Better Off Overall test is being amended in this bill. And then I promise I'll leave it there.
So, do you want me to kick off? So the bill is providing that the Commission has to undertake a global assessment of whether each employee actually is better off overall. The Better Off Overall test, the BOOT, is intended to be a global test at the moment, but yeah, the bill is kind of clarifying that that's the way that it should operate. In practice, it hasn't always been the case. The Commission also has to give consideration to the views of the parties as to whether the Better Off Overall test has been met, and that's something that we've heard a bit in our consultations that we've had, that the parties negotiate an agreement. I think they've reached an agreement themselves as to whether it passes the BOOT, and then there's been those complexity when they've gone to the Commission. So giving views to, considering the views of all of the bargaining representatives, but giving primary consideration to a common view of the bargaining representative of the employer and bargaining representatives of the employees that are employee organisation. It also requires that the Commission only have regard to patterns or kinds of work or types of employment that are actually reasonably foreseeable. So it removes the requirement to consider prospective employees. And I guess that caused, I think, difficulties for some assessment of the BOOT, where the Commission was looking at, hypothetical employees in the future and what that might mean. So that's removed and replaced by a more direct, reasonably foreseeable nexus, but with the trade-off being that there's a reconsideration process if either an employee's their pattern of work hadn't been considered at the time that the original assessment was undertaken, or a new pattern of work has arisen, but the employer has gone into a different kind of business and that wasn't foreseen at the time of the original test, and allowing that reconsideration to occur.
Okay, thank you.
Good, thank you. Senator Barbara Pocock has a follow-up question.
Thank you, Chair. Just following up on Senator Payne's question around question around industrial action. Does the 3-monthly protected action ballot order still exist after amendments yesterday?
Senator, I'm sorry, Ms. Chair. That amendment has been omitted from the bill, so the provision that a protected action ballot be valid for 3 months and that industrial action be taken within that 3-month time frame has been omitted by the amendment sheet.
So current arrangements are persist?
We revert to the current arrangements.
Okay, thank you.
Good, thank you. So, Senator, Deputy Chair, Senator O'Sullivan.
Thank you, Chair. How long have I?
A few minutes.
A few minutes. Okay. Well, Chair, I've got to say you've been quite fair in the allocation of time. I do acknowledge that you have given the coalition senators proportionally more time than others. I do appreciate that, but I must say we would have had, with my 3 minutes, and I'm taking 30 seconds of it now, 25 minutes with the department on one of the most complex bills that's probably going to go through this parliament this term, and it's quite, so it's most unsatisfactory, I've got to say. But I do acknowledge your time that you've given us. Thank you. Now, just regard to a question that Senator Lambie asked before with regards to the table that you're going to provide in looking at the differences between the powers of the Fair Work Ombudsman and the ABCC. I do acknowledge you took that question on notice in Estimates. Estimates has a reply date on that for mid-December, so I'm going to put the question to you again now so that we get it back by Monday if we can. Sorry about that. Might be some work to do over the weekend, but we do need that to consider this bill. Now, just in the couple of minutes I've got, Part 18 of the bill addresses bargaining disputes, and the bill refers to scope that the Fair Work Commission will have in relation to intractable bargaining, to being able to make an intractable bargaining declaration. Are you able to explain this to me? And in doing so, can you provide me with a definition of intractable, or is that left to the discretion of the Fair Work Commission?
So, the Commission can make a what's called an intractable bargaining declaration, where the parties have essentially tried to resolve the issues through using the Section 240 process. So that might be conciliation. If the Commission's satisfied that there's no reasonable prospect of agreement being reached, and that it's otherwise reasonable in all the circumstances, taking into account the views of the party. The term intractable is not defined in the bill. The test gives reference to is there no reasonable prospect of agreement being reached. The amendments that were agreed in the House now include a minimum period of good faith bargaining before that declaration can be issued. And so that would be a minimum bargaining period of the earlier of either 6 months after the nominal expiry date of the existing agreement, or 3 months after the first application was made for under Section 240, so for a conciliation for example, and that's to reflect the government's continuing consultation on parties wishing to see that that there has been at least that minimum period of bargaining occurring. I'd say what those provisions are designed to achieve is that at the moment arbitration is only available in extremely limited circumstances. So that would be where protected industrial action's been taken, it's been terminated, either because the significant economic damage that's been caused by the protected industrial action. That's one of the tests for which industrial action can be terminated. So you have to have reached that point where there's been industrial action of, I guess, such a nature to warrant termination on those grounds, and then the Commission at that point can step in to arbitrate an outcome. So these provisions are designed to still have a high threshold around that, reasonable prospect of agreement being reached, but not, I guess, as high a threshold as what is currently provided for in the Act.
If I may add to that, the second circumstance in which the Fair Work Commission can make an arbitrate is where a serious breach declaration order has been made, and there have in fact been no such orders made that the department is aware of.
Okay, so we have heard testimony from employers, and obviously with regard to the amendment that you refer to, that they're still absorbing that. It's still new for them because it was only yesterday. But what the concern from employer groups is that it will unlock unilateral arbitration into the enterprise bargaining system for the first time. Employer groups have said that it's a retrograde step and will return us back to an arbitral system-based regime, effectively taking away the decision making from those that know their business best, the employer, the business. Can you talk us through what safeguards there will be to prevent that?
I think that some of the safeguards are in the test itself. So that requirement that, or what now, a minimum bargaining period, but also that the parties have sought to conciliate the issue before they can apply for an intractable bargaining determination. And the Commission will obviously look at those matters, decide whether it thinks actually no, the parties really kind of can and should keep bargaining, maybe some further conciliation would assist the parties to reach resolution. So they would certainly be factors the Commission would consider in deciding whether to issue a determination.
But you still got this situation where it's like it only takes one party, doesn't it? It becomes a unilateral issue where they can take it, only takes one party to take it to the Fair Work Commission.
You could unilaterally apply, but the Commission would take into account those factors of, have they used the 240 process already? They would make an assessment, obviously, based on the views of the parties that are put to the Commission as to whether there were reasonable prospects of
Has there been any
reaching.
consideration given to, so taking on board what you've said about ultimately that it's the discretion of the Fair Work Commission to apply that test, but to give employers some more confidence about maybe providing more definition to what it would be, of a higher standard or a bit more explanation? Or do you think that's not necessary?
I think what we've tried to do in the test is to have the no reasonable prospect of agreement being reached if the Fair Work Commission does not make the declaration, and that's really trying to get at that concept of what is an intractable bargain. So there's no reasonable prospect that agreement has been reached. The Fair Work Commission is satisfied that it's dealt with the dispute under Section 240. The applicant must have participated in those processes, and it's reasonable in all the circumstances. We would say that those 4 factors taken together, plus now with the 5th factor that is the minimum bargaining period, would essentially define what is an intractable bargaining situation.
Okay. I'll put the rest of our questions on notice. Thank you.
Thanks, Deputy Chair. I just want to thank you for coming in and also answering all these questions, which has been a great deal of assistance. And if you've taken, which you have, questions on notice, could you please return the answers to the Secretariat by the close of business on Monday, the 14th of November 2022, and you're now released. Thank you.
Thank you.
Confirming, Chair, a number of senators said they'll put them on notice. When will we receive them? If they weren't heard in oral evidence.
Senator O'Sullivan, just to assist with the questions on notice, are you aware when the questions will be sent over to the department?
Yeah, we'll get them to you. I've got people listening. We'll get them to you today.
Thank you.
Thank you. Thank you, Mr. Manning.
Thanks.
Sensible question.
Yeah, fair enough.
I now invite, where are we? The retail, Mr. Josh Cullinan to, thank you. I now welcome by video conference Mr. Cullinan. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Yes, thank you, Senator. My name is Josh Cullinan, and I'm the Secretary of the Retail and Fast Food Workers Union.
Good, thank you. Would you like to make a short opening statement, and then I'll turn the questions to the senators?
Yes, thank you. Thank you for the opportunity to appear today at the Senate Committee. We hope you have received our submission filed early this afternoon. I'm calling in from the stolen lands of the Dja Dja Wurrung.
Mr. Cullinan, we have received those your submissions, and they are with senators.
Thank you. I'm calling in from the stolen lands of the Dja Dja Wurrung, whose elders I acknowledge, as do I acknowledge this always was and always will be Aboriginal land. We note our submission focuses heavily on the issues of the Better Off Overall test. We've reviewed many of the submissions of the academics that are publicly available at this stage and note very little, if any, reference is made to the Better Off Overall test. And we submit this is because the boot changes are not founded in any identified need, and that no one would tie their reputation to such a purported need. I've heard some say workers on EBAs earn more. Well, not in our sectors. In retail and fast food, for a long time, members of the historical union earned 10% less under ABS figures than workers who were not members of that organisation. And that's because they didn't have enterprise agreements applied to them, which cut their conditions. So sometimes we hear the alt fact that getting any workplaces into bargaining will necessarily lead to increases in wages, but that is not the case in our sector. And the mechanism itself, weakening the boot, belies, or weakening the test by smashing the boot, belies the truth of what will happen to workers if this legislation is passed. We have not had the time to prepare as comprehensive a submission as we would have hoped. We did convene a well-intended meeting of members this week about the changes. Unfortunately, the little time we have had means not all their stories can be told, nor could we manage their participation this afternoon. Their stories are important, not just because we are a democratic member-led union, but because their stories give real life to the real and justified concern the attacks on boot in the bill, described in our submission, will result in disastrous cuts to wages and conditions. Our submission focuses on boot because that is the primary change still pressed in the bill, which attacks workers' rights. Despite the claims of some that RAFWU is concerned about the platforming of a particular voice in bargaining, that is not true. It is a side issue for us. The bill introduces a new test, not the boot, despite keeping the name. Those changes must be stopped, else the lowest paid Australian workers will suffer cuts to wages and conditions. That's our opening statement. Thank you, Senator.
Thank you, Mr. Cullinan. Senator Pocock, if I can go to you first. Yep.
Thank you, Chair, and thank you, Mr. Cullinan, for your patience in waiting through the earlier session. We're running behind time, but and thanks for the committee's indulgence. I'm very pleased to see you here today. I haven't had the chance to read your submission, but I have seen a media release from the 1st of November, which I think did go to the issues that you've highlighted. You did also mention the 3-month Protect Action ballot re-ballot, which I think you must have just heard in the previous hearing is now hasn't been introduced as part of the bill. So that would satisfy one of your concerns, I imagine. But I wonder if you could just give us some examples that are the basis of your concern. Is it mostly around the prospective employees test, or where is your real the nitty-gritty of your concern around the boot?
Sure. So just mentioning firstly, in terms of industrial action, the bargain is that workers give up industrial action. The rescission of those changes, whilst positive, it does keep now the 30-day and 60-day requirement, which is unfortunate. We posit in our submission that all protected action ballot arrangements should be abolished, that they're an unusual spectre that is the true reason for the break on increases in wages. In terms of the boot, the proposed changes have at their core changes which limit the capacity of the Fair Work Commission to assess whether workers can be paid less and have inferior conditions under the proposed agreement compared to the award. There is not a single skerrick of evidence of this being an issue anywhere. I know a lot of people have talked about it for 6 years as if it's an issue, but there isn't a single case where this is an issue, and we deal with that in our submissions. We go to case after case to expose the truth about what happened. What we know will be required if this legislation passes is a special case to be run by a worker to have their situation reconsidered. So, for example, McDonald's could make an agreement, and some would be pleased that 100,000 workers are going to have an agreement that's going to cover them. But that agreement could, at its core, fail to provide future employees with the same conditions as current employees. Future employees could lose penalty rates, casual loadings. They could lose all their conditions. That would have to be approved by the Fair Work Commission. And what would then be imposed upon those new 15-year-olds starting in their first job as a casual worker would be to apply to the Fair Work Commission and seek to have their situation reconsidered. That is just preposterous. The second group would be an employer that says that that certain changes are not reasonably foreseeable. So, for example, At the time, last time Big W made its agreement, it had workers working certain patterns of employment. And it could simply say, we're not going to have different patterns of employment. We don't reasonably foresee them. An employer could say, we don't reasonably foresee that we're going to have casual employees. KFC didn't used to have casual employees. So they could say, so we're not going to have a casual loading. Now, ordinarily, we would say, include the casual loading. What skin is it off your nose? But they could get away with an agreement being approved because it's not reasonably foreseeable they'll have a casual employee. And then the very next month, suddenly decide everyone's going to be casual. In that circumstance, those new casual employees are going to have to run a case, a complex legal case, in the Fair Work Commission to have their situation assessed. The same as someone who works at an employer that didn't used to work on Sundays. So there's no Sunday penalty rates or no weekend penalty rates. If that then changes, the employee has to run the reconsideration case. This is not broken. This is fixing a problem that does not exist. Not a single witness has come up, has ever said that the technical specific issue that needs to be fixed with this. And so it places the impost on our lowest paid workers because we're talking about workers at the very edge or below the minimum award. And that impost on those workers is outrageous. We've got lots of examples that are littered through our submission of similar types of cases and the difficulties that that presents. One of the best examples is in this legislation itself. This legislation proposes a structure to get rid of zombie agreements. Of course, a worker right now could apply to terminate those zombie agreements, but they haven't because they won't. And it will be the same under this reconsideration scheme. Workers will not be applying, they will just be suffering.
So is the heart of your agreement around your concern about the boot test changes basically about an imbalance of power in contesting them and using, for example, the reconsideration mechanism?
Oh, there's absolutely an imbalance in power, but it's that they won't be tested. Mm-hmm. So this proposed structure will just see those tests never occur. It's not just an imbalance, there will be 1 in 100,000 or 1 in 500,000. For example, there was only one worker who applied to terminate the Coles agreement. There was only one worker who applied to terminate the Woolworths agreement. 70 or 80% of workers were worse off.
And so what, in view of your experience and concern, what's the remedy you're proposing?
But we say that the boot changes have to be rescinded altogether. That is the only solution. This system works. This system has uplifted the pay of 500,000 retail workers by $1 billion a year. Right now, Macca's workers get penalty rates because of the boot system. Right now, Woolworths and Coles workers get weeknight and Saturday penalty rates because of the boot system. It has worked. It is the thing that increased wages. These changes will actually attack those wages.
Just in last question, can you just define your sector? When you say retail sector, can you just put a fence around it for me so I have a sense of where your concerns are especially located?
Well, when we talk about retail, we're talking about all retail outlets, retail stores, online and in person. Mm-hmm. Everything from supermarkets to service stations to pharmacies to big box, Bunnings, right through the Kmarts, right out the other end, Apple, all of those types of retail establishments. Bakeries as well, newsagents. And then in fast food, for RAFWU at least, it's every fast food outlet that's not a cafe and doesn't serve alcohol. Mm-hmm. So it's McDonald's, KFC, Hungry Jack's, pizza shops, Domino's Pizza. It's all of those types of entities.
And do you have a number that or a sense of how many workers are caught by that kind of sector definition?
Yes, so in fast food, it's 220,000 workers. Over 100,000 of those are at McDonald's. In retail, we understand it is between 1.3 and 1.5 million workers.
Thank you. Thanks for your evidence and thanks for being here.
Good, thanks very much. Senator Lambie?
Thank you. Thank you, Mr. Cullen. I noticed that you said you guys are struggling to get around the thing, so it was very interesting to hear about what you just said about the boot. So it may have unintended consequences on, what was it? Only 2 million people, 2.5, what was it, between all that? That's a lot of people
Well, we
who
would
have
say
unintended
unintended
consequences in, so they could lose wages. I hadn't heard it like that before. That was fascinating. Thank you for that. Is there anything else that you want to say about the bill itself that I know you haven't had a lot of time? Is there anything else that stood out to you while you've been flicking through it at this point in time that bothers you?
I think that, I think that to maybe explain at its core, so I've been working in unions for 20 years across a whole lot of sectors in every state, in every territory. And at its core, bargaining is about workers extracting from employers something they don't want to give. And they extract that through industrial action or the threat of it. So when we talk about getting better pay or better conditions or more secure jobs, unless there are prohibitions put in place on casual employment, on fixed term employment, what we're really talking about is making it easier for workers to access action and then for employers and workers to make agreements. Anything which makes it easier to do less than the minimum, which is what Boot's about in this circumstance, is about helping someone cut a deal which is less than the minimum. And in our sectors, that's been our experience. And there's been no time, but we will continue to share stories, including with senators, of actual workers who are able to say, under the old deal that should never have gotten through, but will under this new structure, I lost 20% of my wages. I lost 30% of my wages. I mean, there's a Domino's Pizza class action underway right now on these issues. So it's a massive issue. We know that we don't have the loudest voice in the public sphere, but it is a massive issue. And there's been a book written about it by Ben Schneiders, and we're more than happy to get people telling their stories. We just need more time, which we weren't involved in any consultation. We weren't asked. We didn't know we could ask you. I found that out today. We just need more time to be able to get these stories out, and that's really important.
Okay, thank you for that. That's a bit of a shock hearing there's quite a few million people enrolled in that actually may lose wages instead of gain. That's phenomenal. Thank you. I don't. Have you got anything else you would like to add? Because obviously we've just got your submission. I haven't had time to go through that. We're under the pump as well. Is there anything else that you would like to add? Because I have no questions for you that you believe it is important for us to hear.
I think just to reiterate that we are talking about the change will put the onus on our kids. It'll put the onus on 15 and 16-year-olds, casuals in their first job, to apply when it's just not broken. But there is not a single employer that can't bargain right now. They're playing at the edge. This will make it the kids' responsibility to go and take that case. And I just say that the main players know that's never going to happen. So, it's really quite disturbing for us. But no, I don't have anything else other than the questions.
They'd have to sign legal documents, Chair, so they'd have to be 18. How's that work?
Well, no, they'll have to apply to the Fair Work Commission. They might try and have a representative. But they'll have to apply to the Fair Work Commission as a 15, 16, 17-year-old. They can do that. They can ask a parent to help them with it, I guess. They just haven't done it. And we've spent much of our last 6 years helping workers do it.
Thank you.
Senator David Pocock.
Thank you, Chair. Thank you for your time, Mr. Cullen, and thank you for your submission. Again, as everyone else has said, I obviously haven't had time to look at it, but we'll do so. One of the things that's been put to me in consulting stakeholders over the past week is that there seems to be broad support for updating and simplifying the General Retail Industry Award. Would you agree with that?
No, it's been updated. It was finished a couple of years ago. There was a comprehensive set of cases run.
Okay.
So the award itself is minimum conditions.
Okay, so you're happy with it as is?
Oh no, it should be far better, but it is what it is.
And would that not be a better way to increase wages for people in your sector?
The first stage of RAFWU's life, the last 5 years, was about helping workers get rid of the old deals that should never have been approved, that this new law would allow workers to do. So the next stage is us using the laws that we currently have to try and negotiate better deals, like we are at Apple at the moment, and we have at a couple of bookshops. Award changes is one way. Improving the award, so for example, abolishing junior rates or increasing to a living wage, the award rate would have a massive impact for retail and fast food workers because so many of them are reliant either on the award or an agreement that pays so close to it. 1 cent per hour, for example, at Kmart, 1 cent per hour more than the award. So that is one way, but the current systems don't facilitate that for us.
Thank you. And just on junior pay rates, what this is something I've been struggling to get my head around. What is the argument that juniors should be paid as little as they are?
It was a historical argument run in the 80s and early 90s that somehow it led to, it helped with youth unemployment. It was a sunsetted provision that was supposed to end in about 2000, but Labor and Liberal teamed up to entrench them. We do not understand. It's not like Macca's has more employees or have more people working at a particular time because they've got kids. And as we lay out in our submission, this costs workers $3.5 billion a year. It doesn't matter if you're a single mum raising your kids, you still get a junior rate. We use the comparator of a well-off child of a millionaire. They all get the junior rate. They lose $50,000 by the time they turn 21. This government, there could be a bill which overnight returns $3.5 billion, half of which is in 6 main employers. McDonald's makes $700 million a year on junior rates.
Okay. Well, thank you. Again, I'm sorry I don't have more questions. I will go through your submission in time. I appreciate your time. So thank you, Chair.
Thank you very much. Senator Payman.
Thank you, Chair. I've just got a few questions. Can I please confirm your organisation is not affiliated with the ACTU? Am I correct?
Yeah, the ACTU hasn't invited us to affiliate yet. If they do, we'll consider their invitation.
Okay.
We are not affiliated.
No, okay. And you aren't a registered organisation?
No, RAFWU has not been registered as an organisation of employees. We're a registered incorporated association and a registered Australian registral body. And so we're governed by significant legislation. We're governed by the Corporations Act, by ASIC, by Consumer Affairs Victoria, and by Incorporated Associations Law.
Okay. And so RAFWU isn't required to comply with the governance obligations of registered organisations, including around transparency and governance of elections, financial reports, membership roles, and so on?
No, that's incorrect. We're governed by different laws which are more substantive and more onerous than the laws that apply to registered organisations of employees. And so, for example, our officials have to make decisions in consideration of a reasonable person test, whereas registered organisations, they only have to make decisions where it's reasonable by the person making the decision. But there's a whole range. We are subject to audits under our rules and under the law. We're subject to elections under our rules and under the law. So they are different laws, yes, but those oft-repeated mantra are just incorrect. We have laws that apply to us which require all those things.
Okay, thank you for clarifying that. And are you able to tell us how many active paid-up RAFWU members there are currently?
Yes, we don't hide that. That's reported every year. We have 3,000 members. We don't have some rules like, say, for example, the SDA, which keeps members on the hook for 3 years after they stop working. Our rules require us to finish up members once they're no longer members.
All right, and we've had employer groups fear-mongering about widespread industrial action. But your position is that this bill makes industrial action more difficult?
Well, industrial action is already ridiculously difficult. It is already almost impossible to take. So, for example, when our members went on strike in Apple last month, that was the first national strike of workers in
Sorry,
Australian
Mr.
history.
Cullinan, could you just start that answer again, because I just couldn't quite hear it.
I said industrial action in Australia is already immensely difficult and immensely rare. Whilst there are a few keynote public sector, largely unionised sectors that are currently engaging in action, the industrial action Apple workers took last month was the first national strike of retail workers in Australian history. So it is already ridiculously difficult. Having worked across very many different sectors, these laws will make it a little bit more difficult. Having to turn up, it's a bureaucratic nonsense to turn up to the Fair Work Commission when we can already, the bosses can already compel unions, and we can compel the boss to turn up to a conciliation. That for us is just an impost on workers that's going to cost them. It's going to cost them time and energy and resources. And it suggests that people that engage in action are not professional and responsible. But it is an impost. It does make it a little bit more difficult.
Great. Well, thank you so much. Chair, that's all from me.
Well, thank you for your evidence today. If you have taken any questions on notice, could you please return the answers to the Secretariat by close of business Monday, the 14th of November 2022. And that concludes today's hearing. Thank you to all witnesses who appeared and to Hansard and Broadcasting for their assistance. The committee has agreed that responses to questions on notice should be provided by the 14th of November 2022. The committee now stands adjourned.
Thank you, Chair.
Thank you.